We are meeting right now to continue our discussion on the proposed constitutional amendments. I apologize for the late start. We had to discuss a couple closed session items. At 10:30, I'm going to have to step away for a quick call with our state representative regarding some appropriations. But Ryan, let's get started where we left off, please.
All right, we had left off, we had just finished going through the election and selection of justices and judges. And now we are on terms. Section 3 terms, this has gone through various iterations of different drafts. There's the original 2008 had some judges doing 4 years and some justices doing 6-year terms.
Hey, Ryan, if you don't mind pausing, I see Bridget's hand up. Bridget, do you have a question or comment?
Yeah, since this was noticed as a special meeting, don't we have to do a roll call?
Is this a workshop?
Yeah, this is just a workshop.
So we noticed it for 5 o'clock. It's 10 o'clock. So, and I don't believe it was noticed, was it, Ashley?
The special meeting for tomorrow.
Oh, for tomorrow?
Yeah.
Yep.
Yeah, so tomorrow we have a special meeting.
This is
Today
for
is
tomorrow,
just a
Bridget.
workshop.
Okay, sorry about that, thank you.
Yep. We can keep going, Ryan.
All right, so in this current language, we have all justices and judges serving staggered 6-year terms. We have in I don't know why it says E, this should be B. Standard language for judges and justices remain seated unless removed until the oath of office of their administered to their successor. So we don't have, once the new judge, if there's an election, he gets seated, then the previous judge steps down. But this way it keeps that seat always filled by a judge or justice. So I can pause for a second there if there's questions on the terms.
Does anyone have any questions? Aaron?
So maybe you're going to get to it, but there's a provision that if there's no candidates, that it defaults to an appointment. That
There is, yeah,
Just serves a temporary term, right? Or a full term?
Yeah, it'll be further down. We'll get to it.
Okay, Tyler, then Lana. You can go ahead, Tyler.
Reason for 6 as opposed to 4 like the rest of the government?
I'm not dead set on the 6 terms. Part of the reason, so the original 2008 draft had the Supreme Court for 6 and the other court for 4. And my understanding is back then part of the intent was to have longer terms for the Supreme Court to provide maybe more consistency. And we thought if that is one of the goals, it would make sense to have all the judges have a slightly longer term just to keep that consistency on the bench. But I'm not married in any way to that 6-year term. It's pretty standard for a lot of other constitutions to have the judges have a 6-year term and just have a slightly longer term than the tribal council, but it doesn't have to be that way. But that's the reason, Tyler, just to have a little bit more consistency because you have that longer term set. So you potentially have less. You have less elections for judges, less frequency than the tribal council, and it just provides a little bit more stability on the bench.
I mean, you could say the same thing about the OGMA, though, too. So I just prefer it to be consistent 4. That's just my personal opinion. The other thing, we touched on this a little bit, but I think all justices have to be Sioux tribe. The United States would not let somebody sit on the Supreme Court from another country. And if we're going to be a sovereign nation, we have to treat ourselves like sovereigns.
And we'll get down to that point, Tyler, in the qualification section once we figure out if we're happy with this section. So.
Okay, Lana.
So just a refresher from the last time we had the discussion, it was 5 judges in there. Did we change it down to 3? Was that the consensus?
So,
If we can do a recap of what we have changed this far, just to bring us up to speed. I think we had made changes to the name and then And that's what I fully want to have everybody know what that is moving forward. So it went from 5 to 3? Is that where
So,
we're at?
right, yeah, so last workshop, it's up on the screen in B here, composition of the Supreme Court, it was 5. The consensus of last workshop was 3 justices, 1 chief justice, and 2 associate justices. So the current number that we're at is 3.
Okay, thank you.
Do we want, I'm sorry, do you want me to go through all the red lines we previously did? Is that the?
No, I
Oh.
guess I can look back on that once we get this, but just, I want to make it known that it's throughout there so that we know, we get a red line copy.
Yes.
Okay, thank you.
Understood.
Aaron?
To address the concern of, I agree with Tyler that our ideal should be that they be tribal citizens, qualified tribal citizens. That means a law degree. But the issue, if we look, we have difficulty filling attorney spots and judicial positions, but I think that's because we have somewhat of an arbitrary and capricious employment situation, but if they're elected, they're not subject to, termination by the board of directors. They don't work at the pleasure of the board of directors. So I think that will be different. I think there are lots of tribal members out there. I think probably about 15 years ago, we counted there were well over about 300 or 400 tribal members that are attorneys in our tribe. So I do support that they be tribal, but I think we have to have a provision that if they don't surface, that we can't go without a judge. So there should be an ability to do an interim appointment, and that isn't anything different than what we did with our current lower court judge.
So I'm going to step up for my call. Tyler, you're the vice chair. Would you like to chair it from Zoom, or do you want Isaac to do it, who's here in person? Shouldn't take you very long.
Yeah, I think Isaac can do it unless everybody wants to jump onto Zoom so I can see hand raises.
Okay. You want to take care of it, Isaac, for me? All right, I appreciate it. I'll be back.
Okay, so can we do some kind of poll or consensus on 6? It sounds like there's a few that don't want 6, but I don't want to move on this section until we know what the year of the terms.
6 years or 6?
I'm sorry, 6-year terms or 4-year terms are the 2 numbers that have been discussed tonight.
Okay, 1 will be 4-year, 2 will be 6.
Can I make an argument before we do that? Sure. So, again, the reason why you wouldn't have them be the same is for continuity. That's why we have half our elections one year and the other half the next year. Other tribes don't do that, and it does create great instability. It also creates insecurity in investors. They don't want to invest in that kind of structure. And so I think, on one hand, if we're arguing that it's going to be difficult to get tribal members to serve, but then we limit their term to 4 years, the same as the tribal council or the legislature, then we're creating the environment where they're going to see that as less secure. I think a tribal member attorney that's got, any kind of a reputable background could take 6 years out of their life to commit to serving, but I think there will be less people that would be willing to do it for 4 years. So I think it makes sense for continuity purposes. Plus, you're going to train these people. They're attorneys and all of that, but they have to become experts in our law. And so once we get them, we want to keep them for as long as we can, notwithstanding the provisions to remove for cause. But so I think it makes more sense to have them serve a term that straddles and transcends the board terms.
Yeah, actually, if I can chime in quick, I agree with, that's another good reason to have a longer term for your judge, because it does take several years sometimes to get up to speed, whatever jurisdiction you're a judge in. You don't come into the bench knowing all the law that you're going to have to rule on, right? It is a learning process. And if it's 4 years, there could be the situation where you start to master it right when you have to start campaigning, and that can divide the judge's attention. There are a lot of benefits to having a slightly longer term for judges as opposed to legislators.
Tyler?
I just kind of want to reiterate, though, the same can be said for the Ogama. Like, if a new person comes in, never held an elected office, they're going to take some time to hit the ground running, or never worked in policy work even, or never ran an executive position. So, I mean, I don't know. I favor 4.
Okay, poll. 1 is 4, 2 is 6.
I just have to say 6 or.
Yeah.
Either or.
Whatever, yeah, 6 or 4. Sean? 6. Lana?
No change.
Is that 4?
No, that'd be 6. No change would be 6?
6 or 4?
No change is 6?
Yeah.
Okay. Isaac?
6.
Kimberly Hampton?
6.
Aaron?
6.
Michael?
6.
Rob?
Guys hear me?
Oh, yep, I can now. 6 or 4, Rob?
You cut out again.
Hey, actually, I'm going to log out and log back in and see if I have it better.
Okay, 6 or 4? No, I think you logged out. Okay. Kimberly Gravel? 6. Larry?
4.
Bridget?
6.
Tyler?
4.
Kimberly Lee?
6.
The only one I didn't get was Rob.
Yeah.
Got 2 4s and the rest are 6s.
All right.
Brian, so you got your decision.
6 it is. All right. We'll go down now to qualifications. Section 4A, the chief judge, the associate judge of the trial court, and the chief justice of the Supreme Court shall be at least 35 years of age, members of the tribe, and licensed attorneys in good standing with a state bar association, except where no qualified tribal member seeks such office, a non-tribal attorney in good standing may be appointed.
Aaron?
The only problem with the way that is phrased is all else applies, though. They still have to be 35, they still have to be licensed, good standing, and all of that. It doesn't say that, though.
Yeah.
So if we could just modify that.
Right, the intent is all their qualifications would still be in effect, the age,
Yeah.
the license, but we can make that more clear.
Tyler?
Okay, again on this, why an age limit of 35 when you can run for Ogima to be and be 18? The other thing on this one, and I already brought it up, I think we should remove unless they need to be Sioux tribe, especially making judgments on our tribal people. Anybody making judgments on our Constitution. I just do not want this tribe to turn into something where we have non-native people making judgments or conclusions of how we should operate. We're a sovereign nation. We need to have Sioux tribe citizens. Again, I'll use the example. The United States Supreme Court would not allow somebody from another nation to sit on there. So the Sioux tribe Supreme Court, the Sioux tribe court should not have somebody else on there.
Aaron?
So I would agree on the age, that we don't need to designate an age, because if all the other criteria is established, they're at least going to be 26 or 27. And as far as, I don't want to suggest, but I don't want this to be a poison pill, because if we set the criteria that can't be fulfilled, then we don't have a court.
Right.
And I think that's not rational. I don't think that's reasonable for us to do that. This provides for, if we don't have somebody that files to run, that a non-tribal person could run. And also, if we use comparisons, right now we're comparing it to the federal government or whatever, but most tribes do not have tribal member attorneys that are their appellate or their Supreme Court justices. The time will come when we will have that. But some of the smaller tribes, their entire legal teams are non-tribal people. So I agree with the idea of it, but I don't think it's practicable. I don't think we can stipulate all or nothing, that if you're not tribal, we won't have a court. Because that's basically, if we say you have to be tribal or nothing, then if we don't get a tribal candidate, we don't have a tribal court, and we don't have due process as a result.
Anybody else? Blair?
Didn't Aaron just say we had 200 to 300 attorneys that are tribal members?
Yeah, we shouldn't have a problem.
That's right. So we should take that non-tribal attorney out of there.
Well, let's poll on that. I'll request a poll on it.
I agree with the sentiment that I would rather have Sioux tribe members on our bench, or at least other Native Americans, before we would go to a non-tribal. I will just flag, I shared the same concern that Director Payman just kind of reiterated, and other attorneys have. I think the drafters of the 2008 draft didn't share this concern, but I would never want to see Sioux tribe in a position where, for some reason, if we cannot find a Native American or a Sioux tribe member specifically to be on our bench, that we box ourselves into the Constitution where we cannot fill that seat and then we don't have a functioning court. It's something to at least consider.
Hey, Ryan, can I ask you a question?
Yes.
You just did interviews. How many applicants applied?
I had 3 qualified applicants for staff attorney that I interviewed, and four applied.
There might be 200 or 300 out there, but they're not knocking down the tribe's door to come work for us, so.
Were any tribal?
One was other Native, one was Sioux tribe member, but they dropped out of the running. So the other applicants were non-tribal. Right, there was one other Native, there was one Sioux tribe member, and there were two non-natives that applied. There was four applicants, so, and one just was not qualified yet because they were still in law school. So.
Tyler, and then Kim. You too.
So before we do that, can we also pull on the age too? Just note that we want to pull on the age. And then as far as that's concerned, like, my concern is more with the Supreme Court than the trial court, because they're going to be making constitutional decisions, and it is not appropriate for the white man to make decisions for us as a nation. A lot of our issues came from that. It stemmed from that. It's also a little nerve-wracking that they can be appointed. If we're short on tribal citizens with bar licenses, I would rather see it open up to more lay people on the Supreme Court, so we have the tribal voice, with maintaining the bar licenses in the trial courts. I don't really know how that looks. I think this needs more discussion, but I am concerned about non-natives making constitutional judgments against the tribe. We've seen what that looks like in other lawsuits, in other courts, and I don't want to see it here.
Kim. We got Kim, and Mike.
Okay, me, Kim, right?
Yep.
Okay,
Kim G.
MG. So how long does it take for someone to go through law school?
So law school is 4 years.
4 years.
So if you go right from undergrad to law school, you'll probably be around 25, 26 when you graduate, and then you take the bar. So you'll be around 26 years old if you go straight through all the way without taking any breaks.
Then when you take the bar, you're considered,
Once you've passed the bar and you're sworn in, then you're a licensed attorney. That can
so you
take,
could be like 28 years old? And that's,
Also-
well, I mean,
yeah.
hopefully you pass it the first or second time and you're not having to retake it a bunch of times. And so shortly after you graduate, you will take the bar within a matter of months, and you'll have the results pretty quickly, whether you pass or not.
So we should have some good attorneys by the age of 28. But they haven't
Yeah.
really practiced yet?
Right.
Is
So
that the thing?
the 35 years of age was pulled from the 2008 draft. They had that several times in there. I don't want to presume their intent, but maybe part of it was to find someone who maybe had practiced law for a few years before they were a judge. I don't know if that is necessarily dispositive of anything, but it might have been part of the reason for an age
And then
bar.
I thought we couldn't put age into hiring, some kind of, that kind of.
Oh, yeah, but these aren't necessarily hired though, right? They're elected and or they're appointed, and there are other states and, yeah, you can, it's state, federal, there's age limits on judges.
Okay.
That's something that is standard in many jurisdictions, tribal or otherwise, yeah.
Yeah, because I'm with Tyler, once we lock in that 35 years, in order to change it, you're going to have to do an amendment to the Constitution.
That is
again.
true, it does lock us in. We're not, we, meaning the legal department, I'm not set on that being the age necessarily. I pulled that from the 2008 draft, and it's a pretty standard age for a lot of other jurisdictions for their justices, but it does not have to be that way. We can do what's best for
If they
Sioux Tribe.
preferred. But,
Or you don't put any age, and you can legislate certain parameters that are in line with the Constitution, right? You could have a preferred age that wouldn't be out of line with your Constitution. It's
I'd
not
rather
a
see that.
mandate, right? There are ways you could take this out of here. Code could still, or hiring preference could still have preferences without being out of line with your Constitution. It's not a mandate. So there are ways you could still try to target older, more experienced judges.
okay.
Okay, I have Kim Lee, Mike, and Rob.
So once we switch things to non-elected versus elected, is there then, I guess, wage differences? Because then you throw in, if somebody's appointed, say it's not a native, that finishes out that timeline, say, after a year. That's 5 years that we want to talk about locked into something, that's also locked into something. And if that person doesn't work out and the tribe as a whole doesn't like the way that that's going, we're also still locked in, and that's scary.
It's something we talked about that in kind of broad terms last workshop, and I think when we get there, it's further down, we have a resignation recall section. It's probably gonna need a little bit of finessing, because right now, I think the term down there says elected officials, but if you're appointed, are you covered by that recall terms? So if we appoint someone, are they locked in and we can't recall them? That doesn't seem to be the intent. So we probably got to finesse, that's further down in this draft. We'll have to finesse that language when we get there, yeah.
Right, because here's the thing, right? All of this is about listening to our people. And when we're appointing somebody, right, that's not necessarily the people's will, that's what, right now, we think is in the best interest, and in here, what the Ogama thinks is the best interest, that's not the people's will or wish. So that's concerning to me.
And maybe it'll never be an issue. Maybe maybe every election we have multiple candidates for judge running. I don't know. I don't have a crystal ball that can see into the future. But there may be some prudence in having some language to cover the event if we do not have someone like a Sioux Tribe member who's running for office.
Have we looked at that within other government structures that are set up that way? Do they normally have an influx of people that are scratching down the doors to when the judicial branch is separated, regardless of that's 2 or 3?
It's really, it depends. It's a mixed bag, Kim. It depends on the tribe. Some really big tribes, Navajo, Cherokee. I know some friends that have worked out there, and they don't really have too much of an issue finding. They're huge. They're hundreds of thousands of members, and so they usually can populate their attorney's office and courts with attorneys. They have language requirements. You have to speak Navajo. They're able to do it because they're of their size, and maybe we're sizable. We're not that big, but maybe we also would be able to. But a lot of the smaller tribes, I think Aaron, you kind of brought this up earlier. They have like kind of fallback provisions, I'll call them, where they can appoint, not usually elect, but they can appoint other attorneys, whether they're other native or whether they're non-native, to make sure they always have someone on the bench. And so it's pretty common, especially with the smaller tribes, to have language that allows the Ogama or the legislature to appoint or confirm judges, so they make sure they always have someone on the bench just in case they can't find a tribal member. But most of them that I've seen all do have a preference for their own tribe first, but then they have the ability to do other native and or even non-native, just to make sure they always have people on the bench.
So that to me is one of my biggest concerns, okay? Because now we're going from the will of the people to the will of the people, right? When one person is making choices, and this is just one of the issues that I see, right? Where does the will of the people reside? Yes, everybody will be voting the executive branch in, but that doesn't always, and this has nothing to do with the chair we have now, nothing to do with past chairs. What is going to be in the best interest of the people as a whole? And that's what, when I look at this, scares me. Because regardless, when we vote anybody in, right, we're essentially, they're stuck with us for 4 years as long as we do whatever. So that's pretty scary when we're talking about who we're going to put behind that bench, who we're going to put in an executive branch, or how are we going to look out for the people as a whole? And to make sure that their best interest is always at heart. So leave it alone.
It's always a, sorry, I'll let you go first, Aaron, and then I can chime in.
No, it's Mike, Rob, then Aaron.
I don't know, I've heard both sides of the argument so far, so I understand the whole non-tribal thing to make sure that there's someone on the bench, but I think if we just got rid of non and just kept it tribal attorney, and we would probably have a bigger pool and still get at least someone tribal in there. There won't be a Sioux tribe member necessarily, but at least there still be tribal, and I think since this is with what's at stake, I think it probably should be a tribal employee, tribal person as well. So I think if we just take the word non out, I think we should be sufficient to keep on operating. So I'll leave it at that. Yield.
Rob?
Yeah, I agree with Mike, and I actually agree with Tyler on this one, that I think a bar certification is more needed in the trial court. So I think an appointment process for that would be necessary. But as far as constitutional rulings, I think they should all be Sioux tribe members. Or like Mike said, at least tribal. So if we can fix that, but I still believe any trial court judge needs to be certified in that capacity. I think that is more important than making sure they're tribal, just because of the weight of the cases that they're handling. They need to be very well certified and qualified to do so. We're talking about child welfare, and someone's right to parent is the most sacred right you have, and you have to be highly qualified and know the law to make those determinations. And then as far as the age, I think that I don't think it should be left to legislation, because then you have legislators basically getting to map out who gets to provide a check and balance to them. But I don't think it needs to be 35. I'd be okay with just sticking to our current constitutional guidelines. I think it's 18 and older, and that you have to be a Sioux tribe member. And I think that's enough. You have every other right when you turn 18. I don't think that limiting the voice of the members to someone over 35. I honestly don't think the members are going to elect anyone under 35 anyways, unless they're highly qualified. But that's a choice of the members. I don't think we need to draw that out in the Constitution.
Aaron?
So, again, I'm worried about poison pills being thrown up here. The committee spent 3 years, 29 people wrestled through all of these issues and concluded that the importance of a Supreme Court is not to render a personal opinion, not to render an unqualified opinion, but they're ruling on issues of law. They're ruling on constitutional law. And so the committee recommended that that be somebody who's qualified, and that's an attorney. So if, you know, we've had this issue at the appellate court level for our tribe in the past, and it's deficient, where we have non-attorneys on the appellate court. Their job is to examine whether or not the lower court applied the law properly. Their job is not to sit there and to give opinions, personal opinions or historical opinions or anything like that. Their job is to determine if the law was applied properly. The Supreme Court is going to be even more important for them because they're weighing our constitutional rights. And if somebody's rights were violated, or if the legislative branch violates your rights, it could result in creating new law. Because if the legislature makes a determination or legislates a law that violates your constitutional rights and the Supreme Court overturns it, then usually there's a grace period by which the legislature has to revise the law to come in compliance with the constitutional law. So I don't know why somebody is bringing up the question about whether or not the Supreme Court should be qualified, or just anybody off the street that's 18, any tribal member that's 18. I don't know why we're revisiting that, so it sounds like we're going to have to poll on that too. I also don't know why we're bringing in the executive, the OGIMA, as an argument or example that if the people don't get what they want or need, we have a provision for that right now, and we would, in the new law, is an election. So I would argue that we aren't collectively, the majority of us are not listening to the will of the people, because they just told us what they wanted. They said 56% want a 3-branch. There are provisions in the new draft constitution. I don't know if they're going to survive this level or not. I don't know if we're looking at that, but there is a provision for a recall. We don't currently have a recall. We have removal for cause, but we don't have a recall. I'm not opposed to a recall provision in the Constitution. But it almost felt like when we were talking about the executive, that the people weren't making the choice for the executive. We will not be appointing an executive. We're not going to be appointing a chairperson. And I really appreciate Kim's comment to that. I know she wasn't a party to appointing somebody without the will of the people being known, but we should never be appointing an OGIMA without the will of the people. Only the people should be able to make that choice, not the board of directors. So it sounds like we have another poll on whether or not the Supreme Court has to be qualified, licensed attorneys. I know that if ever I end up in front of the Supreme Court, I want them to make a determination based on the law, not based on anything else, not opinion, not my speech in the last election, none of that. None of that's relevant. What's relevant, and the only decision they should make, is whether or not the law was applied properly. And the Supreme Court will be vested with the authority to hear cases based on whether or not the Constitution is being honored and followed. So that needs to be somebody that has the most qualifications. So finally, I could probably get to or agree that they don't have to, or that they have to be tribal members in order to serve in our court system. I can probably get to that, because I do think that they're going to be out there. When we've tried to recruit general counsel, when I was assigned to conduct that process and bring that to the board of directors, we had a lot of tribal members who said, if I didn't report to the board, I would apply. So I think we will have a lot of people apply. So I can concede on the requiring that they have to be tribal, so I can agree to that. I can agree to that they have to be at least 18 years of age, so should be an adult, because I think that the Peter Principle and the qualifications will ferret out unqualified people. It would be a travesty to hire or to elect a 19-year-old that has no law experience at all. That's just nonsense. So I guess I'm trying to see if there was anything else. But I hope that what we aren't doing today and tomorrow is throwing up a bunch of new concepts that is overriding or second-guessing all the work that the Constitutional Committee did. They wrestled through this. They spent 3 years on this issue, and they came to the conclusion that the Supreme Court should be qualified, licensed attorneys. So.
If somebody's talking, you use your mic.
Oh, sorry. I got Kim Lee, Rob, and Tyler.
So I think one thing that, and maybe I'm wrong, that we all agree on is that somebody that's sitting in that courtroom needs to be licensed. I haven't heard anybody say that they thought just any random elected person should be sitting there making those decisions. That is one thing I have not heard, which is great. And nobody is trying to take away what was done in the past. But our present concerns, just in the last month, watching the federal government, the state government, our own government, gridlock, lock each other up, and what a disaster it's been. I don't think we can call it a poison pill. We can call it a difference in opinion, because times do change. Things do change. They've evolved, and we need to make sure that where we're at right now is going to be in the best interest for 7 generations to come, and that we protect 7 generations ago. So I don't think it's necessarily a poison pill, but a difference in opinion. And the divide comes from a lack of respect. So to sit and say we shouldn't even be discussing this, that's wrong. We all have to evolve. And we have to make sure we're protecting everything that our ancestors fought and a lot of them died for. So I would like to have this conversation without it saying, we're saying that it's poison pills. No, it's a care. What we want for the people, hopefully, is all the same in the end.
Rob?
So, I mean, I'm going a little back and forth on the court here. I don't think that non-tribal members should be making constitutional decisions. But in the I think I'm cutting out. Hello? Can you hear me?
Yes, we can hear you.
I think that we're drawing too many lines around the parameters of the judiciary here within the Constitution. I think some things could be left to code, like preference. But I do think that they need to be, after listening to Aaron, I think that they need to be qualified. I think that I don't think we should have a lay judge even on the appellate, as they are determining constitution, but they're also determining rights, and you need a level of law to determine that. As far as age goes, I'm not too concerned with that still. I think you gain every other right when you're 18. You could go in our casinos and gamble. I think, what's that, 19? You could go across the seas and die for your country when you're 18 years old. I don't see any reason you can't run for political office. And I think that's further a limitation of the power of the people. Anyways, like I said, I don't see them electing someone young and inexperienced. But if they're bright enough and they show the right mental frame, I think that they should be able to run and they might have a chance. As far as talking about poison pills, some of these, they could be. And maybe it's not good to use that word because we're throwing around to the idea that people are trying to sabotage the three-branch government, but I'm going to be pretty blunt. I think some people are. So, I mean, it is what it is, and I think they're going to throughout the process because they simply just don't want to give up power. And I'm not saying that about Director Lee or anyone else, but I'm saying, I'm not into hiding what I think about anything on any issue, and if I think there's something nefarious going on, I'm going to call it out. And I do believe that there are people on here who will never support a three-branch government, yet they're participating in this, and I think that's wrong. If you're not going to support the three-branch government, save your input, because your input could be very much intended to derail the process. So, if you're intending on holding out because you're seeking a better document, then by all means have your input. And I think there is a couple of people who are doing that, and I don't blame them for doing so. I think that that's the responsible thing to do. So if you have good intentions of, if this document turns out something you could support, you will support it, then I agree with you. But if you have zero intentions in supporting it, then just, I guess, stay quiet. I don't know. But the idea that, I do have to respond to one thing, this idea that we're not abiding by the will of the people if we go through appointment process. Our members are smart enough to know what they're voting on. And if they just polled to have a three-branch constitution with overwhelming numbers that nobody could argue, that is the will of the people. And that's not debatable. Our chairman right now has exceeded, the voting numbers. If that's not the will of the people, I don't know what is. So whether it's this chairman or another chairman, let's say 20 years down the road, our members will know that based on this Constitution, when they vote in that chairman, that they very well could be voting in someone that will make appointment processes. So I don't want to hide away from making certain decisions because we're worried about an executive appointing. That executive will always be appointed by the members, which is a reflection of the will of the members. So that argument doesn't hold water whatsoever. This is a drastic step towards empowering the will of the people, this document all on its own. So I don't like hearing that it would be scary to have an elected official who's reelected every 4 years appoint someone, because right now you have a board who has complete authority over a court, who hire and fire the judge. That's a whole lot more scary than having an elected executive appoint them any day of the week. That is a scary thing, and that is probably why our members are overwhelmingly telling us you need to separate the powers. They don't like this board having all the powers. I'm going to flat out say it. A lot of members just straight up don't even like this board, because when you don't have a separation of powers, you have a breeding ground for corruption, and it's been the case for our tribe for the last 50 years. So nothing is more scary than the current situation that we're in and the system of government that we've been operating for 50 years. Nothing's more scary than that. So to use the word scary when we're talking about allowing an executive who's been elected by the members and the membership as a whole from all units and at large, I can't see how you could think that the current situation is any less scary than that. What would be scary is continuing another 50 years the way we continued the last 50 years.
Well, it sounds like I missed some good stuff.
Hey, Tyler's next.
Tyler, go ahead.
Going back to the discussion, I do agree. I thought during the last meeting towards the end, we were talking about having a position on the Supreme Court for a layperson to protect that tribal sovereignty. Maybe that was a side conversation. I can't remember. But I do agree. I think 2 of the 3 should have bar licenses, but we need to make room in that Supreme Court for tribal citizens and interpretation of that Constitution. Really concerned there. I do like removing the non-native portion altogether. You know, I can live with that. I do think it needs to be Sioux Tribe first, and Sioux Tribe at every effort possible, especially when interpreting that Constitution. That is my biggest concern right there. The age. It sounds like we agree we can just remove the age, but I do want to talk about having that. Crap, I'm getting called into my appointment here, so maybe I should skip my appointment. Talk about having at least one of the 3 judges in that lay position. That would be my concern. So, but, whatever everybody agrees on.
Aaron.
So generally speaking, we're hearing all kinds of arguments that, to me, second guesses the work that the committee did for 3 years. There was a variety of people on that committee. There was an attorney, at least one attorney that I know, Dickie Mastaw. Most of the people on that committee were not attorneys. I'd say most were not bachelor's degree qualified people. So it represented a diversity of opinions. And what they did, what I understand they did, is they looked to the future. They looked to draft a constitution that will transcend any individual. There's something really arrogant about once we're elected, we think we know better than what the people want. And saying that, well, people change their mind over time or whatever. These people did almost 3 years of their lives to commit to becoming experts on reviewing our Constitution and coming up with recommendations for us. In the cover letter that came from the chair of the committee, he suggested very strongly and clearly not for us to screw it up, not for us to start picking it apart and second guessing everything. And so far today, what we're looking at is we're unpacking or picking apart the age qualification, the preferred or native qualification, and the provision to be able to appoint a non-tribal person if we can't find a tribal person. I'm willing to concede on both of those because I'm not here to find a reason not to approve this and move forward. And I appreciate Rob also echoing the concept of I said poison pill. Maybe that's too strong of a word, but if we're picking apart and coming up with all kinds of reasons not to support what the committee recommended, and what the 2012 review unanimously recommended, and what the Elder Advisory unanimously recommended, and what the 56% of the people recommended, then I don't know that we are serving the will of the people. There was a talk about our job is to serve the will of the people. So that is the very definition of a filibuster, bringing up items that have already been settled by the committee, and also to a great extent settled by the people, because the people had access to this draft document. The people weighed in, and I also appreciate Rob saying they're smart enough because, to me there's almost a feeling like they didn't know what they were voting on, they didn't understand what they were voting on, but they polled, not voted, they polled for a 3-branch. So the one part that just doesn't make sense to me is if we're talking about requiring, and I'm there, I'm in agreement, requiring that the Supreme Court be tribal, then this argument that at least one person has to be a layperson in order to express culture is suggesting that the tribal attorneys that would be on the Supreme Court are somehow not cultural. That by going to school, you've assimilated and you no longer have cultural values in your heart. I think that's offensive. I think we have lots of tribal member attorneys that follow our traditional ways and that understand our cultures and customs, and I don't even think they have to have learn those growing up if they're sensitive to it and they apply some canons of tribal tradition. But the most important qualification for a Supreme Court justice is that they can understand law, that they can interpret constitutional law, and that they weigh in their opinions based on that and nothing else. I do appreciate when, like our appellate court, will weigh cultural customs as they're making their determination, but first and foremost, their role is to interpret the law, not anything else. Not what you heard our culture was, by somebody or whatever. And I've been trying to be careful not to say that people are throwing out poison pills, but I will say, so far now, we've got 3 items that were already decided by the committee. One is the age limit, so we're second guessing that and about to potentially throw that out. One is that we have a provision for appointing non-tribal people to serve at the Supreme Court level if we can't find a tribal. That's right now being considered to be thrown out, not in respect to what the committee recommended. And then now we're all even talking about, talking 2 different sides of our mouths here by saying that they all have to be attorneys, but we need to have somebody, a tribal citizen, that can impose the culture at the Supreme Court level. But if you have all tribal citizens at the Supreme Court level, isn't there a presumption that they're going to have some cultural values? So that does feel like a filibuster to me, because if they're all tribal attorneys, I'm satisfied that they're going to impose some aspect of culture there. Ryan is our chief counsel. You hired Ryan. Did he have to go through a litmus test of culture? Did he have to go through a week-long sweat? Does he know his Indian name? I don't know if he does or not. We never asked that question. He's a tribal member. And I don't know that we afforded you preference either. I mean, you were qualified. So picking and choosing this stuff, I think, is not appropriate. And I think if it was subject to law, it probably would not be legal.
So before I proceed in the list, I have a request. So we're going to take a lunch break in 50 minutes. Until then, can we put our phones away? Quite simple. I'm going to flip mine over. Can you guys put your phones away? This is an important conversation, and we don't need people to tell us what to say if that's what's happening. Because I just looked around the room, and there's 5 people on their phones, and then the hands go up. You can do a point of
I
order.
was on my phone, but to allude that I'm talking to somebody else and I don't need is objectable, so I'm objecting.
At the last JKL meeting, you had JKL staff call you guys out on that after the meeting. So let's just put the phones away.
You just got back here too,
Yep.
but I'm not calling you out for that because I think it's not appropriate.
I know that. But it's a simple request. During this conversation, can we put the phones away?
Mr. Chair. So orders of the day is that we're requesting a poll on the age, whether or not we're going to respect and honor what the committee recommended, or we're going to eliminate the age. The other one is whether or not non-tribal licensed attorneys could be appointed if we can't get a candidate to run. That's another poll. And now it appears like there's also a request to have non-attorneys sitting on the Supreme Court level. Tyler did bring that up. Kim suggested nobody said that, Kim Lee, but Tyler did bring that up.
Okay.
And then I would like to take a poll right now that we put our phones away for the duration of our review.
I don't think we need to do a poll. I think it's a reasonable expectation. We're in a room with staff. Staff aren't on their phones. This is an important conversation. Let's just put them away. Let's have this conversation just in this room. And then we're going to go through the list, and then before lunch, we'll have polls on the areas of action. So, hold on 1 second, Lena. So I have Kim Lee.
Josh, you're unmuted.
I got it.
1 second. I have Kim Lee, Kim Gravel, Rob, then Lana. Yeah, go ahead, Kim.
So the will of the committee, if that was what we were all following, none of us would have this conversation if we didn't believe that we were all here. And this is not my opinion. I also talk to members and also reach out to my elders and look at history. So this conversation, right, and we've got multiple drafts of different generations of people who worked on this. Some of them were through it all, but some of them weren't. So I guess anytime that we're even bringing this up to make sure that it's right now in the best interest of our people. And whether any of us want to believe it or not, I've watched just in the last month alone, every single branch of government fall apart in one way, shape, or form. And you can say that's not scary, but to me it's terrifying. How about I change that adjective?
Okay, Kim Gravel, Rob Lana.
Okay, I don't think anyone's trying to stymie this up or anything. 17 years ago, we weren't having problems getting judges or attorneys. We are right now in this day and age. And that's the reason the age is being removed, the non-tribal, or taking the non out of there. And that was the discussion we had. So we're looking at what's happened in the last 17 years. And at least in the last 6 to 8, we have been having trouble getting judges. And we're going to have how many, Ryan, that we're going to be putting in place?
So you'll have at the trial court level two judges plus maybe substitute judges, but a chief judge and associate. And then the Supreme Court will have a chief judge and 2 associates in the current form. So you'll have, between your 2 courts, you'll have 5 judges.
Right, and that's the reason we're taking some of these stipulations out, because of how hard it is to get these people in these positions. So it's not like we're tearing it apart. I was on that committee 17 years ago, and 17 years ago, it was a whole different world. That's my...
Okay, Rob Lana.
So first of all, I think we all have to be okay with some minor adjustments to this document, because if we're going to be honest, I presented one that was almost identical to what the Constitutional Committee did, and it failed. So this is our process to get some of you guys from a no to a yes. So to say that, to keep pointing back to the committee, we're past doing exactly what the committee wanted. So now my intent is to try to remain as close to the intentions of the very fundamentals of this. So that means the separation entities have to work as a check and balance that empowers our members. So minor adjustments to court staff or the age of who can run, if that gets you guys to a yes, I'm fine with it. I've accepted that we are not getting the draft that the committee presented. I knew that when you guys voted no on the one that I presented, because it was very close. We've now changed way more than I've changed, way more, and you guys voted no on mine. So let's stop pretending like we're here to appease the will of the committee, and now focus on appeasing the will of the membership as the whole on the most latest survey, and respect as much as we possibly can respect about this, and still arrive to a yes. But let's not be pretending that we're still trying to keep pointing back to the committee and saying we're not going to change it. You guys already changed way more than I even intended or tried to change. So with the changes that are being discussed here, I'm still a yes. We have not dissolved the fundamentals of this document, and nor will what we're polling on do that. So I'm going to be a little more lenient and let you guys all have your input without being too confrontational. But I want to get away from this keep pointing back to the committee thing. That's long gone, and that was a long time ago. It was voted down. It's not supported. There was no go on it. So let's try to remain as close to the intent of the fundamental principles and not change too much about the document. But we'll never be able to say that we did exactly what the committee intended right now. So let's stop doing that. And I don't know that there's been a collapse of every branch of government. I don't know what Director Lee's talking about, if that's the state or the federal government. I think that we have elections, and elections have consequences, and some people just don't like the turnout of the elections. But we still have a functioning Supreme Court. We still have a functioning executive branch, whether people like it or not, or who's in office. You know, I think we could do a lot better, but it is what it is. At the end of the day, the people voted. You still have a legislative branch. Is our government doing what we as Native Americans want them to do? Absolutely not. But at the end of the day, it was the people who decided it. And I'm not going to argue with the process of that. Because it works a heck of a lot better than what we've been doing for 50 years. What we've been doing for 50 years is a one-branch government, where your government can hire and fire the judge who makes decisions in a small tribe. I mean, we're the biggest tribe east of Mississippi, but in terms of community, it's a small-knit community. Everyone's going to know everyone. So you have a board who has large families appointing judges and having control over the judicial system, and to think that that does not affect how the judicial works is absolutely crazy. And you know, we're talking about the will of the members. I don't think it's a terrifying thing to place the power of government away from the legislative body and into the hands of the people. That's what this document does. No matter which way you cut it or argue it, I think some biases about our current chairman are coming through in these decisions, and it's to be expected. But at the end of the day, no matter how you cut it, this document takes power from the legislative body, which our members do not want this body to have. They don't. It's been overwhelming for 20 years. You could talk about the will of the people all you want. The will of the people is separate the powers, period. It's not argument. So many of us put that on our platforms. I don't know how we do that and then sit in these seats and say, well, it's a terrifying thing. No. It's what the people want. It's overwhelming. It's not debatable. So I don't know why we're going to keep bringing up stuff like that. This is exactly what the members voted on. It's what they worked on for 20 years, or it's what they worked on from 2005 to 2008. It's what they presented. It's what they reaffirmed in 2012. It's what all the Elder Committee said to go off of. It's what the members just pulled overwhelmingly on. So I don't know where that argument's coming through. I yield.
Okay, I have Lana, then Aaron, and then hopefully we're done with the discussion and we can give some direction on this document with some polls. Unless we have more hands up. Do we have more hands up? Okay, Lana, then Aaron.
Well, I haven't said anything other than ask what the changes were, so I don't, these words like poison pills and all those things are that's not going to get us anywhere throughout this concept. You know, and the lectures need to stop. When people have opinions, those opinions need to be accepted if we want to get anywhere. So I've been quiet all morning other than asking for the changes. One thing I will say, for what it's worth, is a minor adjustment to Kim Lee might be a major adjustment to Isaac. So those things are up to interpretation by us having our input. We're not going to get anywhere if we just go through lectures throughout the day. I frankly think people love to hear themselves talk about it. The same thing. So I'm probably not going to change anything because, like I said, one minor change to you might be a major change to me or the membership. So I'm going to try to, and sticking as closely as we can. I don't know how you interpret that, but that's up to you individually or me individually. And as far as putting my phone away, not a chance. I will pick up my phone anytime. If people want to contact me throughout, they can do that. So I don't know what's going to happen when I pick up my phone, but I will be. So.
Okay, Aaron, you can go ahead.
So, you know, I don't know how many people are watching this. We posted it so people could see. You know, I want to recognize that there is an inherent bias at this board table because what we're talking about is divesting our unitary discretionary authority. You've heard arguments at this table just this morning about that contradict what the committee came up with by saying, well, I've talked to an elder or I've talked to somebody who doesn't agree with it. But if we cherry pick who we're listening to, then, we can pick and choose who we're listening to, and we have to trust that the board member that's sharing that actually did talk to somebody. Or we can look to see what the people told us. What the people told us through this process over a span of 3 years, 29 people appointed in every unit, every single unit, and in every community in every unit. So we're talking about 9 communities. The Elder Advisory is 9 communities. So every single one of the units that you go to their elder committee meetings, the elders in those committees that are represented at the Elder Advisory recommended that we approve the document, and the chairman, in very explicit words, I posted the memo, said, don't mess it up, don't change it. And so I am concerned, and I'll call it out whenever I feel it necessary, that we are undermining what the committee's intention was for us to pass. And so far, we've seen, we haven't gotten past 3 items that the committee recommended, and we're undoing the age, we're undoing the native preference, or not native preference, but requiring that they have to be all native, and then whether or not they even should be attorneys on the Supreme Court, which I think that argument doesn't make any sense at all, and that might not be everybody's feelings, but it was suggested here. And so how do we know what the people want, rather than just anecdotally cherry picking what, this person said or that person said, is to go based on what the people collectively have told us. And what the people collectively have told us is that they want a 3-branch separation of powers. So it remains up to the interpretation of this board for now, because we will change our Constitution. Our government will evolve to a 3-branch separation of powers. Whether it happens now or it happens in the future, we know that the people are strongly behind that. And I guess one other thing, and Rob had said, I don't see where the government's unraveling. I do agree that we're in a very precarious situation right now with our United States President, the Supreme Court, and the legislature. But one very big difference is throughout all of that conflict at the federal level, we have been successful with being part of litigation to overturn the president's decisions. Decisions on not funding us, decisions on reducing reduction in force, dismantling the delivery of services to Indian country. We have been participating in that. We've been successful in that. But the big difference between that outside process and us, citizens in the United States have due process. They can file lawsuits when the president violates your rights. They can file lawsuits when the Congress violates your rights. We don't have that provision at all right now. And we've been 20-some years into this, and it's unconscionable to me that we can come up with arguments not to move forward while every citizen currently does not have the right to due process. They don't have a right to file in tribal court to overturn the board's decisions, and that is unconscionable. That can't continue, and the people will not stand for that. So the people decide who they elect, and when it becomes clear whether people support a 3-branch separation of powers or they don't, or they disguise it that they have concerns or whatever, that'll become obvious. People are watching. They know what we're doing, and they know what they expect, and they don't want us to delay it any further. So I do hope we get to the polls. There's 3 different polls that I can see so far. One is on lowering the age, or not having a minimum age, which I can concede to, because as long as you still have to be an attorney, then you're going to at least be 25 or 26 years old. I can concede on requiring that they all have to be tribal members that are attorneys to serve in our court system. And I don't think it's necessary for us to try to unravel, because I don't know if some just don't understand what's drafted, but it does say that they have to be attorneys right now, and that's what the committee recommended. And the Supreme Court should not be made up of anybody that's not a qualified attorney. To me, that's just completely nonsense. What are they making their opinions on if it's not the law? So.
Okay, so the list I have is Isaac, Rob, then Kim.
Hey, Mr. Chairman, somehow we got to speed this process up if we're going to have a vote on the 6th of January, so I don't know what we can do, but all we're talking about here, from what I see, is we're talking about age and qualification. That's pretty simple to me when you break it down like that. I mean, and everybody's had opportunity to review everything, right? You shouldn't have to stand here on a grandstand to speak your piece, and let's move on so we can get this done. That's the most important thing for us,
It
right?
seems like most of these things, people would need one turn to talk about. State your opinion. We don't need to have arguments and debates going back and forth, and I stand by it. If you guys have phone calls, go out in the hallway. You know, my phone's turned upside down. I have 2 kids. I'm reachable, but we're in a professional setting right now, and our staff is there, and no one else is on their phone. This is part of a long-standing complaint from people that come to the tribe.
I'm just authenticating to get onto my email right now, and I
Okay.
got booted off the thing, so I'm using my
Okay.
password on here to get onto there.
Mike, but you absolutely know, when people come to this meeting, when they come to
Show you
workshops,
If you need to come look over my
I don't need to
shoulder.
look at it, but what I'm telling you in front of this camera where thousands of people watch, we have people after people come to these workshops and say the board of directors
Well,
is
I'm
zoned out
using
on their
my
phones.
Email to get onto the web thing for everything.
Mike,
So,
it's a
point of order.
it's a simple request, just put your phones away for this
I'm
conversation.
going to finish getting onto the thing.
Okay, that's absolutely fine.
But I'm-
That is
yeah.
absolutely fine. Okay, so let's move on to Rob, then Kim.
I'm good.
Okay, Kim?
Okay, what we have in front of us is the 3-branch separation of powers. So we're not doing it. And Aaron, I'm sorry, but when you're talking, it makes it sound like nobody is looking at the 3-branch right now, and this is what we're working on. We're tweaking it. We're getting rid of some of the things that aren't going to work today, that may have worked 17 years ago. So nobody here is not working on the 3-branch. We're all sitting here with the 3-branch draft in front of us. So I want the people in the audience and online to know that we are working on this. And I keep hearing it's our duty, anyone who doesn't do this is not doing the will of the people. We are sitting here working on the 3-branch, and I want that known. So when we come back after lunch, we're probably going to go to another section that might need some tweaking. I mean, I just showed Ryan a little mistake there, so I just want everyone online and in the audience to know that everyone sitting at this table right now is working on the 3-branch.
Okay, let's provide some direction now. So we need to do some polls. So the first poll will be not having a minimum age. Second poll is requiring that everyone seated on the bench will be a tribal member. Is that correct, Ryan? I missed part of this conversation. Okay.
Yeah, so-
So would that be a Sioux tribe member or tribal member?
So, yeah, the poll for the voting, or taking out the 35 years of age, a poll for whether all of them need to be Sioux tribe members.
Okay, Sioux tribe members, okay.
Because right now we have the ability in this draft to appoint a non-tribal attorney if need be. So I need direction on that.
Okay, and then I heard reference to a third poll?
Poll may or may not be necessary, because several board members have said they never heard it, but when you were stepped out, Tyler did suggest that we don't need to have all 3 of the justices at the Supreme Court level be licensed attorneys. He suggested that at least one should be able to be a tribal citizen that can bring culture to the table, when the other 2 tribal attorneys that are at the thing can also bring culture to the table.
So are we requesting a poll on that as well, that everyone have a law license that sit on our bench? Okay.
Tyler's the only one, I
second,
don't think
Kim.
we need it.
Is anyone else wanting that poll?
Can I do a point of inquiry real quick?
First, Kim Lee, she had her hand up first. Go ahead, Kim.
Just to add to that, it's not that I necessarily didn't hear it. And what I thought, I guess you were referencing, which I apologize that is not the way I had heard that, was the Chief Justice for Supreme Court. That was what I had thought that you were discussing, not so much the court that'll sit with that. So just as clarification, we don't need to poll on that, in my opinion, but
Okay.
that was what I thought you were.
I appreciate that clarification, but Tyler was clear and explicit in suggesting that at least one of the Supreme Court justices need not be an attorney.
Okay, Rob.
I think you might have been the only one on that. I don't think we need a poll. But my point of inquiry was, Ryan, if and I might not be remembering this correctly, but what is the appointment process in here? That's not carried out from the original draft, is it? That is because we need to identify a process for that, right? Is this a legal suggestion here?
So
I just don't remember it being in the original draft. I think it was a component that I even had to do something with when I presented my draft.
Yeah, you're correct, Rob. The 2008 draft did not have an appointment process. I've talked to some members, tribal members who were on those committees, and it sounds like it was discussed, but it never made it into the 2008 draft. It was in the amendments that you presented was that last October now? Time is funny.
Yeah.
And they are, I don't think I tweaked it too much from what you presented. They are being presented again. The legal department thinks that it is a worthwhile discussion to have some kind of appointment process to fall back on. Last workshop, just to refresh everyone's memory, we did, in section 2A here, we did come to the consensus that associate justices of the Supreme Court are not elected. They are appointed by the OGMA and approved by the legislature. And that we pulled on that last time. That was in whatever 3 weeks ago that was. So we are suggesting from the legal department some kind of appointment process for the associate justices, as well as for a fallback if we can't find a chief judge, as long as they meet whatever qualifications this majority body comes up with. If no one runs for office, we strongly suggest you have some kind of appointment process in place. Yes.
Okay, no, I agree, and I think that's the intent, but I just wanted to clarify, because I think some people mentioned that this was changing the document, but that's a needed process. So I just wanted to make sure that everyone's aware that was not in the 2012, but it's needed. So that's an example of, why we need to be here, what we're doing, and this is like what Mike said. He said if we get to a point where we have a document that's satisfactory, then he can support a 3-branch government. So we're doing right now what a lot of the board members who didn't agree with either my draft or just wanted to sit down and make sure that they could tell their constituents, I did my due diligence and made sure that document was something I could support. So changing or implementing a process that's not there, that's a needed process. So we're not in the wrong by adding this to it. And I just wanted to point that out again to say that it's not the same document, but we're doing what we need to do to deliver to the members what they want us to do, and that's the 3-branch government.
Okay, Tyler, do you want me to do a poll on licensed attorney? I want to be fair in this. I didn't hear anyone else support it, but if you want me to poll, I can.
I don't think he's on.
Okay. All right, so poll number 1 is having a minimum age. Yes would signify that you want it to be 35 or older, which was the recommendation of the Constitutional Committee, and no would be, there's no minimum age, but we're assuming that someone's going to be law school educated, which would have a minimum age of what, like 25, 26 years old if someone goes directly from high school to undergrad to law school. So that would be poll number 1. Any questions on that? So a yes would be that you want the judges to be 35 years or older, a no would be, it's up to the voters. Okay, so we'll do a poll on that.
Kimberly Gravel.
No.
Kimberly Hampton. She's not online. Lana.
No change. So that'd be a yes.
Bridget.
No.
Rob.
No.
Sean. Larry.
No.
Kimberly Lee.
Yes.
Tyler. Aaron.
I will say no.
Michael.
No.
Isaac.
Yes, no change.
Austin. You're going to vote, right?
I will say,
It's either that or, which I guess would be 25 or
let's
whatever.
say,
but
I don't
law
care to have a minimum age, so.
school. Okay.
No.
Noes win.
So the noes win, so we'll strike the minimum age.
All right, so I'll just word it to be consistent with all the other branches that they have to be of voting age. You have to be 18 to run for office, but otherwise, there's no other minimum age.
Okay, so poll number 2, requiring that everyone that sit on our legal benches be Sioux Tribe members. Yes would be signify that you want them to all be Sioux Tribe members. No would give flexibility on that. Any questions? Okay, so yes, you want them to be Sioux Tribe only. No is flexibility on that.
And right now, just to confirm, it's a no on there right now, correct?
So,
Yeah, I think that it wasn't just Sioux Tribe members, it was tribal versus non-member.
Well, that's what I
wasn't it?
asked them about.
Yeah. I guess I want
In the original
clarification.
I guess I need clarification on what, so there's a lot of discussion about only being Sioux Tribe. Can you be Sioux Tribe and Native? Can you be Sioux Tribe, Native, and maybe non-tribal? So right now, I think I'm understanding the poll is, so the preference is to be members of the tribe and licensed attorneys, but if, of the Sioux Tribe. If Sioux Tribe member doesn't run, then we do the appointment process, and the poll is it for only tribal attorneys, or is it for any attorney? So I think I misspoke earlier, Austin, I'm sorry. So the poll is for the appointment process. Do you have to be Native American? Yes, and then no is, any attorney can be appointed.
Okay, so do you want, so is it your recommendation that I do a poll for Native American rather than Sioux Tribe?
Yeah.
Is that what your preference is for this poll?
Yes.
Aaron?
The only problem I have with that is if the argument is that they have to be Sioux Tribe in order to rule on issues that affect Sioux Tribe constitutional rights, being an Indian doesn't make you qualified to do that. I mean, you could be a tribe that has no respect for culture or history, that's consistent with our culture and history. So it seems to me if we have this pristine sort of, I don't know the right word for it, so it doesn't sound too offensive, that only a Sioux Tribe member should be able to rule on Sioux Tribe issues, then we should be polling on Sioux Tribe or not.
Well, how about this? How about the first poll be Sioux Tribe or not?
Yeah.
And if that fails, then we'll do another poll for Native American. That way it gives us flexibility on that. Does that work, guys? Kim?
I just have a quick question. The original document stated what?
The original
What was
document.
the will at that time?
All this. So we're just talking about the trial court right now. I don't want to get us confused with the Supreme Court. So just, A is just the trial court. An attorney, all associate judges and the chief judge shall be members of the tribe, at least 35 years of age, an attorney, and residing in any voting district. So the 2008 draft was just Sioux Tribe.
In the 2012 draft, is it that was the same in that
Yeah,
one?
2012 reconfirmation was the same.
Okay.
So it's
Aaron.
just
The
Sioux
part that people seem to be taking issue with is appointing a non-tribal person if a tribal person doesn't run. So I think we are going to get tribal people that are going to run, because when you stepped out, when we conducted general counsel searches, a lot of Sioux Tribe members that have 15 years of experience that are from St. Ignace, one from St. Ignace, several from the Sioux, said, I don't want to work if I can get fired by the tribal board of directors. Under a new structure, you cannot. They don't have to be worried about arbitrary and capricious terminations, because the only way they can be removed is for cause, judicial misconduct. So I do think we will have a lot of tribal people that will apply, but somehow they got convoluted with the concern that we might be appointing non-tribal people to the court. And I don't think that's a good, well, I won't say it that way. So I'm willing to vote on the way you said. First of all, not vote, but poll on Sioux Tribe or not, and then open it up for other Native. And I'm willing to concede that it has to be tribal, because I do believe Larry made a good point. I don't know if he did it, why he did it that way, but he did make a good point, that there are going to be tribal members that are going to be eligible, that are going to want to serve their tribal nation. So I don't think we will have a shortage of Sioux Tribe members wanting to serve.
Kim?
And I guess we didn't get far enough in the document yet to, it's not necessarily not appointing to make sure that we have ourselves covered, but the provisions of that appointment, right? To make sure that if it isn't working out, and we've seen that unfortunately, right? That it isn't always something that's going to take somebody's bar license away, but we've seen where we've not always had the best interest, or that it was working out in the best interest of the people. So that was my concern, is to make sure that there's provisions to protect us, not us, but us as a whole body of tribal members, that we don't put somebody in a box and have to hold them there if it's not working out. So, and I guess you can comment on that, so.
Sorry, we have this fleshed out further based on the Constitutional Committee's draft. We have a recall resignation section that is designed to cover that. It's a little more stringent than the board can just remove you, but there are ways that if, and we'll make sure that it covers appointed positions, that if you have misconduct or there's a legal reason where you should no longer be on that bench, there are recourses, both from the tribal members can do a recall election, or the legislature can maybe remove. That's all. We have that fleshed out a little more further down, and it's designed, Kim, to cover your. I don't know if the language has to be tweaked, but the intent is to cover what your concern is. Yes.
Okay, Isaac, then Tyler.
Hey, shouldn't our main concern be that the court's functionable?
That's what I said
From
about
the very
40
start.
minutes ago.
So
yeah.
what happens if you don't get a Sioux tribe member or another tribal member apply? And you lose one of your judges. So what do you do? How can you function?
If the qualifications are, you have to be an attorney, you have to be Sioux tribe. That's your qualifications. And you hit a point as a tribe where we don't have anyone that fits that box. You don't have the ability to go outside that box right now. If that's where we end up, to appoint someone
That sounds
who's.
like where we're going, but shouldn't our main concern be that the court's functionable?
I
Or
agree.
else
That
there's,
is
or
why.
else you won't have a 3-branch, right? You'll only have a 2-branch, but with no recourse for members.
That is why I think having an appointment process, which we did agree in principle last workshop.
But again, you're narrowing the category
process.
for who can be appointed. So if you don't have those people to choose from, then the court's going to be stalled. They can't function.
Yeah, and if you want my opinion, whether you want it or not, I guess I'll say it. I think if you have it where it's all natives, so even if you're not Sioux tribe, if I can appoint another Native American, that's a fair compromise, in my opinion.
And the last thing I got to say is we hire outside non-native attorneys to do a lot of stuff for us with treaty rights and everything. So so I mean, what are we saying here? We shouldn't hire them now because this is just, to me, it's simple, right? It's got to be functional. And there's a lot of educated people that are non-native out there, and we use them all the time.
All right, guys, so we have a big speaking list again. It's Tyler, Aaron, Kim, then Rob.
I just want to make sure that we're clear. So that was identified in the last workshop we're on, is the reason for the reservists, because we can have reservists. That was why we agreed to reduce it down to 3. So having a good reserve pool would be beneficial for this discussion. And then also we highlighted in the last meeting, and I thought you highlighted it, Ryan, because I brought it up, was that we have a removal process for elected positions, but not for appointed positions. So,
Yeah, correct. That's why I told Kim, we got to tweak that section. But yeah, you
Right.
flagged that, and we need to clean that up so it covers appointed positions, because that's the
okay,
intent.
yeah, I just want to make sure, because that was captured last meeting, and I don't want to go backwards. I just want to keep moving forward so we can get through this. So the reserve cut judges, that was covered too, correct? Like, we covered that, and that's why we agreed to go from 5 to 3 on the Supreme.
Correct. We covered that, but we didn't have time, and we're now on it today. We didn't get to the actual qualifications of who could run, who could be appointed. Just the majority agreed that we'd have an appointment process. We could have those reserved judges, but now
Right.
we have to figure out who's qualified to be in that bucket, right? So.
Right. So I don't think a non-functioning court is, even going to happen when you have a reserve pool, because our appellate, as it exists now, has quite a few qualified people on it. So I want to throw that out there as my assumption is some of those people may actually run for the Supreme Court, but that's just an assumption.
Okay, Aaron.
So, all right, I don't know if maybe some are not comprehensively looking at what we're talking about, because it sounds like now we're backtracking. What I would support, and maybe we should propose, or poll on, is, which I think where we got to, which is, judges need to be tribal members, Sioux Tribe members, elected, and the provision for appointment, if someone doesn't emerge, the appointment process is the OGIMA makes a recommendation, the legislature ratifies. That's a perfect and complete balance of power, because the OGIMA doesn't have the full right and the legislature doesn't have the full right. They got to come together in order for it to happen. And what wasn't being proposed is that non-tribal people be able to be elected. Nobody's ever talked about that, but we jumped on this morning as if we were talking about electing non-tribal people to serve on the tribal court. So I think the poll should be that they be tribal members to be elected, but that reservist judges have preference if they're Sioux Tribe members, but that they can be appointed for like a one-year term until another election is scheduled or something. The other thing is that I think it's an
Aaron,
easy
can I
enough.
pause that for a second?
Yeah.
Just so everyone understands. What you're proposing is a poll that states that all judges are elected. You have to be a Sioux Tribe citizen. In the rare event that we don't have enough Sioux Tribe citizens running for those seats, you have an appointment process to where the OGIMA proposes a candidate. It has to be a Native American, so you'd have flexibility within Sioux Tribe or a member of a different tribe. And then just like the Supreme Court in the United States, the legislative branch, which the board of directors would become, would have to ratify it. You guys would have to be in support of it.
I would settle on that, except Isaac made a really good argument that there are people out there that might be willing to serve, and our chief judge right now is not tribal. The attorney who got we won our lawsuit for not having sanitation in Sault Ste. Marie and won a $7 million judgment, was non-tribal.
Well, it seems like that's what we're debating right now. We know that there has to be an appointment process to make the court functioning if you don't have enough people to run in the election. The question is, who can be appointed? Is it just Sioux Tribe people, Native Americans of any tribe, or do we give flexibility for non-tribal members to be in there?
So
Like, we can
maybe-
cut to the chase and have polls on
maybe
that
we
right
have
now
a-
and just skip the speaking list.
Maybe we have a sequential process where the attempts to recommend for appointment from the OGIMA to the legislature be tribal, Sioux Tribe, other Native, and then non-Native if we don't get anywhere. If you keep making, or if it's you, if you keep making recommendations, the legislature keeps saying no, 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 then we should be able to make an appointment till we find somebody and not rule anybody out, because that could lock down our system. So, and I hope that's not by design, because then there's no way to challenge your constitutional rights, because we don't have a functioning court.
Okay, so we have to move forward, so we have a couple names on the speaking list. I ask that you guys keep your hands down. We've exhausted this conversation. Let's give some direction and figure out where we're at with this after that. Is everyone in agreement? Okay, so Kim, then Rob.
So functioning versus law-abiding, I think, is two different things. And we've watched, I guess, that fall apart. And so whether that's tribal, non-tribal, because those are two different things. You can be law-abiding and functioning, and people can still lose their kids because of somebody who may or may not, I guess, have a thought process one way or another. So do we hope that Sioux Tribe members would be looking out for the best interest of people? Sure, we do. But functioning versus law-abiding, and you're right, the people will elect that. But how many lives could possibly be ruined if we're not careful?
Rob?
I'm okay with the way the poll's going here. I just wanted to do, I don't know if it would be probably not a point of inquiry, but since we're talking about the appointment process, I think Tyler mentioned it, that there needs to be also a removal process if there's an appointment. And I think that that's needed. I think that we need to have that discussion. I don't know if it's later on. But my other thing here, Ryan, was that, where was it? I just had a note here. So let's say that we don't have a judge who runs, a Sioux Tribe member who runs for office. I think we could assume that it might be a little difficult to find one to appoint then. Because if any one of them had run, they would have run unopposed. So at that point, we have to assume that we're having a little bit of difficulty finding a Sioux Tribe judge. So I think that we do have to regress in our preference during the appointment process, whereas the electoral would be Sioux Tribe only, a Sioux Tribe law degree holding member. That is what should be the election process, and that those should be the only people who could run for election. But we do have to regress when we're talking about appointment process, because the whole reason for the appointment is that a Sioux Tribe qualified candidate didn't run for office. Now, it very well could be they just didn't want to do it because of politics, or they didn't want to run an election. But if an appointment is available, they'll take it. I don't think that's really fair. I don't think you should hold out thinking, well, if no one runs, then I could be appointed. So I think that the intent of an appointment process is the idea that we are having difficulty finding a Sioux Tribe member to fill that position. We know that because no one qualified that's a Sioux Tribe member decided to run. So we do got to regress there. I do think that, and Ryan, correct me if I'm wrong, I do think what we could do here is create or establish within the Constitution that it's up to the legislative body to codify how the Ogama selects after that, which you could in turn do a preference, which my opinion is that it should be Sioux Tribe member for electoral. If you have to appoint, then make it tribal preference. And then if there's no tribal members or of any tribe that is applicable or the legislative accepts from the Ogama, then he could then regress again and appoint someone who is non-tribal, but to go through that. Now, my other question, Ryan, would be, let's say someone doesn't want to take an appointment process, and this would probably have to be done through code and legislation, but if we could leave room for it within the Constitution, I think it would help us. Let's say we can't find a Sioux Tribe member or a tribal member who wants to fill the remainder of that appointment, but they're willing to work on a case-by-case basis. Would we be able to leave room within the Constitution to legislate within code that we could hire a tribal judge for a shorter term, let's say 3 months, or even a case-by-case basis if they're not willing to accept an appointment? Or does the rest of the board, and Ryan, maybe you have a good reason for this, that we need to stick to the terms versus a contractual thing where we could bring someone in and say, we need a another qualified judge to sit on this case. Would we be able to do that, or is it just best practice to leave the terms there and find someone who's willing to accept the term?
Okay.
That's a lot to unpack.
That's a bunch of questions. You have to probably refresh my memory on a couple of them, Rob. So there is going to be a removal, recall, resignation, vacancy section way further down in our contract. We're not going to get it today, maybe not even tomorrow. Maybe it's on the January 5th one. But we do have it, and we'll make sure it's working properly. So that is part of this constitution draft. It's a section we think needs to be changed from our current language, and we have suggestions for that. So that's coming at some point in our workshops. I forget your second question.
He asked whether we should punt to the legislature to make the law for appointments.
Gotcha. Yes, so you could leave this more open-ended here and just say, except where no qualified tribal member seeks such office, an attorney in good standing may be appointed, and then legislate how you want to do that. Leave it a little more open in the Constitution, and then flesh out the process in legislation. That would be best practice. That would be allowable. That would be preferred, that we don't try to flesh out all the preference in the Constitution. The third question about whether we would leave it open-ended to have some kind of like contract, like a short-term contract. I think it's probably, in my opinion, best practice to like stick to the terms of those. If it's 6 years, stick to those 6-year terms and appoint someone. Find someone who is going to be willing to be appointed for those term, whatever remaining on the term. If it's a recall or whether it's the full 6. And with the understanding that they are subject to removal based on the Constitution language that we'll get to later. But I think if you left this section A, this last sentence, a little more open, that just says an attorney in good standing may be appointed, I think you could probably legislate temporary appointments and still be in line with your Constitution in the event we need just someone for 3 months, and then but that would not be ideal, nor would I say that's best practice. But I think if you left this section more open-ended, like I just suggested, the legislature would have that ability. Does that answer all the questions?
Yeah, you hit them all, and I appreciate that, because I think that maybe we need, when we're polling, maybe some of these we need to add in leave to legislation, because this is one where I think as long as the electoral process is for Sioux tribe members only, when we get to the appointment process, we absolutely have to regress, because, like I said, the whole purpose of that is that a Sioux tribe member did not submit a letter of intent to run for office. So we do have to regress in who we're selecting from. That's the whole purpose of the appointment process. But I think if we leave it open to legislation, it leaves room for us to correct things. There seems to be a lot of worry on the board that what we decide right now might not work. And I think that that's the best way to address something that we fear might not work, is to leave room for us to make adjustments for it to work within legislation. And considering the appointment process is not going to deteriorate any of the separation or checks and balances, I think maybe this is a spot where we say, yes, let's leave this open to legislation. The Constitution's not made to draw out every detail of law. It's made to ensure that members have fundamental rights. And I think that this might be a spot where we could say, let's leave to legislation and move on.
Okay.
I don't know what else thinks, but it seems to be the simplest and most logical thing here.
All right, Kim Gravel promised me she has something very brief to say, and then we'll poll, guys.
When we refer to another tribe, should we say another federally recognized tribe based on our
I think that would be
conversation this
assumed.
morning?
Yeah.
I actually have a note. I have a note up top. I think we kind of touched on it last time. For a global change, I didn't make any global changes yet for the language, but that's one that I think I have flagged as a global change. Citizen and federally recognized tribe. There were a couple others. But yeah, we can make that change. Once we get the substance down, we can make those little tweaks like that throughout the document, yeah.
All right, so I'm going to recap. So when we have elections for appellate and Supreme Court judges, it's going to be Sioux Tribe members. I mean, this is our government. But we have to figure out a mechanism if we don't have enough people run. We have to have a functioning court, so we have to have bodies on that bench. So there has to be an appointment process. So right now, the appointment process is the OGMA nominates someone, the legislature confirms, similar to how the president nominates someone to the Supreme Court of the United States, and then Congress confirms that through a confirmation process.
Mr. Chair, as a clarification, I think.
So the
attorney
clarification is-
clarified that was not in the draft, but that's something the board talked about.
We will get to that. Yep.
Subsequently.
Yep, it has to be like
It
that.
is in the draft, Aaron.
The original draft?
Oh, not the original, like 2008? No, but it's in what we workshop, it's in this draft, and we workshopped it
So
3 weeks
what we need to poll on is who is eligible for a nomination, whether it's a Sioux Tribe member, whether or not it's a member of a federally recognized tribe, or whether or not the OGMA has the flexibility to nominate anyone. And then if your political leanings are someone on our court should be a Sioux Tribe member, you would have the flexibility just to vote no on anyone, as long as they weren't a Sioux Tribe member. So are you guys comfortable with me doing this all in one poll to where you say Sioux Tribe, Native American, anyone? Or we can split it up individually, but for time's sake, I think that would be the most effective way to go about it.
Which native will mean federally?
Can we have an
Exactly.
option to leave the legislation like Ryan suggested too?
Could you repeat that, Rob?
Can we have an option to leave the legislation and have that be open as Ryan suggested? With the wording that he suggested? I forget what it was, but it was.
So the third option that Austin just said, like anyone, that would be the open-ended option, and then you legislate how you determine, how you select the anyone, the any attorney.
You guys would
that
have the
third option.
flexibility to do that as members of the legislature. Aaron?
Yeah,
Okay, thanks.
the problem I have with that is then that requires that we trust that the legislature will make the right decision. And right now, we know that we're having difficulty over 20 years with divesting that power and authority. So what happens when the legislature just chooses not to legislate how to make that appointment? So I would suggest that we do, as you just suggested, that we do the Sioux Tribe, Native, other, and the legislature has full authority to reject anybody you nominate. So, so the legislature, I think one of the big misnomers is that somehow the legislature is not going to have a role and responsibility and have no power, but the legislature will remain the preeminent authority under the tribe in the new structure because they legislate. So I don't support what Rob's suggesting, that we leave it up to the legislature to decide. I think we need to have it in the Constitution, because otherwise the legislature can just choose not to articulate it, and what do we do about it then? You don't have any way to challenge it. That's why it's got to be in the Constitution, so that we can challenge if the legislature doesn't do their job.
Okay. Rob, do you have something to respond to that? Your hand's still up?
Yeah, I'm not suggesting we take it out of the Constitution. I think it is a Constitution. And if you put it in the Constitution, then the legislator has to legislate a process for it.
Sounds like we're on the same page then, right? All right, so the poll will be for the nomination process to our court, Sioux Tribe member, Native American of a federally recognized tribe, or anyone. And then you guys would decide, okay? Yep, I nominate who's ever in that role. I'm not going to be here forever. So, I mean, this is going to last throughout the tribe's history. So does anyone have any questions about that?
This is consistent with what the committee had drafted originally, but they didn't include it, and then we added it later. So if we're trying to be pristine to what they recommended, this is along the lines of what they wanted.
And if you guys want my recommendation, it would be Native American of a federally recognized tribe or anyone. Probably leaning towards anyone, because at the end of the day, you guys would have the flexibility of striking people down. It would give more flexibility. We don't have a large legal community up here. So that's what my recommendation would be. So Sioux Tribe, Native American of a federally recognized tribe, or anyone. Okay, roll call, please.
Rob?
Anyone.
Kimberly Lee? Aaron?
Consistent with what you proposed.
Anyone?
Isaac?
3.
Anyone.
Kim Gravel?
What do you mean by 3?
Anyone?
He's being clever.
Okay,
Trying to trick me.
anyone.
Anyone? Yeah. Kimberly Hampton?
Skipper.
He's not on.
Oh, yeah.
He's
Mike,
going to be gone for the rest of the day.
Anyone?
Sean, Lana,
I'm confused, but no change at the very, which one's that? One? One.
No, I mean, it's the same as what he proposed, because that's what the committee.
Anyone.
So, no change from what I suggested would be anyone. It would be the third option.
Third option. Yep.
Tyler,
Native.
Larry,
Native.
Bridget,
Native American.
Pardon me, so the third option is native, right?
the third option is everyone.
Be anybody. And then you would have the
Okay,
flexibility.
just for legal, my option is no change, so however that's figured out.
No change from the constitutional committee.
Right.
That would be Sioux Tribe only. That'd be one.
Okay,
That would be
one.
Okay.
Bridget,
Yeah. I said Native American.
Native, okay, thank
me
you.
too.
Yep, it's still the,
Okay, so the will of the board is anyone, and again, you guys would have the flexibility of striking down a nomination if they're non-tribal, if it's just your philosophy that they have to be native to sit on our bench.
Point of information.
Yes.
So one was no change from the committee.
No, 1 was Sioux Tribe, 2 was Native American, 3 was anyone.
Thank you.
Okay. Aaron?
Oh, wait, point of information here, you guys, so we can't say that, so just so Lana's clear here, we can't say that there was an option for no change to the committee, because in the original draft, there was no appointment process, and that's what we're deciding right now. So there's no option available on this one specifically. That would be no change from the committee. We have to adopt a process for appointment. Appointment wasn't in the original draft at all. So none of those
Said
three.
Sioux Tribe only.
Right, that's correct. The appointment process was not in the original draft. The original draft just said you had, like, it has to be a tribal member for all the judge positions. But there was no fleshed out appointment process. Everyone ran for election. Everyone had to be Sioux Tribe enrolled. Everyone had to be 35. Everyone had to be an attorney, if I am understanding this language. It's kind of worded weird, but I think that's what it
Bill
looks like.
7-4.
Okay, Aaron?
So I just want to put, before we go to lunch, I want to put an end to this notion that we have non-attorneys on the court. Only one board member seems to support that. Nobody else has supported it as well and lined up behind it. If we end up in that structure, I will run for the Supreme Court. So think about your position. I will run for the Supreme Court, and I will win.
Isaac, did you have anything to say? Oh, I thought I saw your hand up. All right, guys, it is 12:07, so I've dipped into your lunch break. I want everyone back, so let's have a slightly extended lunch break, maybe 1:30, that way everyone's here. Larry?
Can we go into closed real quick?
Yeah. Let's go and close real quick. It is 1:30 sharp, so as promised, we're going to go ahead and begin. Ryan, let's pick up where we left off, please.
All right, we're on section 4, qualifications, subsection B. This is associate justices of the Supreme Court. I made a couple tweaks and red lines based on our conversation this morning about A. So now reads, associate justices of the Supreme Court shall be of voting age. At least one of the associate justices shall be a member of the tribe. All associate justices shall be Native American, and at least one associate justice shall be an attorney. Where no qualified tribal members seek office, an attorney in good standing may be appointed to be an associate justice to fill any vacancies. I put down below, just so we can see the 2008 draft language, that we're trying to incorporate some of the intent. They had at least 2 other justices shall be members of the tribe, meaning Sioux tribe. All justices shall be of voting age and Native American. At least one associate justice shall be an attorney. So this, as written right now, it does leave room for a non-attorney to be on the Supreme Court. I know we had a robust discussion this morning about that.
So Ryan, non-tribal members wouldn't be eligible to run for office. This would just be through an appointment process if we didn't have any tribal members to go through, right?
Correct. It'd be the same as we talked this morning. If you are in the any attorney category and you're non-tribal, it's only if we have to appoint because no Sioux tribe member ran for office.
World ran out of Sioux tribe members. If they ran out of other qualified attorneys who wanted to fill that appointment, who are Native Americans, part of federally recognized tribes, it's a last case situation.
Correct.
Okay.
So I guess I don't want to presume, but I think everyone's okay with changing the 35 years to be a voting age. But I think the big question that I need direction on is, are all of our Supreme Court justices going to be required to be attorneys?
Okay.
It seems to be mixed
Yep,
feelings.
let's start this discussion. We can start with Aaron.
So I think they should be, because the purpose of either an appellate court or a Supreme Court is to rule on issues of law. And so the Supreme Court especially has the opportunity to overturn decisions of the legislature, and the only time they should be able to do that is if there's issues or violations of their constitutional rights. So, so a layperson doesn't have those. I don't know. Somebody's got their doesn't have that background. And just as we learned with the okay, thank you. Just as we learned with the appellate court in the past, when we established the appellate court, we then had to pay extra money to train the appellate judges to understand what their job was and how to do their job and rule on issues of law. And that became an apparent, obvious mistake, the way that we structured the appellate court by not having all attorneys. So, and for tribal members that are listening to this, if your rights are violated and you want your rights to be upheld, you want standing in tribal court, and you want to be able to take whoever violated your rights, whether it's the executive branch or the legislative branch, and challenge them in court on issues of law. So other opinions, their interpretation of culture or anything else is irrelevant. It's really should be issues of law, and especially, again, at the Supreme Court level, because if the Supreme Court overturns a decision, it's like the legislative decision, like say they wrote a law that violated your rights, they're going to provide a provision for the legislature to fix their mistake by legislating a law that doesn't violate your rights. So to me, as a tribal citizen, I want somebody to be qualified to make that decision, not a layperson who is not a trained attorney to make that decision. And also, before we get back into it, because it was intimated earlier that somehow an attorney is not going to be culturally attuned, I find that horribly offensive, because we do have tribal members that have been raised traditionally and have that background, and just to say because they're educated or because they have a law degree that somehow they're not qualified to weigh in on tribal issues, I think is patently offensive. So I know a lot of tribal members that are attorneys that do follow our traditional ways, and they're no less than anybody else that I know that follows their traditional ways.
Mike?
I think that we've already stipulated that the chief judge is going to be an attorney. This is also saying that at least one of the associate judges is going to be an attorney, so it leaves room for a lay judge. So I think that we're talking about the ability to be able to conduct our own. I think this falls in suit with that, is that 2 of the 3 are going to be attorneys, and if we can't get a third attorney, then this leaves the door open for somebody to be appointed that is willing to step up. So I think that we have done it in the appeal process. I don't think that was a mistake. I think it's worked. So do they get all the decisions right? No. Do I think that our court will get all the decisions right with judges, with attorneys? No. So I'm okay with this provision because it does stipulate that at least one is, and we are already established that the chief judge will be, so I'm okay with that stipulation as is.
I have a quick question. If there's an election, and if you don't have, well, how would you have an election where you'd have someone who's an attorney, though? You know, if you have a pool of people running for that office, and let's say there's one attorney, and that one attorney loses, and you don't have any other attorneys on the bench. Let's say the one attorney's there, it's like, I'm not rerunning. Do you just say the person that lost, who's an attorney, beats the lay judge because there's a requirement that at least one person sitting on there would be a judge? And anyone can respond. I'm just being honest about it and thinking about that scenario.
Yeah, so I scrolled back up to section 2. We did this section last workshop, and the language as it stands right now, the associate justices, which is what we're talking about right now, they are all appointed by the OGMA and confirmed by tribal council, legislature. So the associate justices don't, if this language stands when we vote to
That
go
would be
BIA,
easy.
they
Just
don't,
make
they
sure
don't,
there's
yeah,
one-
they don't
One
run.
nominations has a law degree.
Yeah, so they don't run for elections, so it'd be up to the OGMA and the tribal council, when they confirm it, to make sure they're populating pursuant to the Constitution with at least, as it stands now, at least one of the associate justices being a Sioux tribe member, and at least one of them being an attorney. It doesn't have to be the same.
That answers my question then. Yep. Aaron?
So I'm gonna have to use an example because I want members to understand what we're about to do. So you have 3 judges at the Supreme Court level, if that's where we end up. And you have a Supreme Court justice, and you have 2 associate judges. And if one of them's not an attorney, the other 2 are, just very simply, and they're discussing at the Supreme Court level, their determinations are issues of law, right? So when they're debating and deliberating on whether or not somebody's rights were violated, the 2 attorneys have an advantage because they understand the law. The person who is not an attorney is at a severe disadvantage because unless, and this is what we did in the appellate court, is we had to hire a separate attorney to train the non-legally trained judges to tell them what the law was. So what we were doing basically is who was training the non-attorney appellate judges really was the one making the decision because the non-attorney appellate judge had no clue about what the law was. So it doesn't make sense to me. It doesn't even pass a basic logic test. Again, if the Supreme Court's task is to rule on issues of constitutional law, then you need somebody who is trained in the law to make that interpretation. And very simply, the 2 attorneys are trained, the non-attorney is not, and the 2 attorneys can run roughshod over the non-attorney. They can give their opinion all they want, they can protest, vote no on everything, but how does that serve the interest of the people? What we want is if you have a case, a tribal member has a case, they bring it to the Supreme Court and they want a determination and a ruling on an issue of law, You want somebody who's legally trained to make that determination, not somebody who's not qualified. And again, for the argument that, well, the two attorneys have to be assimilated, they have to be white thinking and Western civilization, or whatever, would prompt you to suggest that tribal member attorneys can't possibly understand our culture, then I just think that's patently offensive. I think that, I think if there's an evaluation or test that they weigh while they're making that determination, kind of like what the court currently does, but ultimately the appellate courts and then the Supreme Court's job is to rule on issues of law. And you want somebody qualified. Just like if you were going to have surgery and you want a doctor that's trained in medical science, you don't want a layperson to give you an opinion about culture or whatever the argument is. You want somebody who's qualified to make that determination. So I don't see why we're even considering non-qualified people to sit on the court.
Okay, Ryan, so I don't see any more hands up, so it looks like we can provide you with direction through a poll. So how would you suggest I frame the poll? Just to give you the concise direction that you need on this issue.
The first option would be to have everyone be an attorney. And the second option would be allow one seat to be a lay, like a non-attorney tribal member. So either all attorneys or room for one non-attorney.
Okay. Is everyone clear on the options? So option 1 is everyone has to be an attorney. Option 2 is we're leaving room for one lay person to sit on the bench. Okay, so when Ashley does roll call, just say 1 or 2. Okay, roll call, please.
Rob? Yeah, he's on. Rob? Kimberly Lee?
Attorneys.
All.
Voted 1.
Yep. All, yep. Aaron?
1.
Attorney, 1.
1.
Isaac? 1. Kimberly Gravel? 2. Michael?
2.
Sean? 1. Tyler?
2.
Larry?
2.
Bridget?
2.
Austin?
1. 1.
And Lana's out of the room.
Okay, so that would be option 2. So leave room for one person to be a lay individual on the bench.
Right. All right, so I think as written then captures that direction, so I think we should be good. We use the same language as above for when, if no one fits all the buckets, then you can just appoint any attorney to sit there. If you can't find a Sioux Tribe member, you can't find another Native American, can't find a lay person, Sioux Tribe justice, then at the end of the day, you can still appoint that. The appointment would be an attorney, but any attorney pursuant to whatever legislative preference might be enacted at some point in the future. All right. C, no person shall be eligible to serve as judge or justice who has ever been convicted of a felony in any jurisdiction. This is from the 2008 draft. We've workshopped this before under prior legal counsel, and I think it's a good idea for the justices to not have felonies.
I would agree. Does anyone disagree? We can poll if otherwise. Okay, it seems like there's a consensus in that area then, Ryan.
All right. D, some like prohibition kind of things. A judge or justice shall not, little I, serve in any capacity in the executive branch or the legislative branch. Makes sense. They can't be in one of our other branches if we're having a separation. Little double I.
Point of
Oops,
inquiry.
sorry.
Go ahead, Aaron.
Lana was out of the room when we polled on whether you had to be an attorney to be on the Supreme Court or non-attorney. Can we get her position on it?
We moved on from there.
Pardon me?
Could you state what you prefer, though? Do you want anyone to be on the Supreme Court that's a lay individual, or do you prefer that everyone be law school educated?
In the original 2008 draft, it left room for one of them to be a lay tribal member, a non-attorney tribal member.
So that would be a 2, which doesn't change the outcome of the poll.
Yeah,
Okay, so that would, the 2 is the original intent. Okay, 2.
correct. Okay. Awesome. All right, little double I. I added, so the draft you have in front of you says, serve in any capacity for any tribe, state, or United States of America, excluding appointments to committees formed for the public good. The 2008 draft was a judge or justice cannot be elected or appointed official of any other government. So I added in the words elected or appointed. So it says, serve in any elected or appointed capacity for any tribe, state, or the United States, excluding appointments for committees formed for the public good.
Does anyone disagree with that? Okay, it seems like there's a consensus that the language should remain the same.
Right, and then little triple I, accept any position or appointment that would create a conflict of interest. Seems to make sense to me.
So Kim raised the question, who would determine what that would be? Would it be the Election Commission?
To be determined. That would be like a legislative type thing, where we flesh that out. The rules of the court would probably come into play as the separate court gets up and running. They will probably adopt codes of ethics and stuff, right? The legislature can also legislate certain parameters defining what they would see as a conflict of interest. Yeah.
Okay, Mike.
Would that apply to then also for the public good comment, the section right above that? Because
I think it would have to. I'm not sure what so that was language that appeared in one of the amendments, I think, that Director McGrory introduced, and it was several of different iterations, including one of Schlehuber's. I'm not sure what exactly the public good means, but we'd have to define that through legislation.
Okay,
Yeah.
thank you.
Or if we don't, the courts will they will determine for us what the public good is, right? So. All right, section 5, jurisdiction of the courts. A, the trial court shall have original jurisdiction over all cases and controversies, both criminal and civil, in law or in equity, arising under the Constitution, treaties, laws, and customs of the tribe, including cases in which the tribe or its officials and employees shall be a party. Any such case or controversy arising within the jurisdiction of the tribe shall be filed and exhausted in the judicial branch before it is filed in any other court or in any other jurisdiction. This grant of jurisdiction shall not be construed to be a waiver of the sovereign immunity of the tribe. It's very similar to what was in 2008. It's very similar to what other constitutions have, other tribal constitutions. It's almost a generic statement of jurisdiction. I don't have any issues with it. It works as is, I think. So. All right. C, the Supreme Court shall have appellate jurisdiction over any case on appeal from the trial court. Only the Supreme Court shall have original and exclusive jurisdiction over any final determination of an election dispute by the Election Commission or any approved plan to redistrict, or we can take that part out, any approved plan to redistrict or reapportion voting units. Per our conversation in the last workshop, we're not dealing with any of that. That's a future Sioux Tribe issue through legislation or otherwise, so that can be removed. And then has such jurisdiction shall include the power to make findings of facts, conclusions of law, and issue all remedies in law and equity. So Supreme Court has appellate jurisdiction, and then they are the ones that would determine any appeals from the Election Commission. Is basically what that says.
Aaron.
So I have a question. So the current Supreme Court, I don't know if we're in a strange era right now, so I don't know how to say this, is they don't generally, you generally don't have standing to just bring any issue in front of the Supreme Court. They have to be, if you can make an argument that someone's fundamental constitutional rights are violated. So are we saying that any issue can be appealed up to the Supreme Court? Or will it be limited to issues of violations of your constitutional rights or your Bill of Rights? Under normal circumstances, cases aren't supposed to get up to the Supreme Court, but we have seen departure from the norm in the last year. I think I remember them contemplating this, but I think that they couldn't figure it out. I think they were leaning towards the Supreme Court existing to hear issues of violations of the Constitution, or they called it constitutional questions.
Yeah.
So not everything could be appealed up to the Supreme Court.
And that first sentence is the same language that was in the 2008 draft. It would potentially, though, you're right, open the door for, unless legislature clarified it, right, open the door for basically any adverse decision that I got in the trial court, I could appeal it. And if that's the intent, that is allowable, but I don't know if that's.
If it's not limited in the Constitution, the legislature is not going to be able to enact something that's more restrictive than what's in the Constitution. So it's critically important that we get it right in the Constitution. So like, I'll give an example for maybe some who haven't studied the law. I had to study it in 3 different degrees that I had. I had to have an advanced course in 3 different degrees, but generally, if there are different outcomes at the circuit court level across the country, and it's a constitutional question, then that can be heard by the Supreme Court. But not every single thing can be heard by the Supreme Court. You can appeal and submit search. I don't know how to say it.
Certiorari.
Yeah, you can submit that to ask them to interpret it, but then they have to interpret it against the law and against judicial precedents. They can't just make stuff up. That's called judicial activism if they do. So unless we intend for every single issue to make its way up to the Supreme Court, we have to make a determination now of if it's constitutional questions that make it up to the Supreme Court, or if it's every single issue that can make its way up to the Supreme Court.
Okay, anyone else? So do you feel like we need to give direction in this area, Ryan, to give the court the discretion to screen out non-constitutional questions that are appealed for them to hear?
Yeah, I think so.
Okay, so, I mean, pros and cons. One con of allowing every case to be heard is the court's capacity, you know what I mean? And its docket being absolutely filled with things that are frivolous and should just be screened out. So, Ryan, the poll should be, number 1, Supreme Court hears all appeals. Number 2, they have the discretion to screen out non-constitutional matters. Does that sound correct?
Yeah, that'd be fine. That would work.
Okay. Does everyone understand what you're voting on?
All appeals.
Does,
Or
yep, number 1 would be all appeals. Number 2, they would have the discretion to screen out non-constitutional appeals. Ask them. Ryan, there's a question. Number 1 would be no change.
Number 1, yeah, number 1, if we mean no change as in what the 2008 draft language was, yeah, number 1 would be the no change.
Okay, Kim, then Tyler?
I guess who would be going through that to make the discretion? Or do you think that that should go up to the Supreme Court level and them look at it to decide whether or not it's a constitutional right?
Right, so the court, we're not down there yet, but the court has the power to create certain rules.
Okay, well, everybody in the court system also doesn't have a law degree, right? So we need to make sure that we clarify who is screening out what to protect the membership, right? Because some things could be screened out, some things couldn't. Again, we talk about this small world where everybody knows everybody. Things could be moving along just because of who you are. That still doesn't, I guess, allow the people that we're entrusting to make those decisions, to make those decisions.
So Ryan, the question is, who would have the authority to screen out the non-constitute changes? Be Supreme Court?
They'd be the court.
Yep.
That's what that, how'd you say it?
Writ of certiorari.
Right, that's where you submit, you request.
You submit, and then the court decides. So we submitted a writ of certiorari for them to hear a downstate gaming case, and they denied it, you know? That's just the way the process works in the federal government. So Tyler?
Yeah, I just, excuse me. I just wanted to kind of bring to attention the edits that we already made because we added in the Bill of Rights. So there will be additional constitutional things that they can see and hear. So in that case, the employment rights as well is part of the Constitution now. So that will be a constitutional case. So I just wanted to kind of highlight that to everybody, but I'm fine with the language. Excuse me.
Okay, anyone else before we poll? So option 1 is the Supreme Court hears all appeals. Option 2, Supreme Court has the discretion to screen out non-constitutional appeals. Okay? All right, Ashley?
Tyler?
Screen out.
Rob?
Be 2.
Mike?
All appeals.
Kimberly Lee? Isaac? Lana?
No change, number 1.
1.
Larry?
1.
Bridget?
1.
Kimberly Gravel? 1. Aaron? 2. Sean? Austin?
2.
Tie.
Yep.
So 6-6, guys. Yeah, Aaron.
So the lower court hears cases and they make determinations on facts. The appellate court hears challenges to misapplication of the law, and that's the appellate court level. So what we're doing, if we have all cases go to the Supreme Court, then what you have is you have an appeal on the appellate court. Limiting it to constitutional issues is why Supreme Courts exist. Supreme Courts don't hear every case all the way up to the Supreme Court. If you have a case in circuit court and you appeal it up to the appellate court, not all cases go to the Supreme Court. You have to submit a request to the Supreme Court, and they determine on whether or not it's a constitutional issue. Then they make a determination to hear the case or not hear the case. And you're leaving it up to them to make that decision, who are supposed to be the experts. But by supporting all cases can be appealed up to the Supreme Court, you're creating a superfluous and extra step where the appellate court is pretty much useless. You're basically skipping past the appellate court because you're having an appeal on the appellate court doing their duty. So that doesn't make any sense. So those are fundamentals in law. And anyway, so I guess stop there.
Hold on.
We don't have an odd number of people in this room, so there's a possibility that we're going to have tie votes on some of these polls. So without objection, let's skip past this. There might be other ties that we have to address at the end of this. Is that okay with everybody? Okay, we'll circle back on this.
Can I ask one clarifying question for you, Aaron? You keep mentioning the appellate court. Are you envisioning that we have the trial court and appeals court and then the Supreme Court? Because this only has the two court. The appellate court is the Supreme Court in this draft. There's only two courts, the trial court.
This is where they ended up.
Yeah. I'm not contemplating a third court system. So I just wanted to understand what you were saying. I was having trouble following, sorry.
Tyler.
That makes it, well, he
Oh, I'm sorry, I didn't think you were done.
That makes it more complicated because that's a deficient structure, because, again, the Supreme Courts are only supposed to exist to hear issues of constitutional law. And if we're replacing the appellate court with the Supreme Court, then if you don't have, I suppose maybe if there's like a branch, like a decision tree, are they hearing the case because somebody believes the application of law didn't happen properly? Then you do need to have due process and a remedy. And if the Supreme Court's the only thing we're proposing, then we're stuck with that. But then the Supreme Court should also separately hear issues of violations of the Constitution. So if all we're doing is proposing one level above the lower court, then it might be essential to have them hear the case. Because otherwise, if you don't like the outcome of a lower court case, you don't have an appeal.
Well, I guess, so let me say this, Austin, I'm sorry. I know you want to move on. So the way this is worded right now, the Supreme Court shall have jurisdiction, but it doesn't say that they shall always exercise their jurisdiction. So they can create appellate rules, or the legislature can create law that more further defines how the Supreme Court can exercise their jurisdiction. Just because they have jurisdiction over something doesn't mandate, a court can have jurisdiction but not take a case, I think is what you're kind of getting at, right? So even the way this is written now, I think leaves that open where they have the jurisdiction, but they can adopt appellate rules to clarify how appellants get up in front of them with they can have their own version of the writ of certiorari, right? As it's written now. Just, we can put a pin in it still, but and further flesh it out, but.
Probably going to be a handful of things we have to circle back on. Tyler?
So two things, I would just like to, maybe, I don't think we have to circle back. I think we can just, have this discussion about how it should be, because with Ryan's explanation there, I would be willing to switch my vote to 1 because it still allows them the opportunity to make their own policies and processes. The other thing is, if you guys could please speak into the mic when you're placing your poll votes so we know what's going on, both for myself and probably the membership that's listening.
Okay. Yeah, we'll work on that, Tyler. You want to move on to the next portion of this, Ryan?
All right. Section 6, powers and duties of the court. This little a here is pulled from the 2008 draft. The primary duty of the judicial branch shall be to promote community and individual healing and forgiveness in all matters which come before the courts in accordance with the laws, customs, and traditions of the tribe. I presume this is meant that we don't want to be a punitive first tribe. We want to be a more healing, culturally sensitive tribe first. I don't have any profound thoughts on this. This is just direct language from 2008. If there's no, we'll leave it in unless someone says something. Little b, the jurisdiction and judicial powers of the court shall extend to all cases and matters of law and equity arising under the tribal constitution or under laws and ordinances applicable to the tribe. Such power shall include, but are not limited to, the trial court adjudicate all civil and criminal matters arising under the jurisdiction of the tribe in accordance with the applicable tribal and federal law, to review ordinances, resolutions, and executive actions arising under its jurisdiction, to ensure that they're consistent with the Constitution, and the power to declare ordinances, resolutions, and executive actions of the tribe void if they are deemed inconsistent with this Constitution. And I'll pause for a second there. So when a lawsuit is brought forward against the legislative or the executive branch, this explicitly gives the trial court the power to rule on that, and if they deem it inconsistent with the Constitution, to make that ruling. C, the chief judge of the trial court shall have the authority to create and present an annual budget request to the legislative branch. So the chief judge of the trial court creates the budget for the trial court. Subject.
So this would be one of the checks and balances that the legislative branch has over the trial court. They would control the purse strings.
Yeah. Good. 2 here, Supreme Court. A, the Supreme Court shall have the power to interpret the Constitution, laws, and executive actions of the tribe arising under its jurisdiction, and the power to declare such laws and executive actions of the tribe void if such laws are not consistent with this Constitution. B, the Chief Justice of the Supreme Court shall have the ability to create and present an annual budget request to the legislative branch. And C, the Supreme Court shall have the power, here's what we were talking about earlier, to adopt rules and court procedures governing the judicial branch subject to the laws of the tribe. So that's where they could have the power to create those appellate rules if that language above stays substantially similar to how it is now. Any questions on that section?
I don't see any hands.
Right to appeal. Any party to a civil action or a defendant in a criminal action who is dissatisfied with the judgment or verdict of a trial court shall have the right to file an appeal to the Supreme Court. Oh, here we go. I forgot I had this, sorry. The Supreme Court shall have the right to accept or deny any appeal from a trial court.
I think that answers our question then.
It did.
So if we want it to remain original, it would give them the discretion.
Yeah, maybe I should have flipped those sections. All right, we got it.
Yeah, I'd like that strong language as it's written, because then the legislature can't play games and write laws that are limiting your constitutional rights.
So does everyone agree that we don't need to circle back on that previous issue since it's pretty black and white in this? Okay, we can move on then, Ryan.
Sorry, guys, that's my fault. Section 7, compensation. The legislative branch shall have the power, the purse strings here, to establish the level of compensation for each judge or justice, provided that the compensation due to each individual judge or justice shall not be diminished during the term of their appointment. We've had discussions previously in different workshops where we've seen other separated governments in disagreement and the legislature trying to mess with the budget or defund a position.
So for example,
This is to protect that.
If the legislature was upset with a Supreme Court decision, they couldn't reduce the salary of the judges to $0 to prevent that from happening. So even though you'd have that check and balance, it couldn't be used in a retaliatory way.
Good? All right, we got through.
Mike has a question or comment?
I got a quick question on the one before that. I was still
Yeah.
trying to comprehend it. But so I like most of the language in here. The one thing it's saying though is a defendant in a criminal action. So is that saying if the prosecutor couldn't appeal anything then, correct?
That's correct.
Okay. I just
That's
wanna
pretty
make sure.
standard where the prosecution doesn't get to appeal, just the
defendant.
defendant.
Okay,
yeah.
I just want to make sure I was understanding it right.
Yep. All right, we got through judicial branch, all right.
Oh, yay, celebrate.
Ready, legislative branch.
That,
I don't know. That's typo there. Okay, section 1, composition. The tribal council shall be comprised of 12 council members representing the 5 voting units in existence at the time of this constitutional amendment and as enumerated under the tribe's election laws.
Oh, I know that the committee wanted an even number, so did we change that, or how did we end up with an even number? Because the committee
Well-
wrestled with that.
This is where we talked about last workshop briefly, and I need direction here. So the 2008 draft, right, had all that redistricting language. There was 3 at-large units created. We're not going down that path right now, as I understand the majority. There's been discussion on adding, both here at this table currently and years previously, about adding like a 13th council member, and that would be another seat in Unit 5. Last workshop, we discussed just putting a pin in this until today, leaving it at 12, and then I wouldn't generally advise it being an even number. There's a speaker of a legislator that we'll get to later. You could take away their vote, so they only vote in a tie. There's multiple ways we can discuss it, but at the first, I wanted to make sure we're all on the same page on how many council members.
okay, Lana?
The 2008 was 13,
It was 15.
15.
There was 12, and then they added 3 at-large units. They divided the lower peninsula into 3 units.
Okay.
Aaron, then Isaac.
Yeah, so I think it was 15, but it was one for the western end, dividing, like drawing a map, a line straight across, splitting Unit 4 and 5, and adding a council member for Unit 5 that would be consistent with some of the other units, because we are totally not in compliance with the Constitution right now with regard to apportionment. Because it says 500 or a fraction thereof on a board member for every 500 people, and we are totally not compliant with that. But it also added an at-large, and it added a Unit 6. So that was 3 total. So that was 12, 13, 14, 15. So I don't like that we aren't following through on the Unit 6 or at-large. However, the polling at this table suggested that we wouldn't even get started if we didn't move off that dime. Those were put aside a long time ago, so I'm okay with that at this point. So then what we're left with is we don't have that added, 8 added or 3 added to make it an uneven number. And so our options are either to add 1, or like you just said, to make the speaker a non-voting member. So that would be the person who presides at the council meetings, legislature, and then only the 11 would be able to vote. And that is an uneven number. Maybe preserving the right to vote in case of a tie, because there could still be a tie, because there could be, 5, would it be 5-5, an abstention, and then the speaker could break the tie. So that would be a solution. I'm not opposed to the idea of an not at large, a added for Unit 5 if we redistrict Unit 4 and 5, but I don't think we have the votes to do that. We don't have the support at the table to do that, so that's superfluous at this point. There's no sense in even talking about it. But you do need an uneven number, and the committee was very adamant that you needed an uneven number. That was a theme that they talked all the way through, and that's why they ended up with 15, so.
Isaac, then Rob.
Yeah, so I have a different thought process. Mine would be 5 and 2, so 5 units, 1 representative for each unit, and 2 at large. And the main purpose is so we can get some stuff done. We sit in these meetings, now I'm going almost on my 4th year, right, just to the finish. And we, a lot of times, don't get anything accomplished because we just can't get along. And the other thing is, just think of the costs we could save. Getting rid of 5 members could almost fund this new constitutional amendment.
Rob.
So I have a little bit of a different view on this portion. And I'm just going to rely on simple logic here. Each of our units vote us in to represent them with a vote at the table. So I don't agree with taking away the vote of the speaker. I don't also think there's any issue with having an even number of legislators, because if there's a tie vote, that means the votes are not there to overturn a veto. So my suggestion would still be to have the chair, the head of the executive branch, determine the tie-break vote. Just because it's ultimately going to be up to the executive anyways if they send it forward. And then it could be reviewed by the judiciary to make sure it's compliant with the Constitution. But if there's a 6-6 vote on the legislator, it could be sent over to the chair's office and say, hey, settle this. Because here's the thing, either way,
I was going to say in the
either
national
way it's
government,
voted
vice
on, the
president
chair
does.
could veto.
I was just adding, in national politics, the vice chairman, or not the vice chairman, the vice president casts that vote in the event of a tie. So, Tyler. Tyler. Can't hear you, Tyler. If you're trying to speak, you're muted right now. Okay, Aaron.
So that's like a turd in a punch bowl. That ain't gonna fly for this board. So I'm saying it like it is. I like the idea, Rob, but I just don't think it's going to happen. So, and I also support what Isaac said about if we had one council member per unit, because the smaller size tribes are more effective and more efficient. Because everybody's got to have an opinion at this table. And if you do have somebody representing every unit, then you got the bases covered. You don't necessarily need 5 people representing Unit 1, right?
And this is another idea. You could also get rid of units altogether, and the tribe could just vote for all the elected officials, like my election. I get elected by everyone in the tribe, regardless of where they live. And it also puts the tribe in a position to select the best representatives possible, despite where they live. So that's another
Tested
idea.
at that level, I support that. I know I'd get elected.
Okay, so what do we want to do here, Ryan? Do you have any proposed polls right now, or do you think we should skip this and circle back?
I don't have anything to propose for a poll, so doesn't sound like we'll get consensus, so probably.
So I'm reluctant to go back to the drawing board. I mean, we had a constitutional committee for a reason, despite me having personal opinions about units. You know, it seems like we want to stick as close to this as possible. So as it's currently written, you have the potential for a tie. So how do you break the tie? Does it just mean in a tie situation, nothing passes? Does it mean that, you know, whoever the executive is or the vice ogama of the tribe casts that similar to national politics? You know, let's put our heads together.
I mean, you see,
Aaron.
But Rob used the example that he doesn't like the idea for an elected official not to be able to cast a vote. So if we want to stay as close to what the committee came up with, and that seems to be kind of a mantra, right? Kind of a purist sort of keep what the committee said to do. We're already not doing that by not adding the 3 additional board members. And I would suspect some people that are trying to stick to what the committee said don't support adding additional board members. So the only thing I think we could do that would be consistent with what the committee wanted would be for the speaker to not have a vote unless there's a tie. And where do we see that? We currently see that right now, because the chairman of the tribe does not have a vote unless there's a tie. So it would be the speaker would not have a vote unless there's a tie. So I would like, hold on.
Yeah, so Kim, to answer your question, like if a 3-branch were to go through, you wouldn't have a chairman of the tribe. So the natural progression would be the chairman would become the executive of the tribe. Whatever title you assign to that, whether it's president, ogama, whatever, that person would be in charge of the day-to-day operations. They would basically replace the board of directors at the top of the organizational chart just to work with the different departments, similar to how the governor works with the director of the DNR, works with the director of MDHHS. There would be a speaker of the House who would facilitate the discussions in the legislative body.
So someone could get voted in that has no experience in any of that.
Correct. Yep, that's the case for all of us.
Oh, that,
Yeah.
but when
And if-
you're the executive of the tribe, I would think you would need that kind of experience, like,
So you'd want some competent people that potentially have business experience or that's surrounded by really smart people who's entrusting them, but that's the current process right now. There's no qualifications to be on the board of directors. Okay. All right,
I
so,
think I voted on that when that section came up back then.
yep,
but
yep. Currently, I mean, the only requirements to state or federal elections is citizenship and age. And then maybe you can't run if you're a felon. Probably not, because our president's a felon. So Rob, then Lana, did I miss any hands? Okay, Rob, Lana, Mike? Okay.
Okay, so first of all, the redistricting has nothing to do with the separation of powers. And at the beginning of this, we determined as a board, I believe we even polled on it, that we are just going to deal with the separation of powers. It is not essential to the separation of powers to determine redistricting or adding people here or there. That can be later decided either through another amendment or legislation. Now, to go back to the tie break, I know certain people have their own biased opinions based on who the current chair is, who the chair was before, who might become the chair. But let me break it down very simply here, so that way we could all have a good idea of what we're voting on. The tiebreaker. So whether you appoint someone in the legislature to break a tie, or you allow the chair to do it, the outcome will be the exact same. Because if you break a tie in the legislature, you will have a 7-6 vote. That's not enough to overturn a chair veto. So how it works is that 7-6 vote will be sent over to the chair's office and say, we have a majority vote, either sign it or veto it. If he signs it, goes to the legislator. If he vetoes it, goes back to the legislator, and we have to have 9 votes to overturn that. So with it being a 7-6 vote, that's going to be the same as if we send it over to the chair's office with a 7-6 vote or a 6-6 vote. It's either sign it or don't. And that decision will not change one bit, regardless of if we have a tiebreaker in the legislator or if we just simply send it over to the chair's office, 6-6 vote, you sign it or don't sign it. Either way, we don't got the votes to overturn that veto, and it goes to the judicial. So I say let the chair break the tie, because it's going to him anyways with a 7-6 vote. Even if you break the tie in the legislator, it's his decision if he wants to sign or veto. So
It's similar to the governor and president. You have to sign it into law or veto it.
exactly. So it's the same whether it's 6-6 or 7-6.
So the way it is right here, we're still going to have a tribal chairman.
There'd be a different title. It wouldn't be a chairman that oversees a board of directors. There wouldn't be a board of directors, so there wouldn't be a board with a chair overseeing it. The board would become the legislative branch, and the board would transition into a full-time legislative role, similar to if you're a state rep or a state senator,
So Kim,
or a congressman or a congresswoman and a senator.
the chair is now, and this, I'm using OGMA because that's the terms 2008 used. We could call it whatever we want later. They become the executive branch. They're in a whole different section. Later on down here, we have a
different
we have a
section.
speaker
That's where I'm
of the House.
lost here.
Yeah, the chair, he or she is no longer part of the legislature in a separation. So they have their own section, their own powers. They're over the government and all the departments. So they're not contemplating in any of this right now.
So the simple majority resolution that was passed don't mean crap anymore, because it could get vetoed if the OGMA doesn't like our decision.
Yeah, subject to a 3/4 as written out right now. We'll get there later. But there's a 3/4 vote override. The legislature could, you could have a really close vote.
Yeah, let's say it's
7-6
6-7.
or whatever. Yeah. Chairman vetoes it.
Evan.
Yeah, chairman vetoes it. Then it goes back to legislature. You guys, there's a big, robust debate.
It has to be 9 of us.
And now you need 9 votes. But somehow you convince through political maneuvering to get those 2 extra votes you needed, then you overrode his veto. Or you didn't, and the bill dies.
So we could decide on things and it could get vetoed every meeting.
That's part of a separation, yeah. Yeah.
Is the override 2/3 or 3/4?
2/3. I think
Sorry,
I
what did
saw.
I say? It might be 2/3. I might have said 3/4. I think it's worded as 2. Let me double check, but I think it's worded as.
3/4 is 9,
If it's 2/3, it's 7.
7, and then I think 9.
If it's 3/4, it's 7. I would err on the side of the
3/4.
3/4.
3/4.
It's 3.
It's 3/4. That's what was used in the 2008 draft, and we've kept that.
Because I know a lot of times when we make decisions here, you don't like them.
You got that right.
And so what's going to happen? Are we going to get vetoed?
So, I mean, that's just how it works in state government. It's how it works in federal government. You know, there's a check and a balance, and we'll get to the executive branch and the balance of power that you have over that branch later. But that's just how it works with governments that have separate but equal branches of government. So you guys enact the laws, just think of it as state, right? The governor signs in the law, vetoes it, doesn't make the governor the queen, right? The legislature can go back and overrule that with a certain level of support. And everyone has to work together. The legislative branch has to work, the executive and the judicial, and when they're all working, everything clicks.
I don't like that.
Well, it's the country you live in. You know, it's a state you live in,
I
too.
know, but I don't like it for here because I hear all the time, we're sitting at this table to make decisions. We make them, we pass, they get passed by the majority, and then it could be vetoed, and nothing ever happens.
By somebody who's also elected by all the people.
Right, but
Presumably,
The
like.
counter argument, if we were playing games like that, we'd all be out of a job. you know?
That's where certain things like a recall election, or there's power to the people here, right, so to speak. They're also, like, we as citizens have certain checks on all of you too when you're separated. Like there's multiple checks to make sure you all are following what you are mandated in the Constitution, whatever version we end up eventually passing. It's just
We'll
the
never
nature
get
of a
nothing
shared,
done, I'll tell
it's the
you right
nature of a
now.
separated government.
Things will never get done.
Okay, Lana, Mike, Aaron, Tyler.
So with the thoughts of not changing the 2008, the 15, that would include the redistricting and all that, and we're not doing that. So the solution was the 12, to keep it 12. And I heard every word that Rob said, and it makes perfect sense to me. But is that the solution, that we leave it at the 12, and then once the legislative passes something, it automatically goes to the chair's office, he can veto it or sign it, and that would be the call? That does make perfect sense. I'm asking,
Right, can you rephrase that, Lana? Sorry.
it's phrased just like Rob phrased it.
Right.
If it passes, since we have the 12, because we're not going to do the 15, so I can't sit here and say I'm keeping it at the no change, because we already said we're not redistricting, so it's down to the 12. So what's going to happen is if we keep it to the 12 and there's a tie, it'll go to the chairman's office, and he will either sign it or veto it, and that's...
I don't know. I think that's part of it. So it could work how Rob said it. It's not explicit in the Constitution that that's how it worked. That really is an implementation, probably a legislative, in part, fix. Like what? So like the House of Representatives at the federal level is you can have a distribution where you tie, and they keep voting. They can either let it die or they keep voting until they get the votes.
That's
there's
the
like
key
there's multiple ways to do it.
So if we said 12, if we keep it at the 12, which we came up with already, because we're past the 15, keep it at the 12, we can keep it that, and then we just come back to the table until we get that other vote. Okay,
Yeah,
I can agree with that.
that's how it works at the federal level for the House of Representatives. If they can't get the votes, it's stalled until they do, or it eventually just dies because they never get the
I
support.
But what happens when there's a tie vote in the House of Representatives?
The Senate, there's a tie vote, then the vice president gets to vote.
Yeah. But we don't have a bicameral House right here.
Yeah,
That's
we
the
don't
thing.
have, right, that's why I don't really recommend having an even number, because we don't have a House and a Senate. We just have a Senate, or we just have one, right? So.
All right, okay, we'll get back to the list. Mike?
Wait, can I clarify there? Because Lana said something that's important.
So if it's a point of information or,
kinda important,
I don't know,
yes.
Mike, I'll ask Mike. Is it okay, Mike?
I can yield to Rob if he's got a question.
It's just a point of clarification here. And it was the point that Lana made, that if we stay with the 12, a tiebreaker will be sent over to the chair's office to break the tie. The point of that was that even if we had a tiebreaker in the legislature and it was 7-6, that's still going to go to the chair's office, and he can decide to sign it or veto it. So the outcome is the same. So Lana's right. Regardless of what we decide in the legislature, the only other option is to leave a tie until we have the other vote, but it's still the same thing. If we get that other vote, you're still going to send it over to the chair's office, and he's still going to sign or veto. So the best bet is just to let him break the tie anyway. If we end up at a tie, kicks over to him.
Or the speaker loses voting ability only in the event of a tie. But let's say, Mike, they like your leadership ability here and they want you to be the speaker. With the chairman or the OGMA or whatever title we're assigning to that, if they're the ones signing it and breaking that tie, you'd still have voting right. Or let's say Tyler gets appointed, you only have one unit rep in Marquette, so does that mean you don't have any voting representation in Unit 5 as a result of that? So all we're talking about is how do you break a tie, because there's 12 of them. So, Mike.
Yeah, I'm not a fan of the speaker thing because I don't think anybody should lose their vote. But I'm also not a fan of the OGMA who's going to be executing the laws being part of the legislation process. So I think what you had stated earlier, Austin, was it's a 6-6. It doesn't change anything. So we either have to come back together and get it resolved ourselves, or we don't pass laws. So
Yep, that's a solution too.
And that's what I would keep it at. Nobody likes the 6-6, but it's also pretty super rare that we're having to get you. I mean, it does happen, but it's pretty super rare. And on really big issues, this body's going to have to come together and pass something with a majority vote. So I'm okay with that.
Aaron.
Yeah, so unless we're willing to add a board member or subtract, because one other option would be to subtract a board member. Unless we're willing to do one of those two to get the uneven. The way that it plays out right now is what's proposed is that the OGMA have the ability to veto, right? But only if it's enacted. If it's not enacted, we don't have to be concerned about it going to the OGMA. So this might surprise people, but, I want a co-equal branch of government, and the legislature should have their authority. So, it doesn't make sense for the OGMA to reach in to cast a tie vote, because then we don't have a separation of powers. So, if you end up with a tie, then it's not enacted, it's not subject to a veto, but it's not enacted. So which means you got to get back to the table and decide, what to do, who to buy off or whatever. No, just kidding. But you got to get back to the table to make a decision. So, and that's the way legislatures do it. So, that's to stay as consistent to what the committee had recommended, given we already violated what they wanted, which was 3 additional seats. If we're sticking at 12 and we're going to have an even number, the solution is either to subtract one of those, take one of the board seats away, or to, if there's a tie vote, that it's just not enacted. We don't need a tiebreaker necessarily. That'd be nice, that's what they wanted, but if we can't come to terms on how to do that.
Okay, Tyler, Rob, Isaac, Lana. Then after and then Kim, and then we'll take a little breather, okay?
To Kim Gravel's point, I don't know if any of you guys have been paying attention to what's happening in Navajo Nation, but that's a very legitimate concern, because he was able to veto the legislature's budget, and then once they finally came to an agreement, he still had vetoed several pieces of funding down, which caused layoffs throughout the tribe and some very discontented tribal members over there. So it's a very real concern to have. To Isaac's point, I actually agree with Isaac on this, is to make it that odd number, go 5 to 2. We sit over here, with one board member, so I think it would make for a more consistent decision-making process, which would be what is best for the tribe. I've kind of advocated all along, if we're going to add that 6th unit, let's just go to a Senate structure and have 12 board members, 2 per unit, with the 6th unit being at large, right? So it would be 2 for unit 1, 2 for unit 2, 2 for unit 3, so on and so forth. And then we would be making decisions that's best for the tribe, not having a bunch of members, flooding the decision-making for one area. I think we've been pretty good at doing the decisions best for the tribe as a group, but we're not always going to be the same people in our seats either. So I'm just trying to think of what's best for the tribe on this one.
The downside of that is, if we compare it to national politics, Delaware would have just as much representation as the state of California.
And they do in the Senate structure.
But not the House of Representatives, and we don't have 2 houses.
But you had said we don't have a House of Representatives because we don't have a 2-party system. So that's what I'm saying. That's why I'm comparing it to a Senate structure.
It's not a matter of party, it's a matter of we don't have a bicameral House.
Yeah. So I lost what I was going to say. Either way, if we don't come to an agreement on things, you re-vote on things or they eventually die, just like was stated earlier. But, I'm more, if Isaac's in favor and more people are in favor, I'm in favor of going 5 and 2, to be honest with you. I'm in favor of leaving it the same. I'm in favor of going a Senate structure. But what we have, we do have to do better. With this, as far as the speaker position, so a lot of tribes who split, they have their chief and they still have a chairman. But also, I think that needs to be addressed with the chief. There does need to be a sub-chief, a succession plan in the executive. So it's just something to ping for later, because I don't know if we're going to get to it. So those are just my thoughts as we're going through this. I've said it before, I'll say it again. But, and then ultimately, Aaron had stated, there's a lot of members over in Unit 4 on this end that don't feel represented. And that split of the line where it actually should be in there would be beneficial to the people over here. That would bring it to an odd number, but it doesn't sound like we're ever going to come to an agreement at this table for those changes.
I don't think we will either, and I think to move this forward, we have to stay on task, because you can make the counter argument where, get rid of units, and then the at-large will have just as much of a voice as the people in the units, So let's just stick to how we break this tie. Rob?
I appreciate some of the stuff that people said, because listening to Mike, I get it. I know what he's saying. He's saying that he doesn't believe the executive should be involved in the legislative process. And like I said, the outcome's still going to be the same. So I'm going to regress back to, I'm going to be more in line with what Mike said now. I think that we just leave it as a tie and keep working on it in the legislature. And then when we get to a majority, then it's time to send it over. So I'm okay with leaving ties. It'll basically be considered tabled, and someone could bring it up and keep working on it if they want. I'm okay with it, and I think it makes the most sense. So, thanks.
I agree. So we have Isaac, Lana, Kim Gravel, and then are we okay to poll on this? Okay, then I'll list you. Are we okay after that? Okay, then I'm going to call on the poll after that.
Hey, Tyler, thanks for your support, but I think you and I are the lone ducks out here. The reason I had stated that is simple. We got 5 units of government, and each unit is like a state, right? And we're fighting over the same dollars that Unit 1 wants, Unit 3 wants, Unit 2 wants. I just think it would be easier to get stuff done and flow nicely, and then you'd have 2 open positions for out-of-state, out-of-service, whatever you want to call them, members, which we don't really give much credence to. But the other thing I'd like to say is, hey, we just showed 20 minutes ago or 30 minutes ago how a 6-6 tie can be worked out just by sitting here and keeping our mouth shut, and it worked itself out. So I think, I don't think anybody should break the tie. I honestly feel that if it's going to be 12 members, then it's 12 members, and if it ends up in a tie, then I got to go back to the drawing board.
Lana, Kim Gravel, Aaron.
Yeah, and with the 3-branch government, and whether 2 or 3, but this is a fundamental major change in how we're moving forward in the composition, and that's, the committee said 15, we're conceding to 12. So that, that in there lies a major change, because we're going from what the committee has said. So with that, I will say that, keep coming back to the table, there is not a tie, and nobody gets involved other than it working itself out. So, but I just wanted to point that out, because this is, we're saying one thing, that we're going to keep it as close as we can. The decision was already made to take it from 15 to 12, and now we're figuring that out. So, yeah, I want to make that comment.
Kim Gravel, then Aaron.
All right. My concern was, and it wasn't a tie, if we voted on something and it was 7-5, 8-4, 9-3, you didn't like it, you could veto it. That's where I had the concern, because nothing in here says it has to be a tie to be vetoed, correct?
You wouldn't veto a tie, you'd only veto enacted legislation. So it has to be passed by some majority to go to
I
the
know, but if
chamber.
right now it's a simple majority, correct?
Right.
So if we pass something at 7-5, he can veto it, and then it comes back here, and
maybe it dies.
what if we do 7-5 again?
Then
And
it's-
everything's going to have a 10-day window.
Point of information, Kim, we're only discussing how many members are on the,
Yeah, but it started with the veto when I asked
well,
the
we're going to
question.
get to that down the
No,
road.
what we're talking about is how we break a tie. So Kim, I'm not going to be here forever. It'll be
No, but I'm
whoever the
just saying
OGMA is.
whoever the chairman
But
OGMA.
there are advantages to government slowing down. You know what I mean? We can look at a lot of decisions that the board of directors has made, not right now, not to pick on this body, that have been a really bad idea, that have cost the tribe. We can talk about downstate gaming expansion. We can talk about a lot of different things. Things that would have been prevented just by a simple veto. You know what I mean? And, at the end of the day, if the executive of the tribe isn't working well with staff to implement what the legislative branch does, and if he's not protecting the rights, which will be verified by Supreme Court decisions, that person will be either recalled or voted out of office. There's mechanisms. So no one in this tribe is going to have a crown.
But I'm
There's going to be
just-
no
I'm
king or
just
queen.
saying, a 9-3 vote could be vetoed. And then we come back here and got to do it again.
If you have 9-3, you already have the votes to overturn it, though.
Right.
Just about.
Unless the executive gets to some of the people who voted. I mean, who said Mike, was that you or about the executive having one of yous just said it, and I can't think of what the wording was. Having the right to overturn, but I don't know. I like having a chairman. You break it during a tie. I mean, whoever the chair is. I keep saying you because you're sitting there, but, and I never did agree with this OGMA when it was part of our discussion way back when.
Aaron.
So, all right, so the issue is whether or not the legislature, who are elected by the people, should have the ability to enact something that's not subject to a veto by somebody who is elected by everybody. That's a pretty simple one for me. The OGMA, or chair, or whatever we end up with, is elected by everybody. That's a unique perspective. Nobody at this table has that perspective necessarily, because you haven't served in the role. And the OGMA will be elected equally or potentially in a more demonstrated strongly fashion because they're elected by everybody, where unit reps are only elected by certain people. So granting the ability to veto a decision that's a bad decision, we have lots of those decisions. The partnership with Jerry Campbell was one. Indian Energy was one. I know it's public. I hope my cousin's not watching. And if we had the ability to veto those decisions, we would be $50 million in the other direction. So, so the legislature doesn't always get it right. And I know I wasn't here for Indian Energy, so I take no responsibility for that, but I was here for Greektown. And in hindsight, that was the wrong decision to make. Kathy Abramson was 100% correct. We lost $750 million on that decision. That would have been a good veto to make. So I don't think we should be opposing the authority of the chair or OGMA to be able to veto just because we don't want them to overturn what I vote on at this table. That's not relinquishing a balanced separation of powers. That's wanting to remain a unitary form of government where your decision stands and it's not subject to anything else. So, so I think that's problematic. What I raised my hand for was, so the only way I would agree to what Isaac proposed earlier, I said I like the idea of 5 board members. The only way that would work would be to do apportionment and divide up the units based on population.
You'd have to change the size of the unit so it's representative of the population. If there's 15 members in Unit 5, and I know that's a fictitious number, but there's 5,000 in Unit 1.
Right.
So how fair is it to have an equal representation?
Unit 5 is about the population's about 1/5 of Unit 1, and there's no way our people are going to support or vote on an amendment where Unit 1 has the same power to enact something as Unit 5. So the only way it could happen is if you did reapportionment and we had 5 units, and then the lines would be completely redrawn, because there's 2 examples of inequities that happen right now. And it's happening because we're outnumbered, is we divide up 2% equally among the short terms equally, 5 ways. And I can tell you, that doesn't make sense for the 5,000 members in Unit 1. We divide up the cultural enhancement equally too. That doesn't make sense to 5,000 people in Unit 1 if Unit 5 gets the same amount as Unit 1. That makes no sense. So, so I don't support 5 unless we do apportionment. And that's not on the table, so we should probably skip past
Yep,
it.
and just as a reminder, we're just talking about how to break this tie. So Rob, then Lana. Tyler.
I was just going to say something similar to Aaron, so I'm not going to go on a big spiel about it. But I'm not trying to start a fight here, but I just got to point out that Director Gravel keeps pointing out things that she doesn't like about this that are the exact reason we're doing it. So it's like, if you're just going to vote for a 2, then just do that. But I mean, to sit here and totally, say that, well, I don't like that. Well, our reason for doing this isn't because we like it or dislike it. It's because our members gave a very clear directive that they expect this from us. So if there's just going to be a vote for a 2 at the end of this, no matter which way we poll on everything for a 3, I don't understand. But to say that we don't want to do that because we have another branch that can check our decisions, that is the entire point of this, is to have another branch that can check our decisions, and then a third branch that can rule on the legality of our decisions. So if we don't want, I just don't think it's productive to keep saying, well, I don't like that. Well, I don't like that. Well, we know you're in support of a 2, not a 3. That's why.
Rob, come on now. Keep it fair.
Get monotonous.
Okay, Lana.
And thanks for that, Austin, because I, for one, appreciate what you have to say, Director Gravel, on your opinion on moving this forward. I'm glad you're at the table, at least discussing it from your point of view, number one. Number two, you brought up dividing up the 2% equally, Aaron, in your chairmanship. So that was one of the things you supported, not liking it now. Hindsight's 20/20, I'm sure. And if we're going to discuss reducing it down to 7, let's discuss putting it back up to the original concept in 2008 of the 15. So if we're going to have that discussion, put the discussion on the table to put it back up to the 15 like the original committee wanted. So I'll say that.
Okay.
Well, I have to object then, because we already determined we're only going to deal with the separation of powers. Redistricting has nothing to do with the separation of powers.
You guys-
And if we do 7, we'd be redistricting.
You
So,
know, you
same
guys-
thing, Rob.
You guys, we can have this discussion. We really
So
can.
keep it 12, let's move on. I mean, poll it. Just poll it.
We can save it for another day, you guys. Tyler, then Kim Gravel.
All right. Well, Aaron brought up a good point, though, is we have, 20,000 members below the bridge who aren't being represented, right? So they do deserve leadership at the board table. So if we're talking about a tiebreaker and the concern there, and we're unwilling to do the 3 at large, I would say add 1 at large. I feel like that's something we can agree to because nobody's getting removed from the table. Unit 1 keeps all their directors. We add 1 voice at the legislature for the at-large members instead of the 3. That'll be an incremental change. We're not going to get to where they were in 2008, but it's something in between. It'll get us to the odd number, and it'll get more representation from more people. Just a thought, as things were being discussed.
So there's a lot of different options there. So I have, let's see, Kim Gravel, Lana, then please let's poll on this, you guys, so we can have a break.
Yeah,
I think at the end of the day, we're just going to all agree with what Mike said, so let's get on with it. Okay, you good?
No,
Okay, does
no,
anyone object?
No, I got it.
Okay, go ahead.
Is it my turn? Rob, I have the right to say if I don't agree with something. Everyone at this table has said today they don't agree with something that we're discussing. I just wanted some answers from Ryan about the veto. I'm saying, okay, if you got 9-3, it could still be vetoed. That's what I want people to know. It's not just in a tie that it could be vetoed.
There would be no veto in the event of a tie because it wouldn't pass for an executive to sign.
Or a 7-5, whatever. I'm just letting them know you could have the majority of the board voting on something and it could be vetoed. And that's where I'm having the problem with the veto power. And I thought we were just here to discuss 3-branch. Are we going to vote on 2 and 3 at the end of the day?
So that's the thing, though. You
We're
can't have
tweaking the
a...
3 branch, right?
Yeah, so we're reviewing 3 branch right now, but at the end of the day, you don't have a separation on any level if you have one body making all the decision without any oversight by another body. So, before I became a social worker, I graduated with a degree in political science. Mike has one as well. Like, you don't have a separation unless you have a veto. That's why it exists in the state level, in every state in the country, all 50 states. That's why it exists on the federal government. You have to have that check and balance. Otherwise, there's no check on the legislative branch of government, period.
So then every time it gets vetoed, it has to come back here until,
If you have enough support to override a veto, but that's the state you've lived in your whole life. That's the country you've lived in your whole life.
I know, but I hear all the time, we're not going under the white man's law.
Well, I mean,
Hear that all
I
the
wouldn't
time
consider it the
here.
white man's law, but I mean, as much problems exist in the federal government, I can't think of a single branch of government that I would like to remove in this country. I mean, I might not agree with the president, but I wouldn't want to remove the presidency from the Constitution. I might not agree with the Supreme Court's decision to overturn Roe v. Wade, but I don't want to scrap the highest court in this land.
Okay, but
That's,
I'm
yeah.
just explaining, I got a problem with it, and then I get crapped on for it. So
Okay.
when I don't
And
like
I'm going to
that.
get
I
on him
don't-
about it. I'm going to get on him
I don't
about it.
crap on anyone else.
Whoa, no, wait a minute. I'm going to respond to that because I was mentioned by name, and I'm just going to make it very simple.
Who said
Kim,
your name?
Kim, you absolutely have a right to speak your mind at this table. I didn't say that you don't. But with that means that I also have the same right to say what I think about your opinion. So we both have a right to speak our mind. I'm not saying you don't, but don't think I'm not going to say what I think about it, because I am every time.
We have to be professional, though, guys. So there's going to be a lot of disagreements on this table. Like, at the end of the day, this is our structure of government. People should feel passionate about it, but at the end of the day, we have a camera on us. It's on us to remain professional and to progress through this document, okay? So it seems like we have a consensus on how to break this tie. So we don't need to go back and forth. We have a lot to get through, Like, we could suspend the discussion right now and just vote on this, and just move on. Or I could continue with the speakers list, but the thing is, someone will say something that someone doesn't like, and then we got 3 more hands up, and then we're an hour into this. So let's just be professional, let's stay on task.
Kim did better.
Okay.
No, I think, the order would be Lana, me, and then Kim.
No, I yelled it after his suggestion.
Aaron, Kim, am I missing anybody, guys? All right, Rob, put your hand down.
So,
Might as well just leave it up at this point.
I'm going to say something that I think is hopefully intended to be magnanimous. I appreciate Kim's perspective. I don't agree with it 100% of the time, but she's not pulling any punches. She's not pretending at this table. She's not misleading people by saying, I haven't decided yet, I'm not sure yet, blah, 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 because I think that's an act of dishonesty. And I didn't look in any particular direction, so if you feel like it applies to you, then that's on you, not me. Right, and I appreciate, all right, having said that, I think the poll, my request for the poll would be, do you support the legislative branch at 12 with no extra measure to try to break a tie? Because we got into this because there's a notion that we need a tiebreaker, but I mean, I had an epiphany sitting here. You don't really need a tiebreaker because if it's a tie vote at the board level, it's not enacted. So that's the answer. And it seems like we have a majority who agree with that. Several people expressed their opinion on that.
Okay, Kim, then let's do the poll, please.
Well, thankfully, I can respect all opinions and understand why everybody feels the way they do. Still stand in the center of the room and form one that is based on what I feel is best for the tribe. So with that, and not that we're supposed to be rewriting this, but sometimes a different point of view is also, the membership does have veto power. However, those numbers don't allow them to have veto power. A change in those numbers would allow the membership the veto power that they would need to overturn anything that we did. And if we had a judicial branch, we wouldn't get the option to sit at this table and decide whether or not it was going to go over there, because then it would be law. So that's my opinion.
So since Mike, I'm going to give you credit for it, Since Mike made that recommendation, after hearing this discussion, does anyone disagree with that? There's 12 people there, so 6-6 means tie, means nothing's passed, means you guys continue to work it out. You good? All right, 5-minute break, guys. Heck, make it 10.
How magnanimous.
Where we left off?
All right, section 2, terms. Terms of office of each council member shall, The term of office for each council member shall be 4 years. The terms of office for all council members shall be staggered. Standard language, similar to what we do now. Section 3, selection. All council members shall be elected by the eligible voters in their voting units pursuant to the requirements in this constitution and the terms of, I changed this to the tribe's election laws to be consistent with number 1. So you're voted in the same way currently, and it will remain the same. Section 4, qualifications. Every council member shall be a member of the tribe, 18 years of age, or older, be a qualified voter of the tribe, physically reside in the voting unit for which they wish to be elected for at least 1 year immediately prior to the election. D, council members shall not, I, serve in any capacity in the executive branch or the judicial branch. Double I, serve in any, I added, same as we did for the judges, any elected or appointed capacity for any tribe, state, or the United States of America, excluding appointments to committees formed for the public good. And triple I, accept any position or appointment that creates a conflict of interest. So it substantially mirrors the same type of requirements as the judicial branch, which they added they had to live in the unit for 1 year before they can run. Good with that? Section 5, compensation. Tribal council shall have the power to establish the level of compensation through the approval of the annual budget for council members, provided that the compensation shall not be diminished during the term of their appointment. The compensation of the tribal council shall remain consistent with the levels of compensation in place at the time of enactment of this constitution. No council member shall be employed in any other governmental role at the state, tribal, or federal level. That's misplaced. That's language from the 2008 draft that they had in there. If we still want to keep that provision, I would move it up to the other qualifications. But they don't want, in 2008, they didn't want any council members to have other employment in other governments. So I need them.
So that means you couldn't be a corrections officer or a police officer or any position in state government, are you saying?
That's what it appears to be the intent of the 2008 draft, but I want direction today on.
So I would seem to think that would go too far.
I do too.
Okay.
I agree.
Does anyone disagree with that? Okay.
So I'd like to just remove this. I think we have the prohibitions covered in the D section above anyway. So.
Lana.
From what I recall, and we weren't privy to the conversations in 2008, but 2012, it just meant a position at the state or federal level. It never went to like a job within the state, like a correction officer or a police officer or a county clerk or anything like that. So I think keeping that language would be fine, but it's at the federal level, not.
No, just say elected position. Cannot have an elected position.
There you go.
Yeah, I think we have that covered
That would work.
in subsection D above, number 2.
Because you might work for the federal, you might work
3.
for the Hiawatha National Forest or something like that. That's a federal position, and it wouldn't be any different than if you were a police officer or something like that at the state police post.
I think your compromised elected position at the federal or state level.
Yeah, so we got that covered, and the real thing they're trying to prevent, I think, is conflict of interest, which we also have covered. So I'll take out that, if there's no objection there.
Okay, Kim?
So then you're saying section 5 would move up to section 4 and be like E?
No, section 5 would remain the
Standalone?
same, except that last sentence, I would delete it. The sentence says, no council member shall be employed in any other governmental role at the state, tribal, or federal level. I'll strike that, and we have what we need covered above in the conflict of interest and the elected and appointed position language.
Got you.
Here's the meat of it, so to speak. The section 6 powers. The legislative powers of the tribe shall be vested in the tribal council, consistent with this constitution. Such powers shall include A, the inherent power to establish laws through the enactment of ordinances and adoptions of resolutions not inconsistent with this constitution. B, to authorize and approve agreements and contracts negotiated by the tribal Ogama on behalf of the tribe with federal, state, and local governments, and with other Indian nations and their departments and political subdivisions, or with private persons on all matters within the authority of tribal council. C, to purchase, lease, take by gift, or otherwise acquire land, interest in land, personal property, or other assets. That's a Freudian slip there, huh? Other assets which may be deemed beneficial to the tribe. So I'll pause for a second. Those are the first three, if there's any questions.
I don't see any questions there.
All right. D, oops. Sorry, D is not in the right spot. That's for the executive power. So D is to establish the executive departments of the tribal government and their governing policies. E, to adopt resolutions or.
Pardon me, I got
Sorry.
a question here.
Yep.
So you took out D.
I took out D, sorry. In my online, it switched my lettering. So I took out to approve or veto any sale, disposition, lease, or encumbrance of the tribe, its land, interest in land or property. That's an executive power. That was a typo. You have the power to purchase land, but you don't have the power to veto your purchases. That's the executive branch.
Gotcha.
That was just a
Okay.
typo.
So if I could say something about D, so this is for you, Kim Gravel, to establish the executive departments of the tribal governments and their governing policies. So if you have an Ogama that's in charge of the government departments, that's one of your checks over the Ogama. It wouldn't just be control of the purse strings, it would be, establishing the executive departments and the policies that the Ogama is required to carry out. So that's one of the checks, and you can expand on that, Ryan, if you think it would be helpful. No, I'm just pointing out that, your concern was a veto from the Ogama to the legislative branch, but this would be one of the checks that you'd have over the Ogama. The Ogama wouldn't just have a crown over the tribe. They would work the executive team that's established by the judicial, and then you guys set the policies.
Right, so E, it's on your printout one, it's E. On the one on Zoom, I struck out that one. It's D. But the legislature has the power to establish all the executive departments of the tribal government and their power to create their policies. So in this current language, the legislature still creates departments and creates their policies. The executive then implements pursuant to whatever legislature adopts. So like Austin said, it's kind of a preemptive check on so you set the tone for what the executive will do at the legislative body.
Yep, and then it's not up to the Ogama just to disregard that. It's similar to within the federal government when Congress funded certain programs and the president said, nah, I'm not going to do that. Funding those programs was a mandate, and that's why, the Supreme Court stepped in and said, Donald Trump, you have to do that. That's an example of them all working together. So Lana and Mike Tyler.
Yeah, so in D that you said you're taking out, you were kind of talking to yourself, but that's what caught me off guard. Because this is the powers of the legislative branch. You're taking D out and putting those over to the executive, but but this says to approve or veto. So that, in my eyes, would give the executive branch the authority that the legislative should have by approving a sale or a disposition of property. So is that language wrong in there? Because it says
I see what you mean,
approve
yeah.
or veto, and he doesn't get both of those rights. That's the balance right there.
It is, you sign it in the law by approving it or you veto it. You approve or veto. That's what the executive does.
Well, look,
I see what you mean, though.
Okay.
So let me backtrack a little. So you have the power to purchase land. So you would have,
We
the
do.
legislature would have the power to sell it as well, subject to veto. So
Ryan,
I was too quick on that. I apologize. So if we take out the veto language, then now the legislature has the power to purchase and to sell land, subject always
However,
to the veto
and
power.
veto goes
Exactly.
over to the executive.
Yeah, it'd always be subject to the veto power of
you
the
would
executive.
still need the Ogama's signature, though. I mean, if you were to purchase land, it would follow the same format now. You do so in a resolution. Ogama either signs it in the law, which is the approval, or vetoes.
Yep, but he needed to switch this language here.
Yeah, the veto
Mike, then
language
Tyler.
was It was in the wrong spot. Yeah.
I think I'll wait until we get to, because if this is getting moved to the executive branch, this is a question directly on this, I'll hold my question until we get to that
Yeah,
executive
the
branch.
the veto part of D,
It
I
will
need
be
to make
there?
sure it's in the executive powers.
Okay.
Right.
My question is on that, and so I will wait until we get to the executive branch and then question it then.
Okay, Tyler?
Brian, just a logistics question. So before, you were talking as if general counsel would just automatically move with the executive, but here we're establishing the executive departments. So we would maintain operational as is until legislature has the opportunity to establish those, or do we pre-legislate that?
Right, that's an implementation question that we'll have to figure out if we get to the point where we're sending something for a secretarial vote and it looks like it's going to pass. Yeah, it can be, we can have legislation ready for when and if this separation passes. Last workshop, made a somewhat passing comment about the government, which would be under the executive branch, would maintain the legal department in its current form. That's just how most other tribes do it. But that's a discussion, that's a later discussion we have to have of how we're going to implement it. Where do all the key employees go? Where does the legal department go? That's way beyond the scope of the actual substance in the Constitution, but it's something that eventually we have to talk about.
So I have a,
Right, but just to follow up, so like this is a process question though, is like, would we be able to operate as is until these policies get passed once the separation occurs? Or do we need to do this in advance in order to maintain function?
So it'd be a little bit of both. So a lot of our codes probably can work with some small tweaks. Some of them might need bigger tweaks. Most of our departments that are on the government side can easily fall under executive branch. Legal maybe is the odd duck out in that one, where the legislature has the power, we'll see later, to employ legal counsel, just like the executive does. We have a bunch of legal counsel that we currently employ. We have to figure out how we want to structure it. I don't have recommendations on that today.
can I give some feedback? Okay, so basically the general counsel for the United States is the U.S. Attorney's Office. Who does the U.S. Attorney work for?
It's the executive branch.
Exactly. It doesn't work for Senate. It doesn't work for Congress. Same thing, Attorney General for the state of Michigan. Does it work for the state Senate? I know it's a standalone position that is semi-independent. They have their own election, but it works for the governor. A lot of times we talk about that being the governor's attorney. So that would be my interpretation. So when we talk about the different departments and the different directors over those departments, I would interpret that as cabinet level positions, to where the OGMA nominates someone and then the legislature votes to confirm that person. So that's another check, Kim. So let's say, you're concerned with who the OGMA is filling these positions. I would have to ask your permission to hire certain people. It would come before this as a vote. So let's say, general counsel, let's say Ryan wins the lottery and he's like, I'm done working for the Sioux tribe. We need a new general counsel. Okay. So I would do interviews, and then I would come to the board, the legislative branch, and say, hey, I've conducted interviews. I have the Sioux tribe member who I think will do a fantastic job. There could be a confirmation process where that individual is sitting before you. You guys ask all sorts of questions about his, just law philosophy, things like that. And at the end of the day, it would be up to you guys to hire that person. And then I would work with that person to carry out the policies of the tribe. But at the end of the day, it would still be a direct report to the OGMA's office, similar how the DOJ and all those are to the president.
So I appreciate that, but I was asking about the process. It was a process question about what comes first, the chicken or the egg, or do they come at the same time? And then do we need to get those on our agendas like early next year to move this forward? I think it's an important question because we have to continue to operate, but we also have to establish these new policies and laws once this transitions.
Okay, Aaron.
So, all right, I've heard this argument several times. It's not a reason not to move forward. And also, when we vote to establish a 3-branch and request a secretarial election, we can then also establish a transition period in order to prepare for that time. We already have an appropriated budget, so I'm going to guess that in the best of circumstances, we won't be enacting a separation of powers until like June or July at the earliest. And in the time from January to June and July, we can be preparing what that transition looks like. And so other tribes that have a separation of powers, the council does have their own attorney. But for the most part, the staff that work for tribes work for the executive branch. They don't work for the legislative branch. That's going to be a very new thing for us, a very different thing from us, because we have all of the top executives report directly to 13 people. We also know that's not an effective structure. We know it's not efficient. We know that the morale and climate for people that report directly to the council is not something that they like. That's probably why we don't get a lot of applicants for top positions in the tribe. But I think part of the implementation would be to approve a transition plan that allows for the continued operations until such time that the balance of power can kick in. And what does that look like? The executive drafts up a proposed budget. The legislature drafts up a proposed budget. They come together, they work out the differences, and then the legislature enacts the budget. So they retain the power over the purse strings of the tribe. But there's a specific provision in this draft where if the legislature plays games and they try not to approve the budget, that you continue with the existing budget until they enact a budget. So they can't play that game. So
Prevents the government shutdown like you see on the federal level.
right, all of this was discussed, all of this was contemplated, it's not brand new. Go back and read the minutes, the notes of everything all the hard work that they did. And so if we're lucky enough, like I said, to approve a 3-branch separation request for the secretary, we can immediately get started, that's what we're paid to do, to start drafting up what that transition would look like.
Okay, did I miss anybody?
Yep, me.
Okay, go ahead.
So the process of it, do you agree with that, Ryan? Do you agree that the process could easily be, we could go as is? And how do you envision this? Because Aaron envisions it one way, and that's, we can. Well, the committee envisioned a lot of things, and we're changing quite a few of those. Major or minor, we're changing them.
And that's the way the governments work, state, local,
Right. My question was to Ryan. So Ryan, how do you envision the process working, whether we pass the 3-branch or the 2-branch for it to work and government is seamless going forward?
Well, for a 2-branch, it'd be, I think, the easiest, right? Easiest, I say that in like the terms of not having to do a lot of code changes, because we're just separating the judicial branch and everything else kind of stays the same. For a 3-branch, I think a lot of our day-to-day can carry on as it currently is, with some slight tweaks while we make the bigger code changes that might be needed. But I think like most of the government departments could carry on. They'd be ultimately reporting to the OGMA instead of the board, but like a lot of the other positions can
We'd have
remain
two
intact.
different- We'd have
right?
two different, we wouldn't have just one general counsel, though, because the executive would have a counsel and the legislative would have a counsel. So
Right.
we would have to, that's a
That's why I say, yeah.
fundamental.
Point of information.
The legal department, I think,
Real
is-
challenge that we would have in order to move forward for those 2 branches to work.
So point of information, Ryan, would you only need one general counsel and then legal representation for the legislative branch, similar to senior staff attorney, just to make sure they weren't making decisions that would end up in the Supreme Court sued? At the end of the day, there's one general counsel for the tribe.
So a lot of the tribes here in Michigan that have separated, and other tribes that have some kind of either legislative or, oh, my Zoom just crashed, constitutional separation. They have 1 or 2, depending on how big the tribe is, staff, legal department staff, not legal department, just legal staff, like legal attorneys or support staff that work directly with the tribal council, legislature, whatever they're called. And they are direct reports to that body. They don't report to anyone else. They are there every day like I am now with you. And they're just their own attorney. And then all the other staff attorneys who do the various advising to other departments are usually under the general counsel, chief legal counsel, whatever they call it. And then they're separate. They don't interact with that legislative attorney. But it's not like two general counsels, but the legislative attorney is what most people call it. That's your attorney as a legislature. That's that attorney that helps you with all your code drafting, advises you on all that stuff. They might need more than one person for our size. I don't know, but that you have the power as a legislature to figure out what your legal needs are and try to pass a budget that meets them.
But the legislative would have separate and the executive would have separate, right?
You'd have to be separate. We couldn't advise both.
Because
It
of
just
the
would
conflict.
create conflicts,
Right.
ethic conflicts.
And that's, I think that was I think that was the process question, so.
Yeah,
In the beginning, if we needed to assign someone, create that installation for someone, like the staff attorney is now your attorney while we figure out the long-term thing. Like there's ways we can work, I don't know why my Zoom's not working. There's ways we can work with that, but that has to be a short-term thing because you don't want the general counsel, if they're with the executive branch, to be overseeing the legislative attorney. Then you're piercing right through the separation that we're trying to create.
Yeah, so at the end of the day, the legal department is the department of the tribe. All departments direct report to the Ogama, but at that same token, you're going to need legal representation in this room as well to avoid enacting legislation that's going to end up leading to a lawsuit. So you guys would continue to have a legislative administrator, Ashley, Lana, a position similar to that. You guys will have support staff, which would also include legal services as well. But at the end of the day, the departments work for the Ogama, and you guys set the policy, and you guys confirm who is hired. And you also control the purse strings of the tribe as well. You guys pass all the budgets. Aaron.
And I know some are uncomfortable with that notion, because right now what we have is we sit at this table and all 13 people supervise the general counsel. And so the change is going to be that that's not going to be the case anymore. The general counsel will report to the administrative branch, the executive branch. And they'll have their own counsel, like you said, as you're drafting laws, that you're not enacting laws
Point of
that violate
information, Aaron.
constitutional rights.
Point of information, Austin, I mean.
Yes.
So, but that legislative attorney does not report to the general counsel.
Correct.
That's correct, yep.
Okay, I wanted to get that
Nope,
clarified.
it's all yours. That way, in case there's a lawsuit, there's that separation.
So, and I know there was about 15 years ago, there was conflict with Little Travers with their council attorney versus their general counsel. And how they solved it was they both gave expectations that both attorneys collaborate and they communicate. And often, the general counsel would attend sessions of the legislature when invited, so that they could weigh in if there was something that they could collaborate on. So that's something new, that's something different than what we currently have. But and I'll say this very professionally, if we look at some of the decisions that were made in the past, and some of the outcomes by having a diffusion of responsibility by our executives reporting to 13 people, that's why they didn't communicate, because they didn't feel they had to communicate with each other, and the outcomes were very bad and costly for the tribe. So knowing who you report to and reporting up through a chain. And one other final thing is, while I know some board members might feel very uncomfortable with it, we elect the chairperson. We elect the Ogama. We expect when we elect the Ogama that the Ogama has the authority to operate and run the tribe. And I know some council members in the past may not have liked that, but that's what the people expect. Right now, they don't understand why it gets all tripped up and the chairman doesn't have any authority. They expect the chairman to have the authority. And this structure will realign their expectations with reality. So the chairperson, the Ogama, will have the authority to administer the tribe.
Okay, Lana.
That's not accurate. You know why? We had a constitutional amendment that took the authorities away from the chairman and all the CEO duties out. So if they read the Constitution, they know that. That's an amendment. That's history. That's fact. So that was in there. So people, my members understand that. I mean, the ones I talk to, they're not foolish. They're not ignorant to the fact that they elect a chairperson and they expect inherent rights of that chairperson. But in our existing constitution, there is no authorities in there right now. That needs, there does need to be changed, but that's a fact right now. So,
I have to respond.
Can you mind if I say something first, Aaron? So when I talk to people, they assume that the chairman has much more authority and power than he actually has. So, I mean, a lot of us weren't politically active in the tribe 15 years ago for, due to our age or due to whatever reason. But like, there's this idea that like, if you want something in the tribe, you just go to the chairman's office, he can sign a couple things and it's done. And that couldn't be further from the truth. So right now, the chairman, he chairs a meeting, he votes in the event of a tie, he's the official spokesperson of the tribe, advocates for the tribe on the local, state, and federal level. Beyond that, there isn't a singular leader of the tribe because that spokesman's ability is codified. It can be taken away. I have a couple little pieces of power. I can shut down the fisheries if it's needed, but, that's not the case. And as far as that constitutional amendment goes, this is what we're talking about here. And, over the course of our country has enacted amendments that they've later decided was a bad idea. So I always use prohibition as a classic constitutional amendment. At one point in our country's history, there is the general belief that we should outlaw alcohol, and it was outlawed. But you fast forward a number of years, and then the country said, well, that wasn't a good idea. And that's what I view this constitutional survey that we just sent to the membership. We've seen what happens, when we don't have a strong chairman, whether it's me or someone else, because I can promise you I am not going to be here forever, and, they've reversed their decision. Over twice the membership who participated in that survey said that they want power to a certain chairman because they know what a separation of powers is and they know what a veto power is because they've lived in a country that has that on the state level and the federal level their entire life. So that's all I had to say.
So in 2010, there's only one board member that is still on the board from that time period, and that's Lana. And the person who I really respect, who's deceased now, is Denny McKelvey. And when Denny McKelvey voted for it, he said the reason he voted for it was because it was only taking the title of CEO out, and that the way that the amendment was drafted was confusing to people. And the vast majority of the people that I've talked to have reiterated that that's what they thought. So how do we know what people want? We just voted on a poll that overwhelmingly said we should have a separation of powers that vests the Ogama with the authority. So while that passed in 2010 with several tribal members saying that it was deceiving, it was misunderstood, Denny McKelvey, who voted on it, said he voted for it with the stipulation it was only changing the title. The board also had the authority to delegate the authority, and they did. In 2012, unanimously, the board delegated the authority when I served as chair. Then the board in 2016 voted to rescind that authority. 500 tribal members circulated a petition. Aaron Schluhuber, in writing, wrote that it was a valid petition. The politics of the tribal board insisted that John Wernette rewrite that so it wasn't valid anymore, and we were denied our right as citizens to overturn that. We would have overturned that. The members would have overturned rescinding the authority of the chair. You talk to any tribal member, they don't anticipate that the council of the tribal board votes on every single action of the tribe. They don't expect that. They don't support that. They don't respect it. How do we know? We just did a poll, and 56% said they want a 3-branch separation of powers. So, so if we're talking about what the people want, and this will, I know that there's some, nobody here has written it that I've seen, but there's some crazy stuff out there that some people are posting saying that that amendment overrides and there's nothing we can do going forward. If we vote on a secretarial election, the people vote on it, that takes precedence. And at that point, it doesn't matter what individual board members think or want, because the people of the tribe will make that decision. And we have the best guess about what the people want is that latest poll. One other way to know is that every time that I ran for office, I ran on separating the powers and having the administrative authority. When you ran for the 1, 2, 3 times you had to run to get your seat, you also ran on it. The percentage of votes that you got was about 57%. The next person in line was, you had a landslide victory. They were about 15 or 16% behind you. Last time that I ran, it was also a landslide, and I campaigned on the chairman having the administrative authority of the tribe. and that means all the people of the tribe voted for that. So we know what the people want. It's time for us to leave all that in behind and move forward with what the people want. They want a strong executive. They want a chairperson who's qualified to do the job, to administer the operation of the tribe. That's what our people expect. None of us should be standing in front of that and preventing that from happening.
And if I could add one more thing, they want someone to hold accountable too. So if the tribal departments aren't running fluidly, you can can that chairman during an election. You can't can 12 people. There's no accountability. You say the board, well, who's the board? You know, they want some person to point to and say, things aren't working properly. I want this fixed. Otherwise, I'm going to replace you.
Point of
And that's fair.
information. You guys can tag team me all you want and portray it that I'm on an opinion here. My fact was that we did have a constitutional amendment. Never said that that couldn't be changed. I never said that that couldn't be undone and change wasn't coming. I said the fact is there was a constitutional amendment that was put in place that we took those duties out. So.
And it's just as conceivable that the members who voted for that now recognize the error of that vote. And that's why 56% of the members are saying they want a separation of powers with 3 branches.
Okay, let's get to the list. Tyler, Rob, Aaron.
So just going back to what was originally discussed here and on the table here is, so again, subsection E. I don't know how we got into the legal department. You know, I used it as an example, as bad example. So it says right here, to establish the executive departments of tribal government and their governing policies. So right now we have a government, right? So when we separate out to 3 branches, this was a process question. So say the legislature doesn't want something to shift to the executive. Like, is this stuff that we have to pre-process so we can all get on the same page and continue operating efficiently like we are today? Or, you know, is it something that is done after the fact with just the legislature involved? It was a simple process question. I don't know. I got a little lost in all the discussion there because it says the legislature will establish the executive departments of the tribal government. So that means there's room for interpretation there, and I just want to get on the same page with everybody to make sure we're talking about the same thing. Because, like, we may establish an executive department that doesn't exist. We've already talked about and pulled on keeping the executive out of potentially the Gaming Commission and the Economic Development Commission. So that was really my question towards Ryan is, are these agreements that need to be made beforehand just to continue operating? Is there any risk to us? It was just a simple question. I don't know how it got misinterpreted. You know, I'm not thinking clearly. I'm a little under the weather, but like that, I was looking at E here.
And I'm going to be added to the list, and I can give some examples of how it could work, but I'm going to let the list exhaust itself, so go ahead, Ryan.
Right, because what I'm saying is it's not just automatic, because if we are to establish,
You want me to give you an example?
It doesn't just shift everything.
So you'd switch the organization chart from board of directors to the OGMA's office, right? But there's still certain committees within the tribe that are occupied by the board of directors, like the Gaming Commission. So one thing that you could do is you could replicate what the state does. So you have smaller commissions on the state level that aren't comprised of state reps, state senators. So those commissions of which you were just appointed to, Tyler, are nominated by the governor. They're nominated by the OGMA. So we could use the example of the Gaming Commission or the EDC board. The board wouldn't be on those because the board wouldn't be involved in operations. The OGMA's office would fill those boards with business-minded people, and then the OGMA would chair those meetings. So you'd still have a separation between those committees and the rest of the tribe, so you could offer separate insurance packages and things of that nature, which is the very reason why we created those boards. So yes, there's work to be done, but we got it.
That would be under the assumption that everything just transitions to the executive. Didn't we already poll on keeping the language where it was and keeping the executive out of those?
You would have to have the executive run it because this is clear. The board becomes the legislatures. You guys transition into a purely legislative role that no longer is in day-to-day operations of the tribe.
So it's a little bit of both of
I
what
think
you
you're
guys are
misunderstanding.
saying. So the language in the 2008 draft and similar language here that we'll get to, the gaming authority, the enterprise authority, housing authority, any other future authorities. Right now, we'll have to poll on this, but the council members, if they're otherwise qualified, can serve as unpaid members of those business boards. I'll have to double check. I don't think the OGMA has that same language in there. We certainly can put it in there. So as we go through this draft and as we eventually get to implementation, that is a question that we need to figure out how Sioux Tribe wants to do it. Right now, in the draft, if nothing else changes, and we haven't even got to those sections yet, it's not a given that the OGMA is over every single authority. They're just over the tribal government departments and the executive departments, however they get populated currently or in the future. But that is a point that we need to get consensus here. We talked about it briefly a little bit, like to Tyler's question, at the last workshop. And the consensus at the time was to leave this language as it is so we could have the bigger workshops that we're having now. But right now, as it's written, the gaming authority and the enterprise authority, they could be populated still by the legislature or by other people that we, I did the best practice workshop with you guys last month or the month before, and especially as we're separating, it's maybe not best practices to have the legislature be those bodies. They can, but to Austin's point, I don't think they should, but right now, the way it's worded, they still have the ability to sit on those boards and run the gaming authority, run the enterprise authority.
Point of information.
Yeah.
And I hear both arguments. I mean, I'm open-minded on this, so, but my point of information is, in the 2008 draft, where did the committee put those entities? Under the legislative with being unpaid positions populating that? Or, who keeps interrupting? Or under the executive branch?
They are under the tribal council, they're under the legislative
Okay.
branch, but there's language that both the council members and the OGMA can sit on in the 2008 draft.
Meaning you have no true separation. I mean, there's certain parts of this that isn't perfect. That's why we're here talking about it. I mean, we had a chance to approve it as is, and it didn't get approved, so that's why we're having this conversation. But I mean, at the end of the day, me as the OGMA, if that's the role I'm going to assume, I could nominate Lana, Mike, Kim Gravel to serve on the Housing Commission, and then they would have to go through a confirmation process, I'm assuming, just like the government departments. But at the end of the day, it would be up to the OGMA to make those nominations and then work with that board. It couldn't automatically be assumed that we continue to have the board of directors just with a different name, the legislature, still to control the day-to-day operations of the tribe, not the tribal departments, but the casinos, the EDC businesses. I mean, that's what we're talking about here, is the business structure of the tribe. Rob, then Aaron.
I just wanted to point out something about the 2010 amendment, because there was a little bit of, I wouldn't say misleading, but wrong information there. So like someone said that most people sitting on this board right now weren't politically active. I think other than Kim, Lana, and Aaron, I don't think many were 15, 20 years ago, but I was on the youth council and I was the president. I remember watching this very intently. The purpose of the 2010 amendment was to take budgetary and budgetary authority away from the chairman and the daily processes of policy and procedure away from the chairman, which was successful. I have to point out that this document does not give back to the chairman either of those. Budgetary authority remains with the legislator. Setting daily procedures and processes remain with the legislator. The executive branch is now tasked with carrying them out. So this idea that this undoes 2010 amendment, it's wrong. It doesn't. We still, in this document, hold on to the powers that were restricted back to the board in 2010.
Aaron.
So, all right, if we enact a separation of powers, but then later on, we say, well, we didn't really mean it. We didn't really mean the administration of the tribe would still remain under the board of directors. That's going to go over like a turd in a punch bowl. The people understand, the average person, the 7th grade person understands that a separation of powers means the administration of the tribe is operating under the executive branch. The legislature does not have supervisory authority, nor should they. That's the problem with the structure that we have right now, a diffusion of responsibility where the people that are, like the example was the $88 million judgment, came due, and they report to 13 people. They weren't letting this body of 13 know what was going on, and we ended up with a $10 million liability. So I think that's very fundamental. If we think we're enacting a separation of powers, but we're retaining under the legislative branch the ability to administer, that's not correct. That's fundamentally wrong. So the board will continue, the legislature, to have the appropriations authority, but the board will not manage the budget. That's not appropriate. The administration will manage the budget of the tribe. And as far as, I think there is a prohibition for one branch is not able to serve on another branch. So all this talk about appointing board members to serve on commissions, I don't believe that's even possible. And that's what we want to get away from. Now, having said that, oversight is different than management. And it is in the normal course for legislatures to have oversight authority. So that means that the people that administer the programs and services are subject to oversight hearings, that they have to come in and explain what's going on, and that is appropriate for a legislative branch. That's a effective separation of powers. And they can give direction on what they intended when they enacted the budgets or when they created the structures. So, one other thing, I guess, is this is our opportunity to create something that other tribes have already crossed this threshold. We currently have a gaming authority, which is made up of the members of the tribal board of directors for the management of the operations of our casinos. You don't see that at any other tribe in Michigan. They don't operate that way. They delegate to a gaming commission, and that is the recommendation for the National Indian Gaming Commission, suggests that you have a separation. We also serve as the gaming commission, which is, the best word for that is incestuous. So we are both the administrators and managers over the casino. We're also the regulatory body over the casino. So we are the regulatory body over us, ourselves, as the management. That doesn't even pass the stink test. And the National Indian Gaming Commission has recommended that tribes not operate that way. They made that recommendation in 1998. So we are a little bit behind the 8 ball on that. So once we separate the powers, the administration of the tribe will be under the executive. I think that's what the people expect, subject to the appropriations by the board of directors and whatever structure the legislature that the board of directors, and subject to oversight. And I think that's appropriate. But creeping backwards into thinking that the board of directors or the legislature is going to administer any programs and services or supervise any staff, I think is foolhardy. I don't think that's what the people are looking for. So I hope we don't create a structure that we vote on that leaves that open-ended, because that we'll end up in court for the next 20 years trying to litigate that.
Okay, Rob, then Lana.
I just forgot to put my hand down.
Okay, Lana.
Well, I don't think anybody's saying letting that creep in, because I think that our whole discussion is the separation of powers and how it's going to fit in. That's what we're asking about. So, I'm for one too in the realm that, the board of directors do not have to be on that, but we're getting to the process of how it's going to work. And even Austin said I can appoint, certain board members to those seats, and it still has to be ratified by the board. That's what he said.
You might be incorrect in that, though.
It's an option. It's an option.
It's an option.
It's not that detailed.
Okay.
It's not
I'm not
that
done.
detailed in this, right?
Austin?
You use it all the time.
There you go.
Point of question. Is
You're
there
the
a
chair.
provision, because you've already said it, so it came out of your mouth, Is there a provision in this draft where you can't serve on two branches of the government at the same time?
Microphone, whoever's talking.
So
Yeah.
the distinction would
All the
be,
branches.
it wouldn't technically be a branch, you'd be on a committee. But I do want to speak about this when you're done, Ryan.
Okay, and, well, I want Lana to finish her thought, and then I have a lot to say. It's getting in the nuance, but I think it's important to flag here because we're talking about it, so.
This is one of the most important polls we're going to have on this, whether or not we're going to have a true separation. Otherwise, we're just calling it that.
Right.
Yeah, and there's no doubt, I mean, and I don't speak for everybody, I'll speak for myself, but, you know, if we're going to separate, we do have to separate those things. How we get there is a question that's valid, and we should be asking to figure that out, because you're saying one thing, Aaron's saying another thing, and Austin is bringing up some solutions to get us through this, and now he's saying that he might have been wrong in that, but it's still important for us to understand what's going to happen when we poll and make a vote going down this road.
Yeah.
This is huge deals.
This is one of the biggest pieces
That's
that we
right.
have to figure out.
And the other thing I was going to say, and I'm for one, if we're going to separate, we're separating it all out. And the legislative, the executive, and the judicial is all, but we have to know when we poll how that's going to look. And the other thing I'm going to say, till I put my hand up again, and I wasn't even going to talk much today, but is when they said the 2010 constitutional amendment was so that the chairman didn't be able to do the budget. The chairman has never been able to do the budget. Aaron never got to pass the budget without the board voting on that. The legislative has always had to vote on the budget. We didn't change that in 2010. So that's incorrect.
Okay, let me say what I'm going to say, because you might have a response based on that. So if you're going to have a true separation, the board of directors, which is going to become the legislative branch of the tribe, has to be out of operations. That doesn't just mean governmental, because if all you're doing is separating yourself from governmental, all you did is create a boss for Jessica Dunback. That's it. You know what I mean? And that's not a true separation. That would keep you guys in every closet that you're already in right now. So we have a couple boards that manage the day-to-day operations of the tribe. You got the Gaming Authority, you got the EDC board, and you also have the Gaming Commission. So my interpretation of this is you're still going to need to have those committees and that EDC board, but the board of directors cannot be on it. Maybe there's a situation where you guys can act as a private citizen and I can nominate you guys, but at the end of the day, you guys are still going to have to follow through with that confirmation process. So let's talk about the Gaming Authority. So currently that's comprised of the board of directors. If you're truly going to have a separation, board of directors are off that, so then you need to fill it with people, right? So just like filling positions in the government departments within the tribe, we would conduct interviews, we would find business-minded people who had gaming experience, Sioux tribe members, and I would bring those names forward, and they'd be sitting right where Ryan's sitting, and you guys could interview them to find out whether or not they'd be a good selection. And then you guys would confirm them. Right? So then we'd continue to have those EDC meetings, the Gaming Commission meetings, Gaming Authority meetings. I would still chair those meetings, but I would have a vote in the event of a tie. And you need to have those separate boards if you're going to offer things like separate insurance packages, separate policies, because working in gaming is different than working in the health division, for an example. But that's how you get that divorce. And again, it's not the chairman having a crown. You would still have that board structure. However, the board of directors who would become the legislators would be out of it, just like I would be out of you guys' vote if there's a tie. Like, you have to structure these branches separate but equal. Equal is the key word. Aaron.
So some tribes actually elect their gaming commission. Little Traverse has a 3-branch separation of powers, and they elect their gaming commission. They have been doing that for 25 years. And again, the fact that our tribal board is the gaming authority and the gaming commission is endemic of why we need a separation of powers, because we have been reluctant to relinquish that unitary, all-powerful, unitary structure, autocratic government, because we're both the operators and we're the regulators. That's complete nonsense. That doesn't exist anywhere else in the world. And then we have board members that gamble in our own facilities. That's also a recommendation from the National Gaming Commission, because you're privy to information that the customers are not privy to. And while you can sign a piece of paper and you don't attend gaming commission meetings, you drive home with a board member that is on the gaming commission. So, that doesn't pass the test, and nobody respects that. Nobody respects that. The customers of our casinos do not respect that. It's a fiction. It's like a legal fiction, because we're both the regulators and the operators. So as far as the budget, before that amendment was drafted, we were running $3 million deficits annually. So the board did need to get involved. Actually, before I came on the board had nothing to say about the budgets at all. The chairman at the time would schedule budget reviews where managers would come in and they would submit their budgets, but the executive, the chairman at the time, would tell them what they could ask for, what they couldn't ask for. So I raised my hand and when are we going to vote on the budget? It's right in the Constitution. The board of directors has the authority to appropriate the funds. So I pushed for that, and that's the first year that we actually voted on a budget. Go back and look at our history. Prior to 1996, the board never voted on budgets. So let's dispel that myth that was just propagated.
My point was in 2010, though, that amendment
Well, let
had
me
nothing to
explain
do
how
with
it
the
happened
budget
then.
process.
So from the time I got elected and we put that appropriations process in place, the chairman of the tribe worked with all the departments to prepare a budget, to draft up a budget for the board of directors to approve. And if what you're trying to say is that the legislature has always had the authority on the purse strings, that is correct. And I fought to get that to happen. It didn't exist prior to 1996. So from that time forward, we did have a budget process. And then even when the board delegated, when the board did the secretary election and then the CEO title was taken out, the chairman no longer had the direct authority over the budget. From 2012, when I returned, because I don't know what happened in 2011 and 2000, I know that we bounced checks during that time period. But in 2012, when I returned, and the board delegated the authority, then I went right back to working with the executive management to draft the budgets, to do financial reviews, to monitor the budgets and spending. And we went from, again, bouncing checks, payroll checks in 2010 and 11 to balancing the budget so that we didn't have these $3 million cost overruns in the budget. And it wasn't until probably around the time that I left office again, because what we did, even though the authority wasn't delegated since 2016, what Christine and I and Bill Connolly, and what we did was we still worked with the departments to draft budgets, and we gave them drivers to say, okay, here's how much tribal support we have, here's what the budget should look like. And what happened is subsequently the board started undermining that process by saying, no, we want to know everything. We want them to be able to ask for everything. So then what happened? We got budget requests that went from 17 million, which was at the time the tribal support commitment from the casinos, to now 26, 27, $28 million budgets. And then we have this false projection that we have a projected deficit budget. Well, actually it was true, because the board wasn't giving direction. So when the board had the authority, they were not giving directions. And since I've been back, I've asked for this every February to ask what are the drivers, what should we be telling the departments, and the board has failed to do that every single year since I've been back. And so what happens is the programs draft up budgets of what they want, not what they need, and then we're faced with trying to figure out what to cut from the budget. So it is the authority of the legislature. We had to fight for it. I support keeping it there. But the executive branch, which will be the experts to understand the operations of the tribe and supervise the managers and the executives of the tribe, should play a direct role in drafting the budget, bringing it forward to the board of directors. And the board of directors has the prerogative to say, put that in the trash, we're going to do whatever we want. But what they can't do in this new draft is they can't play the game by not approving a budget, because the existing budget in the new draft will continue. So they can't play that game to stymie up the administration of the tribe. So that's how the budget process has worked.
So we have a question though. So how do we separate the board of directors from those different commissions? So does anyone disagree that the board of directors needs to be removed from those to have a true separation? No, does anyone disagree? Okay, so does anyone disagree that you guys want to be part of that process through a confirmation process to where the OGMA nominates, then you guys confirm? That way you guys would have a check on operations still, because we have to have the check and the balances. That way, if someone's nominated that's just a lunatic, has no business experience, you guys can say, nope, not going to happen, and then we'd have to go to the drawing board at the OGMA's office.
Can I say something else?
You can say something.
So part of the reason it's drafted how it is right now, I want to make sure we're all on the same. So right now, if we pass this today, Gaming Authority, Enterprise Authority, Housing Authority, they remain the same. The legislature could be on it, or other people could be on it. The OGMA's out of it. The reason the OGMA's out of it is, one, to keep that separation, but two, we spent a lot of time as a tribe building up our authorities as separate legal entities, and if you shove them back under the executive, you're losing that common control argument. 'Cause now the tribal government once again controls everything through the OGMA's office. So then you lose the ability for like enterprise to go get their own insurance, to operate under separate policies. You flip all the work we've been doing over the past.
I would disagree
20
with that,
years.
Ryan, because at the end of the day, you're still going to have our government be in charge and have oversight over this. If you completely take away every elected official of that, what's the check and balance over those EDC boards? What's the check and balance over the Gaming Commission, over the Gaming Authority? There is none. They operate completely in the dark, and we have no idea, and we have no check and balance. So my recommendation remains the same. We have to fill those bodies. There has to be oversight from someone that's accountable to the membership, right? And I say that you do a nomination process with a confirmation process with the legislature. And you do it in public hearings with that camera pointed right at this room.
Right,
Otherwise,
yeah,
things are just run in the dark.
Right, that would be fine. So my next point was, I think the next step, especially if we're separating, and I've already said this to you in our workshop about separate entities, they need to be populated by people that the OGMA,
Exactly.
like not the OGMA, not the tribal council. They need to be similar to how we do how STI does it, right? You find people that are good at the business that they need to oversee.
But you'd still have to have an elected official have their eye on it, Ryan. And if you
That's true, but you can't control it. Have an eye on it.
No.
but
You can't control it, but if you have a board, that board is going to control it, and you're going to need an elected official to chair it. And my only input would be in the event of a tie. You know, it could look very similar to the STI board structure. I'm sure a lot of those names would occupy some of these boards and commissions that we have. But at the end of the day, I'm going to be adamant that myself or whoever sits in my seat, because I have no intention of being here forever. This thing has to be built to last, regardless of who the OGMA is. You have to have oversight from our membership. And the only way to do that is to elect. We're not going to elect the chairman of the Gaming Commission, the chairman of the Gaming Authority. Certain tribes do it, but how many elections are we going to have around here? That's not pragmatic or realistic. You have to have someone in charge of the day-to-day operations of those entities, and they're going to have their own boards, whether they're Gaming Commission boards, Gaming Authority boards, but you're still going to need to have an elected official there. That's my position.
Yeah, and I think we're saying the same thing else. I'm not disagreeing with that. I just want to make sure that we're aware as we don't want the executive, we don't want the OGMA to be the person who is directing the gaming authority. That was
Their votes will be, their majority vote will be, their consensus, just like in here. Just like I don't direct this. So, Rob, Lana, Kimley, Aaron. So, go ahead, Rob.
Sorry, I was trying to unmute. Where was I? I was writing some notes down here, and I would like to read. Actually, come back to me.
Lana.
Okay, so, you were interrupted a few different times, and I was trying to figure out what you were trying to say, because I hear you, in a true separation of powers, the OGMA can't have the authority over these.
These entities should not be under the executive branch. You don't want it to make it look like the tribal government. I know they do, but you don't want it, you want to paper it in a way, for lack of a better term, to show that the tribal government isn't controlling these entities. If you want them to remain separate, like we're trying to do with having them get the ability to have their own insurance and their own HR departments and their own benefits and not be subject to the same rules as the government. We need to be very, it can be legislated, it can be done through code.
And that's
We
what
need to
we're
be
doing
very-
right now with our
We need to be
EDC.
very clear that we don't accidentally stick all those departments officially under the executive branch in the way that it sounded like you guys were talking about, because then you can disagree with me all you want, but you legally start unraveling all the legal separation that you made. I like Austin's idea of the appointment. Like, if he wants these people on the board and the tribal council confirms them, and then you have 2 checks on who is the regulatory body.
Either
That
the
works.
legislative
That
or
works.
the executive are in any role in there once that process is complete.
Not in any meaningful day-to-day
Right.
role. You'd
So
have,
I don't,
you'd
as a
build the
legislator, if I was
oversight.
picked as Speaker of the House, say they picked me as Speaker of the House, never happened, but say they did. I wouldn't get to sit and chair those meetings because I'm in the legislative branch, same as Austin or whoever's there, because this isn't about Austin, it's about the executive OGMA. They don't get to do that either, because that wouldn't be a true separation for those entities. And that's what the committee has also established with the language that they have in their.
Right, these authorities we've created, legally speaking, they aren't the tribe. They are more like they're owned by the tribe. And you guys wear multiple hats and you operate them, and it's not best practices, and I've told you that, and you've all said it in so many words today, but it's the reality we live in right now. But we need to make sure, we don't want to inadvertently make it look like the tribe proper, the government, in any of its branches. If you want those authorities to remain separate, you have to make sure we don't accidentally create a system where one branch controls them. And if it's all under the executive branch, unless we do Austin's, similar to what Austin said, which is a great idea, we don't want, we just want to make sure we build that out properly in whatever legislation we need to do.
I think another great idea is have those elected, and they come in and they're held
I mean,
accountable that way.
we have problems getting election commission now with all of our elections, and this adds more. And if we're electing all those different authorities, people are going to quit the election commission.
You might not have professional people that want to go through that process. They might want to just
I think
quietly run
I think for Sioux
businesses.
Tribe, the appointment process, if we flesh that out, as Austin said, makes more sense for our tribe than having a bunch of elections.
But then once that process is complete with the OGMA choosing, making the selection, and the legislative confirming it, we're out. Both branches are out, and then somebody else takes that over,
Right,
correct?
you would,
Okay.
you'd have the check of, you'd have oversight over them in some capacity. We'd have to build out what exactly that
Can I
looks
add
like.
one thing to that
It wouldn't-
before we
it wouldn't
move
be-
on?
They wouldn't be unchecked, right? You'd have the ability
Okay, I think I got
So Ryan, there's already certain committees, so we talk about separating, but Gaming Commission isn't separate, and now there's Gaming Authority. EDC is still comprised of the Board of Directors. The only thing that's truly separate is STI.
Yeah, yeah.
So that's what I'm getting at.
Right.
So, I mean, I wouldn't consider myself the chair of STI, but as far as Gaming Commission, Gaming Authority, EDC Board, I mean, we've talked about this right here at this table.
Yeah, so legally we're separate, even though all the same people populate it. It could be a bunch of different people populating it, and it has the same legal effect.
But at the same time, we're saying they're separate. They're not separate. The same people that sit there are sitting right here right now. That's all I wanted to point out. STI stuff, I completely agree. Okay. Kim?
I guess discussing STI stuff, they also, it's not a ton of money, but are paid for their positions, so that changes that. And who, at that time then, if we're both out, who's the oversight? Each other? Because if he's appointing them and we're affirming them, that's still, they still have to answer to somebody, the executive branch, if they would like to be reappointed. It's still holding that, you don't want to say crown, but it's a crown.
Someone has to be over them,
I'm not
though.
saying that we don't, but we need to make sure that it's all gonna work
Those-
out in the,
Last workshop, when we talked, Tyler asked, like, what codes need the most revision? There's a lot of them, but the authority codes are one of the biggest ones because of all this discussion. We need to make sure it's very clear who controls the day-to-day, who has the oversight, how is that oversight implemented, so the OGMA or the council isn't controlling the day-to-day, but they still have the ability to provide that check on the day-to-day. And it's I don't have all that fleshed out for today's discussion, but those are some of the biggest codes, the criminal codes, the judicial codes, the regulatory, like the authority codes, like those are some of the big ones that we have to take a big, hard look at in a separation of powers to make sure that they work properly, to maintain that legal separation and not have it so one branch controls controls the whole thing. And I think today, we shouldn't have any of you on any of those authorities anyway. That was what I advised to you several months ago, but we're not there yet, right?
No one's all going to resign, though.
But if we separate, it even makes it more important to do a process that gets the elected officials out of that direct day-to-day management. So that's all I want. That was my point, so.
But again,
But
are
right
we
now-
going to start offering compensation to every single one of those as we get them in there? Because that, I think, not that STI gets a lot, but, right, it's worth it for them to participate.
One of the
So,
implementation things, yeah.
because again, a lot of our volunteer committees, people don't want to be on. They don't want to take that heat and that mess that comes with that. So I think that that's definitely something that we need to think about long and hard. So that's all.
Aaron, then Mike,
So how
then Rob.
much are SDI commissioners paid? That's news to me.
I want to say like 1,000 a month or something like that, 1,000 something per meeting, and I think they meet monthly.
Okay, so that's negligible compared to what board members.
You can look it up. It's listed in their corporate charter, which you just have to Google Sioux Tribe Inc., and it's listed as a PDF on the website. Kim, do you have something to respond to that?
Is it a
I'd just
point of
like to,
inquiry?
yeah, well, kind of. I'd like to add, well, just at $15 an hour, $1,000 a month to some people is a lot of money. Might not be to others.
All right, so, okay, so one of the things that I've done in the past is I served on the Carl Levin Wayne State Government Oversight Committee for several years, along with Jocelyn Benson, who is our Secretary of State. So there is an appropriate role for both the legislature and the executive branch to play in government oversight. So we need to define what that is and what that looks like. I like the idea that you, Chairman, recommended for the chair, Orgima, to make the nomination and the legislature to make the appointments. That is exactly what a separation of powers, balance of powers is.
If I could add, it gives the legislature ultimate veto over the executive. So you guys get to veto the team that I assemble if you don't like it. Like, there's checks and balances.
Correct. And I would hope that for the most part, what we're doing when we're creating these appointments is that we're reinforcing the structures that we have evolved to already, because these new structures, which has been surprising to me that we actually enacted them, because it is letting go of some of the authority, because the legislature cannot possibly be the managers of an organization. You want people that do that are qualified, people that have demonstrated experience in that particular area. And that is the Harvard Project proposal that Stephen Kalt came up with 25 years ago to create independent economic operations of the tribe that are not subject to the political whims of a tribe, like don't fire my family member, don't hire my family member, that sort of thing. And he just retired. I was at his retirement event. When we created the first EDC, the way it was pitched to the tribe was that we have a separate EDC. This was in 1992, and I got to do the minutes of it because I was a staff member at the time. But where it became apparent that this was going to be abused is it was supposed to be separate from the tribal board, but then the chairman and the vice chairman were automatically appointed to serve on the EDC. So what we were really doing is we were creating a way to take the economic decisions away from the legislature and to vest it with the chairman and the vice chairman. And I didn't support that then, I don't support that now. I think there needs to be good coordination between the executive branch and these semi-independent bodies that we created that separate structure for a reason. One of them is limit liability. That's important. They should not have the ability to waive sovereign immunity. That always should rest with the tribal council. Or if we enact a code that defines the delegation of that so that they could do it. But no entity should be able to create a liability for the whole tribe. So I think we can find that compromise. But I just want to echo something that Lana said. Lana just did a master class for demonstrating why we need a three-branch separation of powers. Because then the chairman's not in full charge, the council's not in full charge, but there's a combination, and the chairman or Ogima can't make an appointment without the ratification of the legislative branch. So the legislative branch has a lot of power and authority. Of course, they could play games with it, and they could say, I don't like Austin, I never liked Austin, I never voted for him, and I'm never going to support any of his nominees. But the longer that goes on, it becomes apparent to the people what's happening. So that has its built-in disincentive, and that's the recall. Because if the legislature plays those kind of games with the appointments or with the appropriations, then the people can come back around and say, you know what, you're not serving our needs. We voted for the OGMA. We want you to do your job separate from the OGMA's job, and we're not going to vote for you if you keep playing that game. So I do think what you suggested is a good suggestion, which is the nominations are made. I also think maybe we could do some kind of ex officio role, but not a voting role from the administrative branch. But what's really going to be needed is to articulate a oversight code that defines what the chair and what the OGMA and what the legislature's role is in oversight. Because it is appropriate. If a budget's being spent crazy or if they're doing risky investments or whatever, the legislature should be able to schedule a hearing and subpoena to get people to come in to testify so they can answer to the government. But they should be able to independently operate. So we take the politics out of the Gaming Commission, the Gaming Authority, the EDC, Sioux Tribe Inc., Housing Authority, whatever structures we create should be independent.
Okay, Mike, then Rob.
I guess I take a little bit of a different view than most, I think, here, because I think there's room in here for compromising, because I do, whereas I don't think that the executive branch should be over gaming and enterprise for what you stated. But I do like the idea of you appointing them. So, but I also think that things like like health and housing, though, you probably should be, because that falls under governmental. So I think there's space in here that some of the authorities are going to have to still report to the legislative branch, and some of them looks like it could probably report to the executive branch, preserving those silos, because I do think the silo conversation is worth having. So I also don't think it should be comprised of all board members, but I'm not opposed to one board member being on those authorities, because I do think that helps maintain the relationship there. I think it keeps everything flowing. So I don't want to say that no board member should be on any of these authorities, because I do think it helps. It helps in some of the other committees that we've had in the past, and still. So I'm not ruling anything out, but I do appreciate you pointing out that, there needs to be some separation there to keep those silos going. I appreciate, the appointment process, but we do need to figure out which is which, and that's one of the things that's not in this draft, is that we don't touch base on all those things, and this is the time to have those conversations. So I do think that there is room for compromise here, though, so I would support like one seat being by the board, and it could be even someone that you point. So, yeah. And I guess I'll leave it at that.
So Rob, Mike gave me permission to respond to that. So if we're making the argument that all government has to be out of these commissions and committees and everything else like that, at the end of the day, we're still going to need to figure out how we have authority over them, because we can't let them manage our tribal resources without some form of oversight. So if I'm not going to be the chair of those, the non-voting chair, they still have to report to the OGMA's office. If we can have room to potentially have a council member, because we're going to change the board to the tribal council, which is more culturally appropriate, but at the same time, that has to go through that same nomination and confirmation process, because at the end of the day, if there's going to be a true separation, you can't point to anything in state, and there's 50 state governments, and we have a federal government. You can't point to any of them that report to the legislature. They report to the executive branch for the same reasons that the membership wants this. They want a clear, concise person at top of it to hold accountable. And there will be checks and balances on this. Like, I think, at the start of today, like, this seemed more scary than it was, but I think as the conversation progresses, we can see that there's more. These branches are separate and they're equal. There's checks and there's balances. The OGMA could be a terrible guy and veto everything, but on the flip side, the legislature can vote to not confirm every single department head that the OGMA puts forward. I mean, political games can be played on both sides of this, and we haven't even really examined the way that the courts can. But I mean, at the end of the day, if it's a separation, the council's got to be out of operations. You know what I mean? And Ryan, if you're saying that, all government needs to, I mean, I can compromise, I can be out of those committees, but at the end of the day, there will still need to be oversight. Otherwise, how can our membership hold someone accountable if we have this board that's completely separate from the tribe, waiving sovereign immunity if that were to happen, entering into terrible business deals, things of that nature? There has to be some sort of recourse from the membership. That's all I'm getting at, basically.
So we've been talking a lot about what essentially H. I've blown it up a little bit more on the screen, but I have some red line language that maybe I think gets to the potential compromise and leaves a lot of it to legislation, which is probably appropriate, right? So you could give the legislature the power to create by ordinance these legally separate authorities, which we have already done, to manage the business, gaming, or enterprise needs of the tribe, or other necessary authority owned by the tribe as may be needed. And then in parentheses, you give to the executive, the Ogama power, to nominate appointments to the authorities as enacted by law, subject to tribal council approval. And then you have, in the Constitution, you have the basic structure, and then you're gonna have to flesh it out in legislation, but that's appropriate. So it's something like this, I think, kind of blends a lot of what our discussion was today.
I agree.
For Constitution language.
Yeah, I agree.
So.
Rob, then Aaron.
Well, I don't got to repeat a lot of what you just said because that's basically what I had down here on my notes. I don't believe that the legislative body should be on these committees, but I do believe that an appointment process is needed. I think the chair's nomination and the council's affirmation, that makes sense to me. It's all people who were elected by the membership, and it creates a check and balance. So basically, I think that was correct in stating that. Another thing I'm going to go back to real quick is the 2010 amendment, because it was stated that I said something that was inaccurate. So I'm just going to read here. April 7th, 2010, the Sault Ste. Marie Tribe of Chippewa Indians adopted the Second Amendment to the Constitution, which deals with and addresses the Article 2 of the bylaws that changes the Constitution and removes delegation of chairperson's authority under the executive branch. Stephen J. Morello says that essentially what this does is remove the chairman's delegation of any budgetary authority from the process of developing the budget, as well as his oversight of setting and determining the policies of the executive office of Sault Ste. Marie Tribe of Chippewa Indians. So I did not say anything inaccurate. It's either the person that said I was inaccurate didn't understand in 2010. The attorney was wrong in how they explained it to you guys, or what I said is accurate. So and this amendment doesn't change that again, because we are not putting the budgetary authority in the chair's office. The council will still have that authority. It's the chair's office to develop or to help it develop a budget and present it, if you read the article, to present it to the legislative, who then will approve or deny. So the authority still remains in this document, does not change the 2010 amendment. It still remains with the council, as well as setting and determining policy and procedure for the executive branch that was clearly included in the legislative branch. So, I mean, you could say I was wrong, but I'm literally reading it from the Sioux Evening News, and your lead attorney said it. So it's not me. That's where it came from.
Aaron.
Yeah, and the person who wrote that, Steve Morello, was an at-will employee of the Board of Directors, so, and it was after the fact. So he wrote that based on what the council expected him to write. And I can get a written statement from Steve Morello that will clarify that. And then the board did fire him and had to pay out $600,000 for the liability on his contract. I wasn't on the board.
It is written. It doesn't get any more clear than this to me.
Yeah, and I can get a clarification if you'd like it from Steve Morello. But my question is the council why are we talking about appointing council members to serve on these bodies? I don't believe that came from the Constitutional Convention Committee, did it? So they wanted a separation of powers through a branch, but they wanted the legislative branch to be able to get their fingers in the operations of the tribe?
This is one of those inconsistencies that I think maybe has been flagged before. We took some of this language and put in here to try to craft something that maybe would keep that separation that we're trying to build out, although obviously that's not what I think is best practice. But in the 2008 draft, it says no council member may be elected, appointed, or employed in the judicial branch, makes sense, in the executive branch or in any other government or its political subdivisions in a capacity, blah, 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 consultant, some other language, except that the OGMA and council members who are otherwise qualified may serve as unpaid members of the business board or any gaming enterprise owned by the tribe and operated outside the territory.
So that came directly from the committee?
Yeah.
So I think to give fidelity to what they were asking for, if they're unpaid and ex officio, because the problem with having them be on these other commissions is because then they will wield power and authority by being a voting member that could, direct it one way or the other. And the example of why the people voted on that 2010 amendment, I know we always want to focus on the chairman, but the reason is because we had a rogue cop who was voting on budgets directly related to themselves, who ended up indicted and going to prison. That's why the people, just a year and a half after he went to prison, and the board paid out his severance, which I don't understand why, because he had a felony conviction.
It would have been $400,000 if we didn't.
But he had a felony conviction, which it preempted us from having to pay anything out. All those contracts stipulated that if you get a felony conviction, that we don't have to pay anything. And I know that the payment was made the night before he was incarcerated, so he got to cash the check before he went to jail. But the reason why the people at that time voted on that is because they didn't want somebody on the legislative branch to also be in the executive branch to have that kind of concentrated authority. And so that's why I don't like this, but I think I could concede to it if they're unpaid and ex officio on those committees. Otherwise, because here's the thing, they hold the purse strings. You're on the commission. They can say, I'm not going to vote for your budget unless you agree with what I'm proposing. And that creates a conflict. That's a definite breach across the separation of powers. But if they're ex officio and non-voting, I think I can get comfortable with it.
Lana. Then Rob.
Well, I thought we moved on from it, but, we have lots and lots and lots of legal opinions from different attorneys. Some we fired, including the one that helped with the Constitutional Committee. We fired him during a business meeting for his conduct and his role in sitting with board members at that time when he wasn't supposed to. So we can talk about that at a different time, but and I will say that ever since I was on the board, and I'll give credence to you, if you enacted the laws that said that the executive branch or the chairman couldn't pass a budget, when I got on in 2004 and since, the tribal board of directors always passed the budget. The chairman never did. So when it was stated that we changed that in 2010, we never had that prior to 2004. When I was on it. No, someone else did. So I just wanted to make that point. Whatever someone wrote a legal opinion, there's plenty of those going around. Some of them are accurate, some of them aren't. Some of them are made up. Number two is Austin has, and that is a good point that you make, Ryan, and Aaron had to clarify it, because that'll be another major change that we're deviating from the original committee, because under H, it says council members who otherwise qualified may serve as an unpaid member of the authority and the enterprise. I'm not saying I agree with that. The point is, that's in the original 2008. Austin already cited that and came up with a solution. Mike said the same thing. We could put maybe one person on there. The point being, that's in the language from the committee. I support that. Okay, so however we figure out moving forward, that is the language. So having this discussion is good. So, and I had another thing, but I didn't write it down, and I get all worked up.
Okay, Rob, did you forget you put your hand down?
Yes, I did.
So what I'll say is this document isn't perfect. It's not a golden document, otherwise it would have passed 20 years ago. There's already things that we know that the original committee wanted that we've taken out, such as being employed by state or federal government. So when we get to the authority of the OGMA, I imagine there's going to be things that you guys are going to want to take out of there as well. If you want a true separation, council's got to be taken out of this, period. I don't need to be a part of it. If you guys don't want me to chair it, that's fine. We can do a nomination process and a confirmation process involving you guys, but it has to be separate. Otherwise, we didn't really change a whole lot. We have to have separate but equal branches of government, right? Okay. Let's keep going, Ryan.
All right. Am I putting a pin in this H for now? Or do you want to, okay.
Well, I mean, I haven't heard anyone talk about these bodies still being occupied by the legislature. I mean, does anyone disagree? If you're going to have a true separation, you got to have the board out of operations that manage day to day. Like Ryan's saying, we shouldn't be involved in it even today. So does anyone disagree with that? Yeah.
Who do they report to, though? And the oversight's got to be defined. And
It has to be,
yep. Two of them should at least be legislative. The others are open, or I guess just as long as we're on the same page.
I think that's what we have to flesh out, and each authority code is going to, it might not be, they all report to the same branch. Maybe they report to different branches. That's a discussion we have to have for implementation as we, but I think if we give the legislature the power to create the authorities, that makes sense. The OGMA, the power to nominate people to sit on those authorities with confirmation from tribal council. Then in our constitution, I think we have the language we need to then flesh out the actual process and oversight in code where it's supposed to be.
Yeah, we're going to need oversight on it, Mike. You're absolutely correct. But at the end of the day, if we're going to have checks and balances, the legislature will have created this through legislation, and you guys have the final say who sits there. You know what I mean? Like, asking for oversight is not a big ask if I'm already doing it for government or who's ever sitting in my seat. So we can circle back on it if we need to, but.
Or if the majority and that are on this table is fine with the red line language, then that's the language we can use in the Constitution. We can settle it today.
I would say that's accurate, but then we're going to have to figure out oversight later on. So it's.
Yeah, and that's
nominate, you guys have the final say who sits on there.
So, all right, we skipped F and G, so I'll go back up for a second. F and G. F, to adopt resolutions, ordinances, and code providing for the licensing, regulation, and control of non-tribal persons coming upon or being within the territory or jurisdiction of the tribe, excuse me, as defined in this Constitution for the purpose of recreational boating, hunting, fishing, trapping, gathering wild rice or other fruits of the earth, or other usual rights of occupancy. This is kind of a mashup of stuff that was in 2008 and stuff that's in our your guys' current powers.
I would agree with all that. It should be a power reserved to them.
And then G, to create by ordinance regulatory commissions, subordinate organizations to establish, or subordinate organizations, and to establish rules and procedures to regulate all meetings of the tribal council, standing committees, special committees, or other regulatory commissions or subordinate organizations created by ordinance.
Okay, go ahead, Aaron.
I don't know if organization's the right word, if it's entities.
Yeah, I like entities. I think I used organizations because it was in the 2008.
Yeah.
Okay.
Because
Mike?
organization suggests like going to the state and getting organized under the state, but it's entities that we create.
Right now, like, we have a provision right now that allows our chair to intervene, because sometimes legislative bodies can't intervene quickly. So I understand what we got F, we're putting it solely on legislative. Is there a provision that's going to be to address that part in the executive branch?
Yeah, so it's
Are you talking about the fisheries, Mike?
The fisheries.
Like they crash and you got to shut them down right away?
If something's got to happen immediate, I mean, that right now, that power rests in the chair to be able to do that.
Right now, the power rests with the board, and you've delegated that emergency authority to the chair.
Is that the way
You
it's
guys
written?
could technically
So
still pass a law that delegates it to me if you'd like.
Yep, F would still work the same way. You adopt the ordinance, the law that this regulates the fishery, and you can give that same emergency authority we currently have in that law to the to the chair.
I just want to make sure that we didn't, or that
Yeah,
it's covered. So if it's covered, it's
I think something's
covered.
getting missed, though, because there are some things that are in the, well, I don't know, because we're not a party, we don't agree with the decree, but there are some authorities vested with the executive or the chairperson that we, unless we want to go back and amend that, all of that. So I'm confused about where we're at, because there was a time when the board didn't like me serving as the delegate to Cora. They wanted to make the chief of police / board member / convicted felon that person, and they couldn't, because I got a legal opinion, and they had no authority to, because it was in the decree. So we want to make sure that we're not running afoul to wherever we end up with the decree.
Yeah, and so, and F is just right now talking about the non-Indians, right? That we have the ability to regulate the non-tribal persons who are coming in our land and trying to use our resources. That's really what F is trying to cover right now. Not so much the stuff with like the decree, right?
So I guess I'm requesting you review that carefully, because like, again, if we were in the decree right now, that there's authorities vested with the chairperson. And I suppose if we put it in an amendment, then we would have to go back and change whatever agreement we have in a decree. But we're in a weird situation right now, because we are not in agreement with the decree at all.
Yeah, I'll double check on that, Aaron. And also, it's further down in the OGMA section. The OGMA is the case now. The chair is this, but it's explicit in this draft too that they're the representative of the Sioux tribe. And as a representative, if the decree says the tribal chairs or OGMAs have certain ability, that would be in line with the way this current constitution is drafted, with them being the representative of our tribe in the Constitution. Do representatives at the table for negotiations, for Cora stuff? That stuff would all be consistent still. Okay. I, to employ legal counsel. You have a separate branch. Each branch, not the judicial branch, but the legislative and the executive need to have the ability to have their own legal counsel. J, this goes to something Austin said earlier about, like, as we separate out and we have the different government directors, the OGMA appoints them. So the legislature has the power to approve appointments made by the tribal OGMA to the tribal court and to the key executive positions within the government. So the chair, the OGMA, has the ability so for the tribal court, right, it's obviously the ones up above that he can nominate the associate justices, or if no one runs for office, he can nominate another attorney, and then tribal council approves it. For the key executive positions, those would be the executive positions of the different areas of the government. And we talked about it earlier. The OGMA would nominate this person, the tribal council would confirm them.
Okay, Aaron, then Lana.
So when we were talking about this earlier, I think some were intending that let's see, the boards of those be nominated and then appointed, but this wouldn't allow for that.
So this is within just the government. So the authorities are enacted by the government, but they're separate from the government proper. So the authority codes would rule those different authorities, like gaming authority, enterprise authority. But like if we had a CEO or a general counsel or a CIO of the government, all those key positions we have now, this puts the power of those key positions that are within the tribal government structure, not necessarily an enterprise structure. That's something we have to talk about later.
So, but I know, but what I'm concerned about is, we're kind of talking about it now, we're in agreement right now, but where will that authority exist? Will it be in all the separate authorities? And those could be created and not consistent with the intent that we just talked about. So, like, let's say the gaming authority, we get to the point where the OGMA nominates the members of the gaming authority, whatever that number might be. All of these committees, by the way, can be much more efficient in smaller structures, right? But the OGMA make the nomination, and the legislature ratifies them. So, but this is not read that way. So where would the authority for the legislature to make the appointment per the recommendation of the OGMA? Where would that exist?
For the authority, for the authorities?
Yeah.
Yeah. So we're changing H to give the legislature the ability to create the ordinances and that, or the authorities, excuse me. And then we're going to add 9H, but in the OGMA power, the power to nominate to those authorities, subject to tribal council approval.
I just want to close this out, is that needs to exist in the OGMA authority, it needs to exist in the legislative authority as well. Because the authority to nominate exists under the administration, executive. The authority to ratify will exist under the legislature. Because if we don't
So, yeah,
get
we
that
can-
pinned down,
Right,
that'll end up
I
in
see-
litigation.
I see what you mean. Yeah, so we could add that, we could just add that to J or to H, the authority to not only create the authorities, but to approve the nominations to said authorities. Yeah.
Lana, then Mike.
And J does include like the CEO, the CFO, the general counsel, all of those executive positions in the tribal government.
Yeah. The simple answer is yeah, but
Yeah,
the longer
that's what I
answer is
wanted.
we have to have a bigger discussion on all of our key employees and how they will fit under our new structure. But the simple answer is yes. But it's not that simple.
Right, I know it's not that simple, and I don't know when the appropriate, when the appropriate time to have that conversation is so that we understand that. Because again, the intent of the committee is to, have the OGMA make those selections, the legislation ratify it, but we have existing members in those positions now. So, and that question does come up. I don't know if it comes up to everybody, but it's come up to me. So we have to understand how we're going to go down that road. And I've asked the question before, and we've said we're going to talk about it. I mean, that's another big question.
My interpretation is you guys would have the final say.
Well, we do, because we
Yep,
have to
yep.
ratify what you
And
asked for.
everyone there would continue to be the executive team, but if there's any changes, you guys have the final say. Unless you guys legislate that key employees look differently than what they are, meaning we subtract certain people from having that title of key employee, or we add certain people, and that would be up to you guys.
Okay, I think okay, I'll
Yep,
listen.
Mike, then Aaron.
I don't disagree with any of that, but on here, like, it says to employ legal counsel, and we had talked earlier about maintaining and retaining our board administrator and their staff, but it's not constitutionally going to be protected then? So I guess, do we need to put that in here as well? I just want to make sure that, because you did state it earlier that we would retain that, but this doesn't show that it's a constitutional protection or anything like that, that we don't have that ability to maintain that. So I just want to make sure that we're covering our bases. And I don't know. if
I would
we
agree
did
with that, Mike.
to
Yeah.
So we
employ
can
legal
add to
counsel.
I,
You guys need support staff, and it has to report just to you guys.
to employ legal counsel and necessary staff, and we can add to J,
Okay.
to approve appointments made by the OGMA to tribal court, duly enacted authorities pursuant to H, which covers Aaron's question, and then to key executive positions within the government. So then I think we have maybe have everything covered that way.
Okay.
Aaron.
So I'm glad you raised that because it's been unclear in the past. And I know when I left office in 2008, every single person in the chair's office got fired, every single one. And tribal members that commit to working for this organization, what the federal government has as the Pendleton Act to prevent patronage and seeking patronage. It seems kind of impossible in this environment right now at the federal level that exists, but it does exist. And actually, the Supreme Court just actually ruled that the president does not have the authority to just simply fire people. But the legislature will have the authority to establish those positions in their budget. And when we do make this split, the chair won't carry any of those staff continue under the chair. But the one provision that we should probably equally put in the draft is staff for the chair. because that was always debated, whether or not the chair should have any staff. And right now, the chair doesn't supervise even one person in the organization of the tribe. Tribal members find that to be very strange and very odd. They don't agree with that. The vast majority do not agree with that. So the chairperson should have their administrative support staff, because the work of the chairperson of the tribe to receive all the grants and contracts, to be the oversight of all that, the signatory on all of that, that takes work. It takes a lot of monitoring, and she's here right now. And I think that surprises, some board members that don't understand the full breadth of all of that work that has to happen. So I think we should equally put that in when we do the OGMA's authority. We put it in the Constitution so that it's understood it has to happen. Then it's still subject to appropriations. There was also something else I was going to say. Oh, the other thing is, so the President of the United States or the governor doesn't, well, the governor not at all, but the President of the United States has to nominate positions and the Senate confirms them, but it's not every position. So I think our executive level positions, I think, should be nominated by the OGMA and ratified by the council. And I would hope that for, at least for a period of time in transitioning to this new structure, that we nominate people who are already in those positions.
Absolutely. I support everyone that's in their current executive level position. You guys know that. Like, advocated for Ryan, Jess, Holly, everyone. I don't consider those to be political appointments, that change with a new president, OGMA, whatever you call it. Those are 9-to-5 positions, and we have working class families that depend on those jobs. So absolutely.
Hearing that, I think we should consider drafting up something like the Pendleton Act and that prevents patronage, because what I don't think most of us on the board want is that when we change chairs, we gut the staff that work for the tribe. The staff that work for the tribe try to do their jobs non-politically. They do their best to kind of balance out, but they shouldn't have to worry about losing their job if we change chairs or OGMAs, and we have to then go back through a nomination process. I don't think we have to go through all of that. I don't support going through all of that. So.
I agree with you 100%, Aaron. Rob.
I just wanted to circle back to Mike's suggestion to put, to lay out the board office support. I just want clarification. Did that pass? Did we add that unanimously, or are we going to poll on it? Because I agree with Mike on this, and I think that it needs to be in the Constitution.
I don't think it needs to be polled. I support that as well. You guys are entitled to your support staff. You guys need it. Does anyone oppose it? Okay, it's in there then.
Oh,
yep, absolutely.
Okay, thanks.
Yep.
Thank you.
Did I miss anyone's hands, guys? Okay, we can keep going then, Ryan.
All right, K, I think we're on K, to enact a public legislative process for the adoption of resolutions, ordinances, laws, and budgets. This is a little different. This is a lot different than what was in 2008. They had fleshed out a very long process of how the legislature would do 30 days notice and comment periods and all these things that are best left to code. So we've taken that concept of their ability to create a legislative process and put it as a power of the legislature, but didn't flesh out what that legislative process is. I think it's best left to code. But just, we're all on the same page. 2008 fleshed out a huge, long process for how to enact, like everything tribal council needed to do before they could enact a law. And that's not included in this draft here.
Aaron.
So I support not having to articulate it all out because it can be legislated, but I also think we need a minimum standard established because the people of the tribe should be part of the process when you enact legislation. And at the state level, at the city level, at the federal level, any laws that are being contemplated, there's opportunity for the citizens to weigh in so they can advise their elected officials whether they support something or don't support it. And right now, I think we have don't think we respect that. I don't think that we have that structure currently. The Constitution requires a minimum of 5 days' notice. We have a couple of ways that we can call meetings that do not comply with that. So if we had a separation of powers, we could file a lawsuit on that. But I think that we should have at least some kind of minimum established. Right now, the minimum is 5 days' notice. I don't think it needs to be overly cumbersome and elongated, but I do think we need to have in the Constitution the requirement for notice and comment, the minimum standard for the notice and comment.
Keep going, Ryan. Oh, Lana.
Thank you. Yeah, well, another major change if we're taking it out, you know, if they had it all cited in there, and who, did this board already take it out, or did we?
Nope, I took it out. I mean, it's separate, I mean, I didn't take it out originally, but legal recommended taking it out and putting it into legislation, and I agree with that prior advice from prior legal counsel. Was it 30 days? It was, 30 days before? Yeah, it's, each proposal on budget, it needs to be in a bill. You have to conduct at least one public hearing in a district, a unit, they called it district, in a unit held outside of a normal legislative session. The council could compel evidence records and subpoena people for hearings on the bill.
Well, even just.
You publish every bill in the newspaper at least 30 days prior to a vote, unless it was a budget modification. I could go further.
Yeah,
Those were
you don't have to, that's my point. You just made my point, because, you know, we talk about, we'll stick to it a little bit, you know, we'll stick to it, minor changes, major changes, and I think we're getting somewhere. There's going to be changes, definitely, but, you know, thinking back to both 2008 and 2012, those are big, huge things where, you know, that's where you put the power to the people so that they have the say in what the legislation's going to do. So, I know it's cumbersome, but, you know, they spent a lot of time on that. And again, when we ask people to have input on us passing that, they're thinking it's that. So, you know, legal took it out, and I understand the reasons why, because it's cumbersome and it's a lot, but it's also what was in there. So, I don't know the answer moving forward on how we, but those are big, huge issues that they put in there. So I'll just say that, however it's going to go, I probably wouldn't just sit idle and say, let's just take it out and figure it out later, though. I wouldn't say that, but I'm probably in the minority.
So Ryan, I was using the restroom. Could you fill me in with what this is about? Is this about the requirement to notice what's being voted on?
This is K on the draft that currently reads that the legislature has the power to create a legislative process for the adoption of resolution, ordinances, laws, and budgets, as opposed to fleshing out, like the 2008 draft did, what that legislative process looks.
So we're basically saying that the legislature will create the process for how many days to notice it, rather than mandate what the minimum days of notice is in the Constitution?
Right, it gives them the power to decide what the appropriate notice is, whether there's a comment period.
And they had all that in there already.
They had that in there in the 2008 draft. I was also directed to not put a bunch of stuff back in that was not strictly necessary in a separation, and this is one that isn't strictly necessary in a constitutional separation.
That's past legal directing that?
No, this was directed at the last workshop, or the
board.
By the board, to try to make this just the areas that are like actually expressly needed for a separation, and without all the extra stuff. So that's partly also why it's not in there. You don't need to flesh out all the process and legislation to separate. You just need to give the power to the legislature to be able to create that process.
Okay. All right, I have Aaron, Isaac, and then Mike. Real quickly, though, could you scroll down to see how much more we have to go through to finish this section? Because it was my goal to finish this section before the day ended. We got 5 minutes left.
We have 1, 2, 3, 4, 5, 6, 7 more.
But we might not have any comment on
They
those 7
should,
more. Right?
I don't want to jinx it, but yeah, they might not have any.
All right, guys, you guys want to be concise and use this time efficient, see if we can knock this out? I got my kids' Christmas, so does Ashley. We're both getting out of here very quickly, okay? So go ahead, Aaron.
So maybe towards the end of the day, it'll be a Christmas spirit feeling, but I agree with Lana. I was just trying to figure out how we can accommodate, because this should also apply to any of those commissions, right? So if we're creating a notice and comment requirement, it should be applied to all of the entities under the tribe, which includes the Sioux Tribe Bank, the EDC, and we could create a very cumbersome process. I'm 100% in support of notice and comment. I was trained on that. My graduate degree is specific to this. So I think that we can legislate it, but I think what we put in the Constitution has to be non-ambiguous, so that whatever we legislate is consistent with the Constitution, and if it's a 2-week or if it's a 1 month or whatever, I think 1 month is long. Maybe we don't need that for a month, because whatever we enact here should apply to all those other commissions, and we might be creating a structure that they can't operate within. So I'm in favor of keeping it as they drafted, but I'm also supportive of writing language that can be then, legislation can flow from that and be consistent with that.
Okay, Isaac.
Yeah, but Ryan, isn't that what you're saying, though?
Could I add to that? How do you have an emergency meeting if you have to pass legislation? Let's say,
I was just going to say.
We're sued and we have to have a settlement, but you have to notice it 30 days, and the plaintiffs want their money right away. Like, that's one of the barriers to this thing. Like, we can still notice it, like 5 days, but 30 days does create a lot of barriers, you guys.
Yes.
Think of the different examples that we've had while we've sat on this board, and think of, okay, we have to press pause for 30 days before we can pass it. It puts us in a difficult position.
If you put a minimum, at whatever timeline, whatever time, unless it's 5 days maybe, but almost whatever time you put in here, if you lock yourselves into a specific time that you have to notice it, you're going to run into a situation where, oh, crap, there's something that's an emergency, and now I can't act because the Constitution says I need 15 days, unless we build also in some kind of emergency provision into the Constitution.
Yeah, and that's my concern, right? Like Austin stated, we're going to have times that we're going to have to act immediately, right? And that could happen tomorrow. I mean, so what if we have to wait 30 days? That might be too late, right? And it could cost us a heck of a lot more. So how we adjust the time thing is to put it somewhere else where it can be legislated.
Okay, Lana.
Yeah, and I only brought it up again, and I know that I want you guys to get to your Christmas party.
No, it's good. They had a power outage at JKL, so canceled.
That's a major change, because the legislative process is they spent time on that, and they enacted timelines, and I can distinctly remember them talking about it in 2012, the timelines, in order for them to know what's going on, for transparency of what the legislation's doing. And let's not forget that that's why we want the change as well, for transparency. So the happy medium in my eyes would be, the norm would be to add that stuff back in, but also an emergency provision that has to be justified. So if we go down that route, the Ogima can say, we need this waived because we're going to be sued, but there's a justification and there's a history stating that, and not to be abused, because again, there's checks and balances, but the other, just from a member looking in, if there's a process in place for them to know what we're doing in a timeline, that's a major change by us taking it out.
Yeah, I agree. It's a major change. You and I are never going to see eye to eye, Lana, on that being in the Constitution, I will, you guys don't have to agree with me, of course,
Right.
but I will,
And you don't have to
I will always say that it should be more broad in the Constitution, so you legislate the details, and I'll die on that hill, and maybe I'll lose, but that's all right, that's
Right.
fine, so.
And you never have to agree with me either, so we can do it respectfully.
So put your hands up, you guys.
It was me, then Rob, and then Kim.
Okay, one second. Aaron, Rob, Mike, Kim. Okay, and we're not going to rush through this, okay? If we need to just break for the day and get back to this tomorrow, we're going to do it. We're not going to do a rush job. So at the end of this discussion, if we're not ready to poll on this item, then we'll handle it tomorrow, okay? Okay, Aaron.
So I'm supportive of an emergency provision. We need to be specific and unambiguous with whatever we draft for that. I think if there's a risk to the tribes, either liability would be the main one, because that could cover financial liability or some other kind of liability. But I also don't want to leave it open-ended. And the reason for that is because, and I'll be general in how I say this, so nobody has to think I'm talking about them, is in the past, we've done things at this board level that I don't think are consistent with the Constitution. Right now, the chair has the ability to schedule a meeting, and because some board members disagreed when I was chair with when I would schedule meetings, we created this extramural ability for the board to cancel meetings. That doesn't exist in the Constitution. And if we had a separation of powers right now, we would be able to take the board to court if they did that. So I think it needs to be clear and unambiguous. I think it could be generalized and stated generally so that we can then legislate it consistent with the general legislation. I think a month is a long time. I think 2 weeks maybe would be more tenable. But if we put in that a minimum standard of 2 weeks' notice, and then the legislature can fully enact what that looks like, whatever. But I do support what Isaac said for some kind of emergency provision. But the other thing is, we can't just have discretion over deciding what's an emergency or what's foiable or whatever, because that's the structure we have now. That's arbitrary and capricious, and it's a violation of your basic rights as a citizen. I don't want to get to that point. So whatever, I think general statement of what that notice and comment is, and then we can further articulate it out in legislation, but having a provision for an emergency provision.
So this seems like it's an issue that we're not going to be able to finish. So we're going to poll on this tomorrow. I'll finish the list, but I think it would be helpful to have our executive level staff here to talk about that, because how many times did they forget to put something on an agenda with just 5 days notice, and then we had to waive rules to add it because we might have missed out on a grant opportunity or something like that. So I think that's why Ryan has the position that he has, is because he's in operations, we're in leadership. He's seeing how this is practical and how it's pragmatic. So let's pull on this tomorrow. We'll finish the speakers list and then we'll pick up on it. But I think we should have Danny here. We should have Alan here. We should have the other people that have to live with the decisions that we make here. So Rob, Mike, Kim.
So it appeared that Lana and I were not in agreement on most things today, but thankfully, here's one thing that I can honestly say that I would not have said that any better than Lana. She's 100% right there. There's a reason that they put that provision in there. I also agree with Aaron and Isaac and Ryan that there needs to be some kind of emergency thing, and I think Lana said that as well. But the 30-day notice on many things is perfectly attainable, but we do have those situations where we need to add things on an emergency basis. But the provision for the 30 days was not just to slow down the legislative process, but it was to give us time as legislators to communicate with our constituents, to get feedback from them, to figure out how they would like us to approach the vote, which is essential, because a lot of times people will throw things on an agenda. Well, I got 5 days to communicate with members, and I don't just vote on everything based on how I feel. I gauge the membership constantly, and I'm very engaged with the membership. So I agree with what Lana said here, 100%. I think we put that back in there, but then establish an emergency procedure for things like, you know, if a ransomware attack, or like Austin suggested, if we have a grant that we're going to miss out on. We still need a provision where like right now, it takes 9 votes to put it on an agenda. I think we need that, but I also think that, like Lana said, there's a very specific reason they put that in there. And they spent a lot of time drafting it, so there was a lot of thought put in there. So I'm in agreement with Lana on this.
Okay, Mike, then Kim?
I guess just to, I mean, I appreciate the legislative process. I agree with you actually on that it should be, but I do think you need a bare minimum notice. I don't think members deserve a notice. So I think it should be constitutionally protected as well as a bare minimum. It's almost like we would have benefited from tiers, like, this many days for standard stuff, then have special meetings for this kind of stuff, then emergency needs for this kind of stuff, notice. I don't think that's very practical to put it in here that way, but I do think it needs a bare minimum of notice in here, because I don't think we should legislate to be able to do 24 hours notice on anything, so I do think there needs to be a bare minimum in here. But I also think that if we're going to do special meetings or anything like that, it needs to be defined. We can't, we use it too loosely. So if it could state what like some provisions in there, like it's legislative, it's grant opportunities, property sales, those are probably things that are going to come up. So we have our special meetings that we've called. We can see what types of those are. We can identify them. So are we going to be able to identify them all? No, but maybe that's when we need the public input anyways. So, but a bare minimum should be in here, and I think we should put a little bit of constitution protection in here of what constitutes special meetings. I don't think it should be a carte blanche special meeting, and we can add stuff. So, yield.
Kim, then Lana, then maybe we can adjourn for the day?
Okay. I think it's not going to hurt my feelings if we change it from the lengthy time down to half the time, because after sitting here, I can see how things need to get done quicker, and a lot of our stuff we vote on is basic leases, different things, you know what I mean? And, but I agree there has to be that emergency provision in there, because just a couple weeks ago, we had something with EDC that had to be done quick, and something's got to be signed, right. So that emergency provision has to be in there, but I'm okay if the timeline gets cut down to 15 days, 10 days.
Yeah, and the authority codes, not to cut you off, Kim, the authority codes right now do allow for those shorter notices.
Emergency.
And this is, the intent of this is for the tribal council's process, not necessarily all the authorities' processes. Those can be left to code. They don't have to follow necessarily, unless you want them to, all the public legislative process.
Okay, that's where I was thinking we might get, like, if they have to wait 30 days, and then we're saying, okay.
There's stuff that with Kuwait and Enterprise that even waiting 14 days, it might not be an emergency, but it might be urgent. It's yeah, there's all kinds of things we gotta figure out.
Okay. Lana?
What a good way to end the day, me and Rob agreeing on something. So, but I really think that we can recognize both, because like I said, and other people said, that legislative process can go in there because they worked hard on that, and it doesn't deviate majorly, we used that word earlier this morning, majorly on what the committee wanted. But right now, it's a simple fix, because right now we have a legislative process in the works for the chairman in order for us to get grants that we can't get on the agenda. We have a resolution right now in existence that gives him authority to do that. And it's simple. It didn't always work all the time, but we have that in place right now. So if someone comes to Austin and says, I need this by tomorrow at 2, and he doesn't have the authority, he can sign off on that grant. And we can simply do that legislatively with an emergency policy waiver once it comes to that. But again, they spent a lot of time on that, and that is a fundamental key on what they wanted in that for transparency on what the legislative portion was doing.
Okay, closing comments. Let's think this one through. let's come back to this room with clear heads. Let's think of our time on the board. We obviously have to have a minimum requirement for noticing what we're going to vote on, but we obviously have to have provisions to pivot in the event of an emergency. Other than that, we did a good job today. We got through a lot of this document. We had some arguments, but everyone, for the most part, kept it clean. I expect everyone to be passionate about this subject because at the end of the day, we all care about this place. We care about this tribe. And this place is bigger than us. I just had staff pull some numbers for some government meetings. We have 1,636 employees here that rely on this place for their health insurance, for their paychecks, to put roof over their heads and food on their family's table. So we owe it to them to do a good job, but we also owe the people who voted in that constitutional survey to start tackling this as well. So I wish everyone a good night, and I'll see everyone here tomorrow at 10, and then we'll have the special meeting afterwards.
Thanks, everyone, for the workshop.
Have a good day, guys.
Good job, everyone. Bye,
The recording has stopped.
Purchasing.